Welcome to the first hearing of the Committee's inquiry into the Workers' Compensation Legislation Amendment Bill 2025. I acknowledge the Gadigal people of the Eora Nation, the traditional custodians of the lands on which we're meeting today, and I pay my respects to elders past and present, and celebrate the diversity of Aboriginal peoples and their ongoing cultures and connection to the lands and waters of New South Wales. I also acknowledge and pay my respects to any Aboriginal and Torres Strait Islander people joining us today or watching online. My name is Abigail Boyd and I am chair of this committee. I ask everyone in the room to please turn their mobile phones to silent. Parliamentary privilege applies to witnesses in relation to the evidence they give today. However, it does not apply to what witnesses say outside of the hearing. I urge witnesses to be careful about making comments to the media or to others after completing their evidence. In addition, the Legislative Council has adopted rules to provide procedural fairness for inquiry participants, and I encourage committee members and witnesses to be mindful of these procedures. Given the circumstances in which this inquiry was established, the committee has determined that its first priority and the focus of today's hearing will be to investigate the financial and other assumptions underpinning the proposed reforms set out in the bill. After today's hearing, the committee will decide on the next steps for this inquiry, including in relation to submissions and whether to hold further hearings. The committee's website will be updated with this information. Given the possibly short time frame for this inquiry, witnesses will be required to return answers to questions on notice within 24 hours from when the transcript is received, rather than the usual 21 days. The committee will decide later today whether it will allow supplementary questions from members. So I now turn to our first set of witnesses. Welcome and thank you so much for giving time to give evidence, and also for many of you for making your time available to the committee last week. Could I get each witness, starting from my left, to please state their name and position title and then swear either the oath or the affirmation?
Dale Liu, General Manager of Actuarial Services, iCare. Affirmation. So I solemnly, sincerely and truly declare and affirm that the evidence now to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you.
Good morning, Tony Wesling, Group Executive, Workers' Compensation at iCare. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you.
Hello. Michael Coots-Trotter, Secretary of the New South Wales Treasury. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you.
Good morning, Andre Wheeler, Executive Director, State Insurance Schemes, New South Wales Treasury. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Mandy Young, the Chief Executive of the State Insurance Regulatory Authority. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you.
Good morning, Christian Fanker, Director of Scheme Design, Policy and Performance at CIRA. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you very much. And would you like to commence by making a short opening statement?
No.
Excellent. No one? Fabulous. In which case we will start with questions from the opposition. The Honourable Damien Tudor.
Thank you. Mr. Liu, have you been asked to do any modelling in relation to proposed amendments from the opposition and Mr. Latham in the last 48 hours?
I've seen the amendments. We've started work in looking at it, yes.
So where is that up to, and when can we expect to see it?
Next couple of days, I would say.
Next couple of days?
We're working through it. It's complex modelling, but we are working through it with...
So would you accept from me that in relation to each of the proposals which have been put, each of those proposals would represent savings to the scheme?
Sorry, I'm just trying to remember all the proposals. There are a number of proposals put together.
A number of amendments.
Some of which are savings, some of which are costs compared to the bill as it currently stands.
Well, which ones have you identified as being costs?
The ones relating to threshold and how threshold is applied.
Well, certainly I accept that, but are any of the other proposals which have been put, do they represent anything but savings?
Can I take that one on notice? I think I can't recall all of them perfectly. Nothing's coming to mind, but can I please take that one on notice?
Good.
If you want a definitive answer.
Well, let me put a specific proposal to you. If in fact there was a requirement that even in respect of a cohort of workers within the 21 to 31% range who in fact had a work capacity of 20 hours per week, that they in fact would not be entitled to continue claims, notwithstanding the reinstatement of Section 39A. Would you accept that that provision would in fact constitute savings to the scheme?
My memory is probably not identical or perfect, but if that was in conjunction with the threshold, no, that will increase the cost to the scheme compared to the bill as it stands.
Well,
if it's a standalone,
I put it to you in this way, that in fact there would be a cohort who would go off benefits because they had a capacity to work. That would represent a saving to the scheme, would it not?
Under those words, yes. I think we're looking through the data. My vague understanding of the scheme is that is not a significant change in terms of the 15 compared to the 20 hours of work capacity.
When you say not a significant change, what do you say, or what do you mean by not a significant change?
I mean, we're doing the work on it, so please just take this.
Well, you formed a view that it's not significant.
Yeah.
So when you say it's not significant, what do you mean by not significant?
But what I mean by is a lot of workers present with no work capacity. So whether it's 15 or 20, it doesn't make that big of a difference when it comes to the cohort that's impacted.
Mr. Coates-Trotter, or potentially other members of the panel, there is a New South Wales Government Return to Work Strategy 2025-28.
Yes.
I take it you're very familiar with that document.
I'm reasonably familiar with that document. I co-wrote a forward to it with Mr. Draper.
Indeed.
Yes.
So let me ask you in relation to that document, the implementation of the strategies surrounding the Return to Work strategy.
Yes.
How is that going?
Look, it's relatively early days. The strategy was released in April. The work at this point, led by Premiers, supported by Treasury, is focused on two things. One, working through how we better educate senior leaders and hold them to account for return to work performance within their agencies, including at the Secretary's Board level. And secondly, looking at cohorts of workers in the two big agencies, education and health, and trying to work through some of the detail about how we might get more of those people who are assessed as having a capacity to work back to work as quickly as possible.
And in fact, that's a key underpinning of the whole of the strategy, is getting people back to work. So when you say holding secretaries to account,
yeah,
what does that mean?
Well, it's got to be worked through with my colleague Simon Draper, who is in effect, represents the Premier as our employer, but it's really going to be identifying what is expected performance within agencies for return to work.
Yep.
And if we don't deliver that performance, we're going to be held accountable for
Well,
that.
if in fact you were successful in implementing this strategy,
Yep.
and there was a significant upturn in return to work rates as a result of the strategy, then in those circumstances, a lot of the savings which is envisaged by this legislation may in fact be made by the implementation of the strategy, would they not?
No, look, there are 3,500 people at the time of the strategy across the public sector of 410,000 who were assessed as having a capacity to work but weren't working. So for those individuals, their families, it's really important we give them the opportunity to heal through work, get back to work. But the financial cost of that is around $60 million a year, so it's not insignificant, but compared to the multi-billion-dollar challenges in the TMF and the nominal insurer, it's helpful, but it's not a game changer.
Well,
It's just
it's counterintuitive, isn't it? That if in respect we are getting people back to work more quickly, then there will be savings to the scheme.
That's true, but these are people who are assessed as having a capacity to work. There'd be others within the scheme who don't currently have an assessment that they are capable of work. So it's the right thing to do, it's an important thing to do, but as I say, Mr. Tudor, I hope it's savings of around $60 million.
So you would say
Or avoided costs, I should
well, a lot
reframe
of the
that as
commentary in
avoided costs.
relation to the savings which are to be made are because people are not returning to work in circumstances where they are getting embedded in the system and are resisting returning to work. Is that not the case?
Well, I wouldn't describe it as resisting returning to work. I think the government's view is that the scheme does not adequately prevent, doesn't create the right sort of incentives to get people back to work quickly.
Well, in relation to holding people to account in relation to the strategies developed by the scheme.
Yep.
How in fact will that work? Besides the secretaries being held to account, will each department in fact be required to establish their own criteria for implementing the strategy?
So the aim is working with various stakeholders to identify from evidence the best models of return to work in a public sector context and ensuring that each agency has assessed its own practices and processes and leadership against what we know to be the gold standard, and that agencies move as rapidly as possible towards doing it as well as possible. So that's going to involve a whole range of performance measures within agencies and accountabilities that attach to those.
And what are the consequences if they don't meet those requirements?
To be determined.
You haven't thought through what will be the potentially down the line managers if
Well,
in fact.
Well, I mean,
Education and health.
Yep.
You know.
Well, health's actually recently improved its return to work rates.
Right. Well, education.
Okay, I'm not familiar with that.
So, what is the
data.
consequence for not complying with the strategy?
Well, that's, as I say, Mr. Tudor, to be determined. Look, I mean, the performance of senior leaders is assessed against a range of objectives in the role. We've got a responsibility for the safety of our workforce. We've got a responsibility for the outputs of the agency. We need people to produce those outputs. So we are going to be assessed on how well we make use of the talents and capabilities of our workforce. And if we've got 3,500 people who are capable of work across the sector but not at work, that is a huge missed opportunity and a real cost to those individuals. We need to do something about it.
Ms. Young, there are potentially schemes available for assisting people to return to work. In fact, opportunities for $5,000 for employees to look at other opportunities, a $10,400 grant to employers who take on new employees. What's the take-up rate in relation to those schemes which are available through CIRA for people returning to work?
So I think it's fair to say the take-up rate is lower than what we would like that to be. I'd have to get you the specific number. I don't have that to hand. However, I would say that we're actually doing an evaluation of our vocational programs at the moment. That's due to back to us in August, and we're also working with Treasury and the Premier's Department to see if we can pilot a couple of versions of those programs once we get that evaluation into the TMF. So we're doing a range of work on the vocational programs at the moment.
And was modelling done in relation to those programs to establish the effectiveness of those programs?
So that's precisely what we're doing within the evaluation at the moment, where we're looking at how those programs are functioning, the take-up rates, how effective they are. I would say that the indications, I don't want to preempt the outcome of that evaluation, the indications are that people do return to work at much faster rates if they go through those programs.
Mr. Liu, are you doing that modelling?
No.
Who's doing the modelling?
No, it's an independent piece of work. I think it's Urbis, but I will just come back to you on to confirm.
Mr. Liu, Mr. Coates-Trotter has just told us that the savings in relation to the return to work strategy would potentially save $60 million. Did you do that modelling?
It did come from my team, yes.
It did come from your team. And you accept that the only savings to be made in relation to this return to work strategy would be $60 million?
It's I should clarify, it is a central estimate based on all of the data and evidence we had at the time. How it will play out, really we need to see how the program performs. That was our best estimate at the time.
Wouldn't you give this program a chance to operate before you actually embarked upon removing benefits?
That's a matter for government.
Mr. Coates-Trotter?
That is a matter for government, Mr. Tudor.
Indeed. One of the things which are...
Just to give you a point of context or contrast, the upcoming budget will reveal that the workers' compensation liability in the Treasury Managed Fund has deteriorated or grown. The liability's grown by $2.6 billion over 5 years in the most recent actuarial revaluation between the half-yearly review and our upcoming budget. So you've got billions of dollars on one hand, a moral imperative but relatively limited savings on the other, that there is a continuing problem with the sustainability of both the public and private scheme.
Can I just ask you about that?
Yep.
Mr. Garling made reference in the evidence which he had previously given to this committee in respect of the exposure draft of this bill.
Yep.
That the modelling in relation to the potential exposure of the TMF is predicated upon all claims not being satisfied within, all liabilities of the scheme not being satisfied within an earlier period of time and potentially going to the worst case scenarios for the scheme. Would you accept that?
Well, I think that's Mr. Liu's expertise. It's his modelling.
Is that the manner in which you...
That is not the manner in which the modelling
Well,
is
you tell
done.
me how that modelling is done for the $2.6 billion over a 5-year period.
So that $2.6 billion over the 5 period is based on the December actuarial valuation of the TMF workers' comp portfolio. The December 24 valuation, apologies, looked at the data up to September end in terms of all of the claims trends, how much the injured worker gets in terms of weekly benefits, medical benefits, how many of them go down the path of work injury damages, how long people stay on scheme, and then use the actual experience to project that forwards. Where we see trends, there are actual judgment required to make a call around whether the trend would continue or whether the trend is noise.
So it's not an exact science then in terms of the $2.6 billion, is it? It's predicated on potentially trends which may be in fact impacted by the return to work strategy which you're currently adopting.
Look, it is the best estimate based on the information we had at the time.
Mr. Wesling, one of the observations made in the return to work strategy was that the people do return to work more quickly in circumstances where they have had access to psychological help within 12 weeks of making a claim. How many people get to actually see a psychologist within that period of time?
Mr. Tudor, I can tell you the average time it takes for an injured worker to get psychological help is about 70 days. The median is about 40 days from what we looked at. That's a result of obviously access to those types of services. We have made available emergency access to counselling services 24/7 which are available immediately to injured workers, but for some of those specialist
But part of the
consults.
strategy has to, as I understand it, involves, and certainly in relation to psychological injuries, making a psychologist or a psychiatrist available at an earlier point in the on the making of a claim.
Sorry, Mr. Are you talking in relation to the whole of government return to work strategy? Well, we are doing a broader set of activities to try and make psychological services available earlier for injured workers.
And tell me what the strategy is in relation to doing that.
Making services available earlier. Well, we have, are you aware, we have the specialist claims model we've launched with a number of our CSPs. Some of that is about trying to fast track access to services. We make available as many appointments as we can as soon as possible to injured workers. As I said, we've launched and we're expanding the access to on-demand 24/7 counselling and sort of emergency psychological services. Those are part of the strategies that we're pursuing.
Okay, and in terms of the early intervention of a psychologist and a psychiatrist,
Yes.
what's the KPI that you are setting for claims managers to have claimants in front of a psychologist or a psychiatrist?
Well, we don't have a specific KPI on that, Mr. Trudeau.
Why?
Well,
It's a key factor in getting people back to work.
I take that point.
And you have no KPIs for your claims managers to actually have workers in front of psychological help.
Well, we've commenced tracking how long it takes on average, but keep in mind the injured worker accesses these services via referral from their nominating treating doctor, often using a specialist that's best for them. So there's a range of factors that goes into that we don't control of how injured workers access those services. We can make additional services available over and above that. And we're looking in the specialist claims model from the CSPs around things like having block bookings of psychological services to be available, things like that, but those are very early stage.
Mr. Wessling, are you aware of any fraud which takes place in relation to this scheme? In respect of psychological injuries?
Well, we obviously have, throughout the year, we'll receive a number of allegations of fraud from against workers, against employers. We have a process. Our case managers obviously consider any allegations of fraud and assess the information they have available. We scan or we do additional investigations where we think there is fraud, and in those circumstances we will refer those to CIRA.
Are you aware of any provision in this amending legislation which addresses issues relating to fraud?
I'd probably have to pass it off to Andre.
There are a number of measures that are included that are targeted at improving the integrity of the scheme.
No.
I would not say that they are primarily directed towards fraud per se in a criminal conduct sense, but there are certainly measures, particularly in relation to CIRA's medical assessment panels and the powers that it will have with respect to performance and quality and monitoring, that are intended to lift quality and integrity and the efficiency of services provided.
Thank you. If I could start by asking you, Ms. Wheeler, when we spoke last week, we were trying to get a grip on what that 2.6 billion figure for the TMF was about. I've heard now that it's 2.6 billion over 5 years as an estimate. And is that an estimate of what these particular reforms would save?
No, that is the scheme's performance absent any reform.
Reform?
So that this is just a deterioration in the workers' compensation scheme. The TMF component of the scheme is adding $2.6 billion in employee expenses over 5 years.
Over 5 years, okay.
Yeah. So
And-
2024, 25 and the following 4 years.
And when we spoke about this last week, there was a suggestion that maybe that also included exempt workers in there. Is that correct? Can you tell me how much we're talking
I
about
could
for
happy to
non-exempt?
take that on notice for you, Ms. Boyd. It would be...
With respect, sorry, it was taken on notice last week. So
Oh,
I'm just, if
well,
my
Ms.
apologies.
Wheeler has the details.
I can take that one.
You can take that one. Great.
We've looked into that, so that for that 2.6, roughly about a third is due to exempt workers and
Okay.
2/3 is due to non-exempt workers.
Okay, so we're looking at about 500 and, what is that, 500 and, someone help me out, 2.6 billion divided by 520 million
If you just
with
give me
the
a moment.
exempt, and then per year, and then without the exempt, you're talking about 2/3 of that. So we're looking at about a decline of around 300 and something million per year. Sounds quite different when you put it like that to this sort of grand 2.6 billion. If we're just looking at 300 and something million per year, which no one's saying it's not a problem, but clearly
No, that's true,
that
but
sounds like a
unfortunately
different
there's
number.
been a relentless increase in this liability with every 6 monthly actuarial valuation. Certainly since I've been in this job, my job's been to go and deliver another round of bad news to the Treasurer about the deterioration in
Okay,
TMF.
I'm sure. No one's saying that the costs aren't increasing.
Yeah.
But when we look at iCare's performance as a whole, are you familiar, Mr. Coutts-Trotter, with the Auditor General's work from 2024, April 2024 on claims management?
Look, only at the
performance?
highest level, Ms. Boyd.
Yeah.
Yeah.
So two of the things that the Auditor General pointed out at that time that were adding significant costs to the system for unidentified benefit at that point was the cost of the claim service providers. And if I look at the difference in the last 5 years for how much remuneration those CSPs are being paid, we're looking at an increase of around $408 million in 5 years per year.
Sure.
So it's costing iCare over $400 million each year extra for claim service providers. Is that correct?
I'd need to pass to my colleagues in iCare to confirm that, but that sounds about right. And it was something that my colleague Ms. Wheeler and the Treasury team looked at with our operational expenditure review. Did some high-level benchmarking of the costs of the New South Wales scheme compared to comparable public, largely public, but in some cases privately underwritten schemes.
So when we look at, and again, a lot of percentages have been used in this discussion so far, and we've heard the increase of 5% to 7% of psychological claims within the nominal insurers being referred to as an explosion or some sort of catastrophe in the news. But if we look at that increase in claim service providers, from 2019 it was around 48% of iCare's total costs, and now it's at 71.2% of iCare's total costs. And again, representing an extra $400 million per year.
Yeah.
Was that not an area that you thought was worthy of looking at for savings before we sort of punch down on injured workers?
So we've looked at everything. So the investment returns of the funds that back these two schemes. So have the investment objectives for both TMF through one fund and the nominal insurer through decisions of the iCare board. The investment objectives have been lifted, meaning that there is a preparedness to take a degree more short-term volatility in order to earn a more secure and better longer-term result. We've looked at the operating expenses with inside iCare and and the organisation is delivering a set of savings. They've taken executive roles out, they've reorganised the organisation and made other savings. Obviously the government's made decisions in relation to the premium levels in the nominal insurer. So we've really looked and done work on every
Yeah.
aspect of this, including, of course, return to work in the public sector.
So just on return to work, because I understand that despite the Auditor General saying that there was no identified benefit or even
Yeah.
objective of introducing this claim services provider model that has, as we've seen now, it's seen an increase in over 400 million a year. It was then introduced into the TMF as well.
It is in the process
In
of
the
being
process.
It's
Yes.
process of being introduced. ICARE's forward numbers, Ms. Boyd, assume a avoided cost from the claims management model of, on average, about $450 million a year.
No, it's 4.5 billion over the 10 years.
4.5
avoided cost.
4.5 billion over
Yeah.
10 years, so an average of $450 million a year.
That's
Should
quite an
hand-
assumption based on what we're seeing in terms of the deterioration in the amount of claims providers and what they're getting.
Well, a professional framework for case managers, higher quality support earlier in the journey of a claim, trying to keep people connected to work, get them back to work
Just
more
on
quickly. If that works, it will substantially avoid
Yeah.
costs in the
Well,
scheme.
if that works. So just on that, because one of the other things the Auditor General points out is obviously return to work, as we've heard from the opposition, is one of the critical, obviously it is critical to the sustainability of the scheme. But as these claim service providers have been brought on and are increasing the costs for iCare, we're also seeing return to work rates decrease. And the Auditor General comments that as part of this, iCare actually took away the incentives for return to work goals for these CSPs. Is that correct? Do we not have... Were there years in the past 5 years where there was no return to work incentive for these CSPs?
Not that I'm aware of, Ms. Boyd. We certainly have, in the current contracts in the nominal insurer, significant, I'm not sure what proportion, but probably half of the performance fees will be based on return to work outcomes. That was what the new model was predicated on when it was launched back in 2023.
That's not what the Auditor General says. Maybe you could take that on notice and come back to
Okay.
it when I find the page. Can I also ask, the other thing the Auditor General said was there's been hardly any work on fraud management and identified the huge amount of savings that could be made by CIRA in particular, taking a bit more of a focus on weeding out fraud in the system. Has that, I understand that work has only just begun, but is there any kind of estimate for how much that's going to save the scheme?
So, from the work that we've been doing on fraud, and we've been taking a really hard and close look at this over the last year particularly, we haven't got estimates in terms of dollar values. Fraud, we work through a range of processes, so some are referrals to us, some are tip-offs, and some other ways that we work through understanding what's coming through to us. Over the last year alone, so this year to date, we've referred more matters to our legal team for potential prosecution than over the 4 years previously. So we're really picking up in terms of how we do that work and what that looks like. We don't have modelling on the money in terms of what that might save, but certainly we are focusing on how we deal with fraud and getting more enforcement into place.
So those two identified costs in the system would save far more than these reforms. At what point did Treasury, I guess, decide not to go down the route of tidying up iCare's largesse before it decided to go ahead with these reforms?
We would take the view that our operational review identified areas where iCare can and should save money, and that the board and the management of the organisations responded. As I say, at a high level, our benchmarking indicated that once you delivered those savings, iCare looked to be, at a high level, a relatively efficiently run organisation once the savings are delivered.
Mr. Latham.
Thank you, Chair, and thank you to the witnesses appearing today. To Mr. Liu, what role did you play in modelling the cost of the amendments the government accepted to this bill in the Legislative Assembly?
We did have a look at the costing, yes.
And what did they show for amendment number 5, moved by Mr Greenwich? Existing claims for whole person impairment injuries, page 38, schedule 1.10, basically taking out retrospectivity.
That's exactly what we provided in terms of advice. It takes out the retrospective elements, and the costings will need to reflect that, is the advice.
Yeah, and what did that cost?
Can I take that on notice? I don't have that. The numbers
Why
have
don't you
moved.
have it available, given it's a major amendment to this bill against the original presentation of the bill agreed to by the government in the Legislative Assembly?
There's a number of moving parts to the costing, and I just want to make sure I picked up the absolute correct one.
Right, moving parts, is that actuarial language for you don't know?
No, it's actual language to say I don't want to give you the wrong number.
Well, I'm just asking why you haven't got the number, and who did you advise? You earlier on sort of implied your advice was that this clause, number 5, moved by the independent member, was necessary. What were you advising, Mr Greenwich, or no? Who did you advise?
I was requested by government to look at the costings.
Okay,
of
and
the
what was that
amendments.
costing? Was it positive or negative impact on the scheme?
The specific one you speak of, Mr Latham, takes out the retrospective elements, so that reduces the avoided cost to the scheme.
It reduces the cost to the scheme.
No, the avoided cost. So
The avoided cost.
So it costs more.
It adds to the overall impact on government funding, the TMF and iCare funding as a nominal insurer.
In short, yes.
Yeah, and by how much?
I said, can I please take that one
No,
on
well, you
notice to begin?
provided this advice to government for very important amendments to their legislation in the LA, and you're saying here you've got a memory
Point of
fail
order.
and can't recall.
I'll hear the point
figure.
of order.
Is that
Order.
what you're saying?
Order. I'll hear the point of order.
Sorry, Chair. Just procedural fairness resolution and courtesy to the witness. The witness is entitled to take a question or notice as is requested.
Okay. If we could just maybe calm things down slightly and allow the witness to see if there is an answer.
Yeah,
able
well,
to provide
maybe
it.
I'm animated, Mr Liu, because in discussions with the Treasurer as to why he needed to go to 31% and knock off after 2.5 years, I put to him the Victorian alternative of tighter definitions on the way in. And his sole justification for this legislation was that there are so many claims and so much expenses in the pipeline, we need to retrospectively deal with those to maintain the financial sustainability of this scheme. And yet, in the Legislative Assembly, seemingly without you being able to tell this committee what was the actual cost, he's agreed to 3 different amendments by an independent to remove the retrospectivity and add to the problem that the Parliament and the government is facing. So that was on amendment number 5. Have you got any recall of amendment number 6? Lump sum compensation for psychological injuries, page 40, schedule 1.10. What happened there in terms of your advice to government as to the cost of that amendment in the LA?
Is there more detail you could read out, Mr Latham? Sorry, I don't.
Well, they took out the retrospectivity for lump sum compensation for psychological injuries. Do you recall that?
Those 2 items travel together, Mr Latham, in our modelling in terms of how it gets applied. So both items of retrospectivity was done together
Right.
as a single item.
Right, and what date did you receive instructions to provide a costing on that?
I can't recall. It'd be when it was presented to me by government. I can't
Was
recall the
that
date.
24 hours, 48 hours, a week prior to the bill being considered in the Legislative Assembly?
All I can recall is we were still working on the costings while the bill was being considered in the Legislative Assembly, so work was ongoing.
So you take that on notice as to when you were first asked to provide this material?
Yeah, happy
It
to.
sounds like you're saying you were asked as the bill was being debated in the Legislative Assembly. Is that your recollection?
Not asked, but we were still doing work on the costing of the amendments as the
Well, someone
Assembly.
asked you to do that, didn't they? You just didn't volunteer and go up to
Well, it was asked.
Mr Mookie or Ms Costas or Mr Greenwich and say, here's some costings for an amendment you haven't yet developed?
He's
No,
good,
but
he's not that
specific-
good.
Sorry?
He's good, but he's not that good.
Well, he's not so great in having a recollection of what's going on here, so that's what I'm seeking.
So the specific wordings matter, and how it works matter. So part of the kind of ongoing work is sometimes we receive, well, what would this look like? But then when further clarified, work needs to continue to make sure that we're addressing the amendments as is presented.
Right, but did you provide dollar costings or just general concept costings?
We provided a range, is my memory.
A range is your
we
memory.
didn't-
And the third one was existing claims in relation to psychological injuries, amendment number 7. You've taken the other two on notice. Have you got any recall of the costing for removing that retrospectivity in the original bill?
So can you, sorry, I really don't remember the items. Can you tell me?
You don't?
what-
Okay, well maybe you can take that on notice as well. But do you find it curious that the Treasurer would say to myself as a crossbench member in the upper house, the whole purpose of the bill is retrospectivity in the pipeline, and then he's accepted 3 amendments in the Legislative Assembly from their crossbench to gut the purpose of the bill?
That's a matter for the Treasurer.
That's a
Mr.
matter for the
Latham.
Treasurer. But you did provide advice as to the consequences of this gutting.
We looked at the costings.
Right, so what now is the bill saving in terms of the pipeline impact? And is it true that we now have to wait 2.5 years for any savings in the schemes, because that's where the cut-off applies, and nobody in the pipeline right now for 2.5 years is impacted by the provisions?
It's not true because of the way the financials and actuarial valuations work. We essentially value and put on the accounts the full cost of the claim as the claim is incurred. So we have to provide an estimate on that. So as the legislative and regulatory environment changes, our costings need to reflect that. So you will see that play through. Like if it changes, you'll see that play through in the financials as we do the actuarial valuation.
Right, but you're confirming to this committee that because of these changes that you've looked at and costed in the Legislative Assembly, these amendments, that nobody who goes into the scheme today is going to be impacted in any way for 2.5 years?
I don't believe that's how the amendment works, Mr. Latham. I'm not an expert, but I don't think the amendments work in such a way that everyone won't be, yeah.
Well, Ms Wheeler, what's your interpretation of how the amendments work?
The amendments would affect people who already have a claim within the system, but would mean that all new injury notifications would be subject to the new thresholds.
Right, so nobody in the pipeline is being affected, and the Treasurer's stated purpose of this bill, which is to deal with the pipeline costs, which he says are enormous and growing quickly, the Treasurer's purpose was gutted by these amendments. Is that your interpretation of what happened? If you accept that was his purpose, because he put it to me that way.
I would see that there are a number of different multiple aspects of the bill that have different impacts, and some of those are immediate and to take effect quickly.
Yeah, well, I'm interested in the pipeline argument that was put to me as the core purpose of the bill. Were you involved in any consultation as to why these amendments should be supported?
We provided technical advice around the drafting and the preparation and the policy impact of those amendments.
Yeah,
to
and
government.
what was your advice on the impact?
In terms of impact, we provided advice around the impact on existing claims within the system.
Okay. So following, Mr Liu, the passage of these amendments, what is the net financial impact of this bill that's come to the LC?
So I believe that there was some costing provided to the committee. Sorry, just bear with me. There were costings provided to the committee in the documents that were uploaded. Those would be the
Well, that was a
figures.
private briefing. I'm trying to get that on the record. Like Mr Coutts-Trotter has said, $4.5 billion
It's
over
part
2
of the
years and
public
rising
documents.
exponentially. What's the impact of the bill after it's been amended in the LA?
It was part of the published documents. I believe it was about 1.1 billion per annum for the nominal insurer and 500 million for the Treasury managed fund
That's the impact of this bill, that's all.
per annum.
That's it. Righto. What's the point? What is the point?
That is a very significant impact, Mr. Latham.
Not compared to the numbers you've been quoting to us.
That's $1.1 billion a year improvement in the nominal insurer. It would allow the nominal insurer to
No,
get
he
back
said
to...
500 million for the nominal.
No,
500
500 million
for
for TMF. And the nominal insurer, $1.1 billion a year, which would mean no further premium increases, and the scheme would be 100% funded by financial year 29-30. It would recover the deficit within...
But not
that
on the
period.
exponential rate of claims growth.
Order.
That you've been
Time
talking
for
Well, that is the
government
modelling.
questions.
That is the modelling.
Thank you, Chair. Just on Mr. Latham's line of questioning, just in terms of the retrospectivity aspect of this, is the intention largely with that to protect the current claims and status of claims of people that are currently in the workers' compensation system, not the, I suppose, the long tail of people looking to come in over the next 5, 6, 7 years?
The intent of Mr. Greenwich's amendment, Mr. Nanva?
Yes.
Yes, I think that was how it was expressed.
Yes. Okay. Thank you. Without labouring the point, just on some headline figures of with respect to the scheme, could you provide the committee with the most recent numbers with respect to the nominal insurer and the TMF, with respect to the number of psychological claims and the cost of those claims from 2018? What's been the percentage increase?
There was a submission from my colleagues at iCare, so I might turn to Mr. Liu to give you an update. But since 2018, the number of psychological claims entering the nominal insurer each year has more than doubled. The number of claims within the scheme has increased fourfold. The number of psychological claims into the TMF has doubled, and the number of psychological claims within the scheme has tripled in that period.
The cost as well?
So the nominal insurer has gone from a surplus of $4.4 billion in 2015 to a deficit of $4.9 billion as at December 2024, so a $9.9 billion deterioration over that period. With the 8% premium increase, the final of 3 8% premium increases that will arrive in 25-26, unfortunately we will have the highest workers' compensation premiums of any Australian state. We are up to 48% higher than other states. So compared to Queensland, their workers' comp premiums for private sector employers will be 48% below ours. So it's quite a significant issue for business, of course, and the cost of the scheme is driven by the fact that we're not getting people back to work as quickly and as successfully as we should.
What are those return to work rates for psychological injuries compared to physical injury?
High 90s for physical injuries at 52 weeks and about 41% for psychological injuries at the same point in time.
With respect to the deficit in both of those schemes, contributions have obviously been made by successive governments now.
Into the Treasury
TMF.
managed fund. The nominal insurer is not part of the state's accounts. It is not a liability that is the state's liability. It's a liability that exists in that scheme and is in effect an employer's liability.
And what have been the premium increases over the last 5 years with
I
respect
should
to the...
turn to Mr. Wessling or Mr. Liu for that.
So, Mr. Nanva, over the last 2 years and moving into the next year, it's 3 years of 3% increases. 8% increases over the 3 years.
Yeah.
So those are the increases we've put in over the last 3 years.
On the most recent valuation of the nominal insurer, what premium increases would you be looking at to get it to 100%, 100% ratio?
It would require the 8% that's arriving in 25-26, followed by 2 12% increases beyond that, So compounding a 36% increase, and that would take our premium rates to 2.5% of wages, compared to other states that are between 1.3 and 1.8% of wages. So we would be a really significant outlier in the cost of workers' compensation to 340,000 businesses in New South Wales.
So I suppose the question I'm asking is, without significant structural reform, contributions of that magnitude by the government into the TMF and premium increases with respect to nominal insurers simply unsustainable, aren't they?
No.
I'm interested in what the key drivers with respect to the deficit in the scheme are. So clearly there are more people entering the scheme and there are more people staying in the scheme longer. So you've effectively got this double whammy. Now, obviously psychological injury, recognition of it is probably more widespread than it has been 5 years ago.
Yeah.
But given the doubling of those numbers, in terms of the people entering the scheme and those significant numbers of people remaining in the scheme, is that to suggest that workplaces are twice as safe as they once were and injuries are suddenly far more insurmountable than they once were for people to get back to work? What are the key drivers that are effectively meaning more people are coming in and more people are staying longer?
So what the data show over that period, 2018 to the present, is the proportion of people assessed at higher levels of whole person impairment, controlled for psychological claim numbers, has increased fivefold in that period. So you've got more people coming into the scheme with a psychological injury, and then they are staying in the scheme longer and they are being assessed at much higher levels of impairment as a result. And that is the primary driver of cost in the recent period.
So issues like, I suppose, claims for sexual harassment, racial discrimination, workplace pressure, they're not significantly...
Workplace pressure, yes. There are only relatively small numbers of claims associated with sexual and racial harassment.
Small numbers?
Small numbers, but the large numbers are interpersonal conflict, workplace pressure, bullying and harassment. General harassment rather than harassment on racial or sexual grounds.
Right. I suppose given the sheer volume of people that are now entering the scheme and remaining in the scheme, just with respect to Ms Boyd's line of questioning around remuneration of claims management providers, I suppose those numbers in isolation, there's a significant increase, but would some of the explanation be the sheer volume of cases that need to be managed, the volume of complex cases, require more case managers, or...?
Yeah, that's right. So over the time since 2018, the volume of claims lodged in the scheme but also being actively managed in the scheme has increased quite significantly. And one of the areas we structure the remuneration model around is to make sure we maintain a reasonable caseload for the frontline claims managers. And in fact, one of the changes we made in 2023 was to actively lower that further. That means we've got more frontline claims managers having a smaller portfolio to get better outcomes for injured workers. And that's happened at the same time as the total number of claims lodged, the total number of open claims, they're more complex, and particularly those site claims in both the nominal insurer and the TMF have increased quite materially over that period.
Right. I'm interested in, I suppose, the structural elements of the proposed reforms. I understand the Victorian government not too long ago undertook reforms of their workers' compensation scheme, and the advice to their government, and I'm taking this from their parliamentary inquiry, is that their consultants found that prevention and claims management initiatives were not alone sufficient to address the financial challenges that their scheme was facing, and they needed to prosecute legislative reforms as well as many of those non-legislative reforms, such as improving return to work rates, improving claims management processes, improving prevention of injuries in the workplace. Is that the advice that you have provided and the assessment that you've got with respect to the New South Wales scheme?
Yes, yes it is. So the investment objective has been pushed to the furthest appropriate point, risk-adjusted returns. Premiums are, as we've discussed, already the highest among the states. The claims management model is assumed to deliver benefits of an average of $450 million a year in avoided costs. We've identified and iCare's delivering savings in their own operations. We've got return to work strategy for the whole of government. There are no levers left to pull other than elements of scheme design.
So we've looked at all the non-legislative...
We've looked at all the non-legislative
levers that we can.
You've got companion legislative reform in the industrial relations system and around safe work. And then, of course, you've got the $344 million package associated with the reforms to fund better early intervention and support and more inspectors for safe work.
Coming back to the headline figures that you referred to with my earlier line of questioning, I'm just interested again, this issue around the sheer volume of people coming into the system and then staying in the system. Does the, I suppose, design of the incentives support and facilitate people returning to work, support and facilitate people not entering the scheme if they don't need to? I suppose I'm concerned that changes to benefits should only be considered if they do create disincentives to people recovering or going back to work. Is it your view and the advice to government that there are some of those disincentives in the current scheme?
Yes, it has been the collective advice of various agencies to government that there are those kind of adverse incentives in the scheme that prevent people from getting back to work or staying at work. And one of the key elements of the package before the Parliament is to try and the so-called alternative model for providing a faster decision and therefore supports for people who may have experienced workplace bullying, harassment, sexual or racial harassment. So taking a longer time frame and compressing it to decision making within 8 weeks is an attempt to provide quicker decision making, which all of the evidence suggests is part and parcel of schemes that perform well. And the package in part is attempting to deliver that faster decision making and earlier supports.
Is the provision of more access to commutations also part of that mechanism to...
Yes, it is. Yeah.
I might pass on to my colleague.
Can I, we spoke earlier and we heard other questions in relation to the pipeline. Now, I'll leave you guys to work out who the appropriate person is to respond to this question, but in relation to the retrospectivity changes, are they primarily designed to protect the claims or status of people currently within the workers' compensation system, or are they designed to address possible future claimants?
Their impact is on people who are currently within the system. So prior to the amendment, I'll invite colleagues to correct me if I get this wrong, if you were in the system but had not yet sought an assessment for whole person impairment, you would be affected by the new threshold changes, initially 25% whole person impairment, later 31%. Following the change, you won't be affected by those change in thresholds if you are a current participant in the scheme. That's the effect of the amendment moved by Mr. Greenwich in the lower house.
Okay.
Yeah.
I note that the 2024 Auditor General's report found that there was a lack of coordination between the research functions of CIRA and iCare. Can you tell me how that's been addressed, please?
I'll hand to Ms Young or
Sure.
Mr Wesley.
So, following that, and also the Law and Justice recommendations from 2023, the 3 executives from iCare, Safe Work and CIRA have been meeting, and we meet monthly at the moment to work through a variety of issues where we need to collaborate a little more. One of those has been around research functions. We had a collective group who worked through what would that look like and could that look like for us to be more collaborative on our research functions. We have come up with a proposal that we are putting forward to the ministers in terms of that. There are a range of pieces of work within that, but we are certainly much more collaborative, and we have a group that actually oversees that and feeds into our executive leadership team, executive committee to work through that. So we have taken really active steps in that. We've put a proposal forward so that we're very aware of what each other are funding and how that will operate, and then we're also looking at how we plan our potential joint research moving forward, which we're doing at the moment as well. There's a research project on the horizon that we're looking at doing collectively.
Will any of that have an effect in relation to fraud in the workers' compensation system?
So I'd have to come back to you in terms of if we're doing any direct research on fraud in relation to the workers' compensation system, but certainly a lot of the work that we do, particularly I think there's a sometimes a little confusion between low value based healthcare and fraud. So low value based healthcare is what we call when people are potentially over-serviced or being provided, more sessions than they need to be for good health outcomes. And I think sometimes people may see that as fraud when in fact it's not technically fraud in terms of the legislation and the way that the Act operates. So we do a range of research actually into low value based healthcare. We've done some more recent work on back pain and putting up a new model of how to deal with that. So the answer to your question is yes, we do it in that context rather than in fraud particularly. So it's fraud related activity, but it's not actually fraud.
Okay. Well, if I can return to the issue then of just fraud, but more broadly, what measures have been put in place to better detect, deter and prosecute potential fraud? And this is to anyone, not only to you, Ms. Young.
So I can answer for CIRA.
Please, thank you.
if that's helpful to you. We've done a range of things over the last while. So we've recently increased the work that we have done across CIRA and within CIRA, and in the past 18 months we've had our investigations team really broaden their scope to include more complex fraud issues. So that includes provider fraud cases involving large businesses and the use of layered corporate structures. So we're getting into much more complex areas. And we're looking at fraud in education programs and early dob-in intervention projects. Since July 2020, we have basically tripled the amount of fraud tip-offs that are coming in, so that's moving forward. The types of fraud that we're identifying are claimants around submitting false certificates of capacity while working and receiving compensation, and also some forged documents. So there's sorts of things that are coming through in that space. For healthcare providers, false billing, overcharging, potentially inflating injury severity. They're the pieces that are coming through. And for employers, we've had a lot of underreporting around workforce wages and securing lower premiums, so that's where our focus has been. So the true extent of what it is, I think, as we touched on before, isn't really known because we don't know how much fraud is in the system. We continue to work through that as we build that capability within CIRA.
And Mr Primrose, if I may just add, because I didn't quite finish my earlier response, parts of the bill do deal with employer fraud with respect to under and non-insurance, in particular increasing penalties in that area. So I'll just highlight that as well.
Yeah. I think one of the key things in terms of that is we've had a real increase of collaboration with insurers, so including iCare, and really working through with them around how we can better work together on fraud and identifying that, and then how we enhance our capability in our investigation process to deal with that.
Actually, if I might add to that as well in terms of that collaboration, since February this year we've undertaken 7 sessions with insurers to sort of help them work towards identifying and being able to spot and report fraud. We also work closely with New South Wales Police, the Tax Office, State Revenue and the NDIS, because often if there's fraud in workers' comp, it may be elsewhere as well.
Okay. Thank you. I think that's...
Just one more question, Chair. Just, I suppose, which single element or driver is causing the greatest deterioration to the scheme? If you could specify one.
So I would imagine it is the trend of ever-rising whole person impairment assessments combined with the rising number of new psychological claims coming into the scheme.
There's a compounding effect of the increase in the number of psychological claims coming into scheme and the psychological claims then making a pass threshold and therefore greater entitlements and benefits for the injured worker. Those two factors compound, and that drives quite a huge increase to both schemes on costs.
Mr. Tudor.
Ms. Young, who is responsible for carrying out work capacity assessments?
So work capacity assessments are essentially done through the certificate of capacity.
Through
the certificate of capacity.
Yeah, who does them?
So primarily that will be a GP.
And how often would they be done?
I would come back to you on the timing, but there are set time frames in which they need to be done.
So a GP in a 10-minute potentially consultation makes an assessment, do they, for the purposes of a person's capacity to return to work?
So I think how they would do that and the time that it would take for that would be much longer. I'm just looking at my colleague over there, Mr. Wesling.
Yeah, but could I answer this, Mr. Chair? So work capacity decisions and work capacity assessments are part of the case management process. So case managers ultimately make the determination on work capacity using inputs from the normal treating doctor or psychologist. Work capacity is obviously a core part of the current scheme. The scheme is built around building capacity for work and getting injured workers back to work. The legislation requires a work capacity decision to be made between the 78th week and the 130th week. So in that last year of the first 2.5 years, it's mandated a work capacity decision occurs, given that that's then the threshold for ongoing or access to certain types of lump sum benefits and ongoing benefits. So it is up to the case manager to complete those work capacity decisions. They can be done at any point in a claim, but historically have been done in that 78 to 130 week period.
So the claims manager would require the injured worker to attend on their GP and produce a certificate from that GP. Is that the...
Well, the input from the information from the GP is one part of input into the work capacity assessment.
Yes.
Who
else provides input?
Well, if there's other treating providers, I could come back on notice and give you all the sorts of inputs.
Would you accept from me that there will be some people who fit into the category of no capacity to return to work?
That's right. There's basically three types of outputs. There's a employed, which means there's capacity to work and the person's working. There's no capacity to work.
And there's somewhere in between.
Or there's capacity to work but not working. So those are the three. So you've either got capacity and are working, you've got capacity and aren't working, or you don't have capacity to work.
In relation to that cohort who have no capacity to return to work, what happens to them?
Well, it can have an impact on the wages, the wage replacements that are paid.
No, but under this new legislation, what would happen to a person with no capacity to return to work?
Sorry, with no capacity. I'd have to pass that under the proposed legislation.
Yes.
Might ask Ms. Wheeler to answer that.
Sorry, what was...
Oh, sorry. It was in relation to the legislation for someone who has no capacity to return to work. What happens to them?
At the end of 130 weeks?
At which...
that under the current legislation, they would cease weekly benefits and continue to receive medical entitlements and care for an additional 52 weeks.
So what happens to them?
in terms of transition off scheme.
No capacity to return to work. What happens to them?
That becomes
So under
Well, but this is a policy decision that the government is making for people who have, on your assessment, have no capacity to return to work. What happens to that cohort of people?
Of course, the big development since the reforms to the scheme in 2012 is the creation of the National Disability Insurance Scheme.
So it's a cost shifting to the...
No, it's not a cost shifting. I mean, the whole design of the National Disability Insurance Scheme is to provide the best possible supports for people with a range of ongoing disabilities, and I think there are around 19,500 people in New South Wales who are currently in the NDIS as a result of psychosocial disability. So that is a pathway for some people that is available now that wasn't available.
But how many
back
of
in the
those
history
people who
of
are
the scheme.
currently in the NDIS have had their injuries caused as a result, or liability except as a result of a workplace injury?
I don't have that data.
But it wouldn't be great because they would be entitled to compensation, would they not? Have no capacity.
No, that's true, but I'm just making the point that there is a now increasingly well-developed pathway of support for people with psychosocial disability, which is what we're talking about if you are severely impaired as a result of a psychological injury at work.
Well, let me ask about that. In respect of the 21 to 31% WPI, how many of those people do you say, Mr. Whistling, have capacity to return to work on the figures available to you?
I wouldn't make a guess at that, Mr. Tudor. I'll take that on notice. But there are workers in that cohort that would have capacity to work.
There would be some, but
Yes.
there'd be a
I don't
significant
have-
number that would have no capacity to return to work, would there not?
I'd have to come back to you on notice. Sorry, I wouldn't want to guess.
Do you
at
know,
that.
Mr. Liu?
I don't have the data.
Have you not been asked to do any modelling in relation to that?
We've not looked into it. I don't have that at hand.
Well, you've come up with a figure of only 27 would in fact be able to continue under this model. 27 in the current scheme would be able to continue their claims. Why haven't you done any modelling in relation to that cohort between 21 and 31% who have no capacity to return to work?
We've looked at, we've been requested in terms of kind of the different combinations of amendments, legislation and proposals. So when we do our costings, it's as kind of per the requests that come through. So when there's requests around changes in thresholds and different rules, we cost those. So that's what we've looked at.
I'm really perplexed by this issue which Mr. Latham has raised in respect of removing the retrospectivity from the scheme. In fact, removes a significant number of claims which are in the pipeline from the effect or the savings which are to be made by the scheme.
Yes.
And it appears that the only cohort which are now going to be the subject of savings under the current scheme is those where no WPI has already been made.
Subject of avoided costs, yes. That's right.
And there's no costing that you have available to you about the diminution of the savings which were previously expected to be made, which are now not able to be made because of that amendment.
So Mr. Liu is going to get that for you. It is a one-off impact.
Well,
It is a one-off impact. It is an impact, though.
well, potentially there are long tails in relation.
And the actuarial revaluation of that has an impact in one financial year. Yeah.
Can I ask, Mr. Wessling, has the number of claims in the system increased from 2019 to 2024 in those 5 years by 260%?
They have increased.
The number of total claims in the system between 2019 to 2024 financial years, what was the percentage increase?
Psychological and physical, or just psychological?
The entire claims, everybody
Oh,
that
okay.
is currently going through the TMF and the normal insurer.
Okay, I don't know.
I'm not sure we've got those numbers with us. We have the lodged claim.
Yeah,
numbers.
on the published documents that were provided to the committee last
Yep.
week,
Yes.
Yep.
it looks like something like, I don't know, 20% increase or something like that. What would you say the increase was in total numbers of claims?
I don't know.
We'll need to look that up. We do have that, but we
Yeah.
just need to look that up.
You'd be
Apologies.
surprised if it was 260% though, if it was 2.6 times as many in 5 years.
For psychological injuries.
Yeah, for all injuries.
For all injuries, no, it wouldn't be
No,
260%.
No, that would be absurd. Sorry, the suggestion was made in a previous question that perhaps the increase of 260% in the cost of claim service providers was somehow connected to this, sort of this similar amount of increase in number of claims, but that's just not correct, is it?
Sorry, I misunderstood your question. No, what I was trying to say is that the drivers of claim service provider costs have included the growth in claims volumes.
Yeah.
And just to clarify that whilst they may not have increased by 2.6 times as you
Nothing
just
like
put forward.
that, no.
But I would just say the psychological claims are we run a lower caseload on psychological claims. They
Yeah.
have, and we heard before from Mr. Cootes-Trotter, they have quadrupled and tripled in the NI and the TMF, respectively.
Okay.
So there are. It's not the only driver of cost
No,
increase.
we'd expect an increase in the cost, but not that.
Well, as I
amount.
said before, we also lowered the caseload for frontline workers in 2023, which will have contributed to some of that as well.
Can I just, sorry, because my time is limited. In the Auditor General's report, she made the statement, reducing performance in return to work rates, even if only temporarily, can have a long-term impact on outcomes for affected workers and for scheme costs. Would you agree with that?
Can you repeat that again, sorry?
Reducing performance in return to work rates, even if temporarily, can have a long-term impact on outcomes for affected workers and for scheme costs.
Yes.
Yes. On the previous page, they make the point that the return to work rate targets for CSPs were lowered by iCare in 2023 compared to 2022. Why would you lower the target work rates for CSPs in a year, given how important it is to incentivise return to work?
Ms. Broad, I'd have to take the specific question related to 2023 on notice, but the targets we set for CSPs today increase year on year for return to
but
work.
they didn't in that year, and the impact of that on the scheme and the scheme costs, according to the Auditor General, would be significant. Would you agree with that?
I would have to go back and understand the reasons if there was a reduction in target.
When we're looking at the idea of this bill, Mr. Cootes-Trotter, as being some sort of focus or part of a focus on prevention,
Yep.
what message do you think it sends to employers if you're effectively saying, actually, this scheme where you put in on a, based on risk weightings and everything else, you put in a certain premium in order to compensate workers when they get injured at work.
Yeah.
But then for a particular cohort of workers, those that have a psychological injury, we're instead going to shift them off of the system and put them into, for example, the NDIS or Medicare or something else. What message do you think that sends to employers about their responsibility to keep workers safe from a psychological injury?
You've characterised the message that the reforms in total send, and I wouldn't agree with that. I think the reforms taken as a whole are all about trying to make faster, better decisions, provide earlier support, and provide incentives for people to return to work, and to impose an appropriate obligation on employers to work and cooperate with that scheme design. And I mean, I would make the point, the Royal Australian College of General Practitioners do support the thrust of the reforms for that reason. They see them as a package in total.
Sorry, just clarifying that, because that's quite important. I believe you verbaled them there. They support the idea of prevention. They don't support this particular package.
Well, look, I shouldn't speak on their behalf, but I've read the material that they publish quite closely, and I think it's fairly described as broad support for the thrust of the reforms.
For prevention, which is not actually what the reforms are. Apologies, Mr. Latham.
Yeah, thank you, Chair. Lou, can I ask what assumptions you've got in your modelling for the number of new claims?
We had a look at claims that currently presented as bullying, harassment, and stress and burnout. That's sadly how they're categorised. And then looked at kind of the proportional reductions that will occur with this bill. It's broadly a third of reduction in terms of psychological claims that the schemes will receive.
And why have you made that assumption given that there's no impact in the pipeline?
I'm not sure that's related to pipeline. We're talking about future injuries and future claims reported into the scheme.
You're saying a third reduction in new claims
Yep.
because of this bill. Is that coming from the definitions that now apply in the bill?
Correct.
Right. Even though these definitions at one level are a very low bar. I mean, bullying is your main issue, and someone just needs to behave unreasonably in the eyes of the person who's being bullied. So you're still going to get a lot of claims there, aren't you?
That's a matter.
It is an objective test. It aims to be an objective test, so it's not just whether the person in receipt of the behaviour thinks it's bullying. There has to be an assessment of whether that's a reasonable view to have formed. So there is an attempt to introduce objectivity, which has been a big problem in the scheme.
But building it into the assumptions is completely subjective, isn't it? This is a new definition. You've got really no idea what impact it has in real-world bullying claims. So the third reduction in new claims, you're saying that just comes from the definitions in the bill? Or is there a behavioural impact that new claimants would think, I'm getting knocked off after 2.5 years, I shouldn't claim right now?
We looked at the
Should
data.
go straight to the NDIS.
We looked at the data in terms of the different categories that they are lodged, and so based on the data, we then did our projections work based on that. So for that piece, there was no behavioural impact.
No behavioural impact. So you're relying on what
The
then
actual
underpins your
experience.
assumptions about the number of people lodging a bullying claim. How did you arrive at that assumption?
Based on the data that we have. So based on the data where claims are presented as bullying or harassment, we looked at the trends, we looked at the actual underlying data and arrived at a reduction based on that.
Yeah, but how did you do that? What's your methodology for saying these are past bullying claims? Here's this pretty low bar definition at Section 8A of the new meaning of bullying. Essentially, it's a guess, isn't it?
There is a certain level of judgment required, but I wouldn't characterise that as a guess. It's based on the data that we have and the volume we have, and therefore the reductions. It would happen based on these definitions.
Okay. Well, my belief of the definition is that anyone making up a claim and getting a site to verify it will still qualify under bullying, but you've arrived at a different optimistic conclusion, haven't you?
I wouldn't characterise it as optimistic. I'm required by my professional standards to provide the central estimate.
Okay. Can you provide your methodology on notice as to how you've arrived at this 1/3 reduction in new claims, which I've got to say, to me looks completely fanciful? And also, could you give the committee a guide on the impact of including the excessive work demands clause after the exposure draft? What's the impact of that? I mean, Mr. Coos-Trotter said excessive work demands are a big problem in the claims. Why have they been added in after the exposure draft, and what's their impact?
I might need to take the impact number on notice. It is an increase in the costs. Memory, it was not a large increase.
Memory's no good on that one either?
Not the exact dollars, but it wasn't a large increase in costs. I just want to get you the exact dollars.
Okay. Mr. Coos-Trotter had a better memory.
Government questions?
Unbelievable.
Thanks,
What do
Chair.
these people do?
If I could just come to the last question in the last session, just around the greatest deterioration to the scheme, and I note your answer. So would it be fair to suggest that the greatest endeavour in a structural reform or legislative reform is to try and tilt the scheme towards those that have the most significant injuries to make it sustainable in the longer term?
Yes, exactly.
Could you explain to the committee what the long tail savings, or where the long tail savings will come from with respect to the proposed reforms?
Yeah, sure. I invite Mr. Liu to comment from an actuarial perspective.
So on that long tail perspective, it is that threshold change that makes by far the biggest difference. And we have released the financial, from the published financial impact for the committee, that highlights that as well in terms of the avoided costs for the threshold items.
Right. So again, it's not from claims that are currently within the system that are being dealt with currently?
No.
Okay. If I could just come to the line of questioning around return to work, is it fair to say that for those that can't return to their place of work that have a higher WPI rating, commutations is part of the flexibility and the options being provided within this bill?
Yes.
To provide I suppose a soft landing of sorts for...
So the bill opens up more opportunities to provide commutations to people in those circumstances.
Okay.
Yeah.
Thank you.
Who otherwise would not get a lump sum. Yeah.
Yep.
Yeah.
That's it from me. Peter, Jenny.
Just a small one, and it's probably for ICARE. The 2019 DOR report in Finding 11 stated, and I quote, ICARE should address the staff turnover at EML as a matter of priority to ensure case management services are improved. Are you aware if staff turnover at EML has been addressed since that report?
And I understand email will be in here later, but I believe when that was written, their staff turnover was 30% or higher of case managers, and that's now below 20%. So it's been reduced significantly over the recent years.
Has it been reduced enough?
Well, I think we accept the fact there will always be turnover, and a number that's less than 20% is a good number, would be our view.
Okay, thank you.
Just probably one other question from me. The McDougall report cited a Compton Sargent review which identified the principal risks to the financial stability of the nominal insurer, and it identified those as the claim costs of existing claims and future underwriting, investment return on financial assets, but also the amount of premiums that will be collected. Is there any sort of modelling that has been done or assessment as to what will happen with respect to premiums if they keep escalating in the manner that's projected if there are no reforms? Is there a risk that people just simply drop out of the scheme, or self-insurers come into the system? Given that's one risk factor, has there been some assessment into what the continuing trend with premium increases will result in?
I invite my colleagues to comment.
So I think, as previously mentioned, if the current trends continue, the one scenario of that is we will need the 8% that is already filed and 2 further tranches of 12%. It is, I just highlight, it is a scenario. We will assess as the times come. That will take the premium rate to 2.5% of wages in the nominal insurer.
Sorry, to
2.5% of wages in the nominal insurer. So that will kind of increase employer costs and provide financial pressure on
what is it
employers.
currently? Sorry.
It's
1.85 with the next filing moves to 1.99.
Right.
yeah.
Okay. Thank you. Thanks.
Can I ask, perhaps Ms Young, do CIRA undertake any enforcement actions to make sure employers comply with their return to work obligations?
Yes, we do. So there's a combination of actions that are taken. Some are done by Safe Work and some by ourselves. So we have an inspectorate which actually goes out to employers to look at their operations around return to work specifically. They're a return to work inspectorate, and they're consistently taking those actions with all forms of employers.
Thanks.
How many fines, how many fines have you issued to employers in relation to return to work obligation breaches?
I can get that for you if you.
Thank you. Did you want another question?
Well, just
Mr.
one
Tudor?
question to you, Ms. Young. You said that there are a number of prosecutions underway in relation to fraud. Can you give me a description of one of the prosecutions that you have that is currently underway?
So I'd rather not give you a description.
You don't have to give us the identity of the litigants.
What's in front of us? We have a range. I mean, some of the previous ones that we've had, for example, those that have gone around underinsurance with Crown.
So underinsurance.
Underinsurance. Some of those have been
underinsurance.
underinsurance. We've got another where we have found where people have set up shell companies and put in place directors.
I'm talking about fraud.
So that's fraud.
Fraud, yep.
That's fraud. So that's where they have actually set up shell companies and they
to hide I understand.
to hide claimants. And I think there's significant amounts of monies coming through those. So they're the sorts of fraud.
So, but there's no identification, for example, of circumstances where someone has no prosecutions in circumstances where someone has lodged a false claim.
There are
There are
circumstances of that.
Can you give me a description of that case?
I would have to have a look at the detail.
My last question is to you, Mr. Kurtzschneider. You identified excessive work claims as being a significant component of new claims.
I talked about work pressure.
Well,
and I think there's a spectrum of work pressure, and
but does it fit under the definition of excessive work claims, which has now been introduced into the Act?
Some would, some wouldn't.
Well,
from memory, and I will let Mr. Liu check the numbers, but I think the introduction of the amendment around excessive work pressure it reduced. Had the effect of increasing liabilities against the government's package by about $170 million over 4 years. So just to give you a sense of its impact, it's modest.
Who asked for that amendment?
That came up from the government's consultation with the union movement.
So between the exposure draft and the final bill?
Yeah.
Can I just ask one final question? It's not correct to say that the government bails out the TMF, is it?
Well, it has. It's put $6 billion in since 2023.
Sorry, are we talking about the payment it makes to cover its own liabilities for its employees and its own general insurance lines, or are we talking about some benevolent bailout?
No, we're talking about putting money into the scheme to ensure its funding ratio is at least 100%.
To cover the government's own liabilities
Yes,
for its own employees and its own insurance.
But it is $6 billion that we could otherwise have spent on other government services, so yes.
Perhaps on notice you can tell us how much of that comes from historical claims and general lines.
Okay.
Because we have run out of time.
Sure.
But yes.
No, happy to.
Thank you. Unfortunately, we have run out of time. I think we could go all day.
Right,
thank you so
Excuse
much.
me, Ms. Boyd. Excuse me, Chair. Sorry to interrupt you. I just wanted to correct the record on who is doing the vocational programs research evaluation. So that's the Australian Council of Educational Research. And just for the numbers, 2,000 people have gone through our return to work programs in the last year.
Thank you. Appreciate that. That brings this session to an end. We will have a quick break and be back at 10:45.
All right, thank you.
Thank you.
We're ready to go. Excellent. Welcome back. I now welcome our next witnesses. Thank you very much for making yourselves available this morning. If I could start with the witness on my immediate left, if you could state your name and position title and then swear either the oath or the affirmation.
Rebecca Said, General Manager, Government Services, Allianz. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you.
My name is Mark Pittman from Allianz, Acting Chief General Manager. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Matthew Vickers, General Manager, SME and Specialty, EML. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you.
Good morning. My name's Don Ferguson. I'm the CEO of EML Management. I'll take the oath. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Good morning, I'm Linda Reeves and I am the Executive Manager of Employer Choice, Claims for GIO. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you. I will invite you to each make a short opening statement. Just before I do, I will note that there are 6 claim service providers in the iCare system. We did invite all 6, but given the time restraints, we weren't able to get everybody here, but we're incredibly grateful that the 3 organisations who appear today have appeared. If I start with
Can I interrupt you there? Apparently there was a statement to the market this morning, or to be made at 11 o'clock today, in relation to
iCare is making a statement to market at 11.
About claims managers. I wonder if any of these witnesses knew anything about that before they came up. But anyway, maybe I should ask that.
Yeah, okay, interesting. We did have a late apology from one of them. Okay, sorry. Let's get back to short opening statements if you'd like to.
Thank you, Chair.
Yeah, yes, please do. Sorry, please go ahead.
So, good morning, Chair and members of the committee. I'd like to thank you for the opportunity to give evidence to the committee this morning. As I said, my name's Mark Pittman. I'm the Acting Chief General Manager for Allianz's Personal Injury Division. And with me is Rebecca Said, our General Manager, Government Services. Allianz is one of Australia's largest workers' compensation providers, and as the Chair pointed out, one of 6 claim service providers in New South Wales, acting on behalf of iCare. Allianz has been in the workers' compensation scheme in New South Wales for over 100 years, and strongly support a fair and financially sustainable workers' compensation scheme that provides access to care and support for injured workers, recognising that all parties have a role to play in ensuring timely and sustainable return to work. Allianz takes our obligations as a claims service provider very seriously, including supporting employers for work, health and safety practices, and assisting them in fulfilling their workers' compensation obligations. Allianz is supportive of legislation that is clear and unambiguous, both in its intent and in its application, that provides support and care for injured workers and employers, and that provides a framework for financially sustainable workers' compensation schemes in New South Wales, and we'd be happy to assist the committee as part of the inquiry.
Thank you.
Thank you, Chair. A short opening statement on behalf of EML. So I'd like to thank you, Chair and committee members, for the invitation to appear today. EML has been operating in the New South Wales workers' compensation system for over 115 years. We're a specialist business that's focused primarily on workers' compensation, and our purpose is clear: to help people get their lives back. As a claims service provider, our primary responsibility is to support injured workers to access the treatment and services they need, while also helping employers to facilitate safe and sustainable return to work outcomes. In New South Wales, we deliver claims management services on behalf of iCare, and nationally we currently manage over 92,000 claims across 13 jurisdictions. Our role is grounded in intervention, fair decision making, and a strong commitment to delivering better outcomes for both workers and employers. We understand the profound impact workplace injuries can have, not just on health, but on families, livelihoods and workplaces, and we take that responsibility seriously. We welcome this inquiry and are committed to assisting the committee by providing open, transparent information about our role, performance, and how we can contribute to a stronger, more effective workers' compensation system in the future.
Thank you.
Chair, I don't have an opening statement. Thank you.
Thanks. Okay, we will commence with questions from the opposition.
Thank you, Chair, and thank you very much for coming in today. It's the first opportunity we've had to talk to the people who are at the coalface of dealing with claims. And the questions I ask, perhaps I'll put it to you, Mr. Ferguson, and then anyone else wants to contribute, they can contribute. At what stage do you say that a person with a psychological injury should be assessed for the purposes by a psychiatrist or a psychologist for the purposes of involving them in a back to work regime?
I think, thank you for the question. It's very important to have access to appropriate specialist assessment and care as part of the process. Very important to make sure that people are assessed by individuals who have the right skills and qualifications in order to determine the needs and also their eligibility for access to the system, as well as supporting them return to work. Specifically in relation to the timing of that, I might pass to Mr. Vickers to give you some further details.
I'd suggest in terms of our approach being framed in early intervention, you would like them to be seeing psychologists or psychiatrists as soon as possible after a mental injury is identified.
Is that 3 weeks, 5 weeks, 10 weeks?
I would love within a week.
Within a week?
A general practitioner making that referral and then access to appropriate treatment and intervention as soon as possible.
Do you arrange treatment or access to psychologists?
Not directly, no.
So you work through the GPs, do you, for the purposes of organising those referrals?
That's correct.
How quickly, in your experience, are claimants actually getting to see a psychologist?
I'd need to take the question on notice. It depends a lot in terms of the region and location that the individual resides in.
Well, you're very experienced in this. The EML are the biggest providers. You have no current information about how, on average, someone would get to see a psychologist or psychiatrist?
Not on average. You can see it as early as a week or 2 weeks after commencement of claim. Equally, there are examples that have been quoted in similar forums to this one of that access not being provided until 8 to 12 weeks after report of claim.
And is that your experience, Mr. Pittman?
It is, Mr. Tudor. We generally see the metropolitan regions, there's a faster access to treatment than it is in the regional areas of New South Wales. So on average, we'd probably see probably an extra 3 weeks, 3 to 4 weeks longer to get treatment in the regional areas compared to the metropolitan regions.
Is there a problem in getting in to actually see psychiatrists and psychologists for the purposes of assessments and working to actually get people back to work?
There is a lack of accredited psychologists and psychiatrists in the scheme.
So if you were working on a scheme to get people back to work more quickly, you would be advocating, would you not, for more psychologists and psychiatrists to be available?
I would be.
In the scheme?
I would be.
In terms of assessing people for capacity to work, what's your involvement in that?
So our case managers will obviously receive the claim. They'll go through the process to assess whether it's work-related, whether it's an injury or illness. We'll obviously rely on the medical information that we receive both from the worker and ourselves, and then we'll process through making the decision around both treatment and liability based on independent evidence that we've received and the information from the worker.
So in terms of capacity to work?
We're relying on the GPs to...
The GP makes that assessment? Any other sources of information that you'd rely on?
Allied Health will also play a part in that.
And in your experience, how many injured workers with psychological injuries have injuries with a 21% whole of person impairment?
I'd have to get back to you, Mr. Tudor, on that. We do know that the bulk of WPI claims we see are in the for psychological injuries are in that around about the 10 to 29, sorry, 15 to 29%.
To
15 to 29%.
29%. Well, in respect of the 21 to 20 to 31, you have no perspective on how many claims fit within that category?
I can get that information.
What is the characteristics of someone with a whole of person impairment above 21%?
It seems there's a scale that's used by the psychologists to assess their function. And there's different areas that they look at, both the worker's ability to actually conduct themselves in a normal way, to look after themselves, look after their families, what's their employability, what's their medical status, both physically and mentally. So there's a number of different cohorts that are looked at. So it's people that are erring on the higher threshold, where they're not able to conduct themselves either physically or mentally or socially in the same way that other people could, that are in the higher category.
And they would have limited capacity to return to work?
They can. It depends on exactly, it is quite a complex assessment, so it depends on which aspect of the assessment. If it's a significant mental stress that's preventing them from returning to work, that tends to be the bigger issue rather than the more physical side of the claim.
Does anyone else want to make a comment in relation to the characteristics of someone who falls within the 21 to 31% cohort?
Not specifically to the characteristics. I would agree with Mr. Pittman in relation to the operation of the PERS scale and it being complex and not necessarily directly related to ability to return to work. Employability is just one of the 6 statements. It's a question around whether or not they're capable of returning to work in the next 12 months in the way that the PERS framework is established. 3 of the other statements are, 3 of the other areas of assessment are based on the testimony of the injured worker at the assessment point, as opposed to there being strong clinical assessment.
Who makes the decision to accept or deny liability for a claim?
We do on the based on the evidence that's received.
How often do you deny claims?
I don't have an exact percentage, but there's a reasonable declinature, but that's not the majority of our claims will accept.
You accept. Is that the case with the other insurers?
Yes.
Do you ever get feedback from the employer that you shouldn't be accepting those claims?
We do.
And the response from the employers, or your response to the employers?
I guess we see our role as educating the employer about what they should be doing to assist a worker return to their pre-injury status as much as possible, or at least to return to some form of work. Assisted with their feelings of value and connection with the workplace and with society.
Well, maybe accepting liability, though, runs counter to the instructions that you're getting from the employer. Is that the case?
It can be.
And you still accept liability in any event?
Where we feel that the evidence justifies that worker having their claim upheld, and that they require the treatment, and that we feel based on the medical evidence we've received and any other evidence that's required, that worker needs that support.
So just let me understand how this process works. You have a claim being lodged with you, and do you take a statement from the employer?
There's an early contact process where we contact the worker, the employer and the treating doctor.
And you take a statement?
It's a verbal. We receive a medical report from the doctor quite often.
And the medical reports are generally from?
In the first case, it'll be a GP.
And that GP, how extensive are the medical reports that you receive in relation to the condition of that worker?
They vary, depending on the doctor's time, knowledge.
based on those two things, you will accept or reject liability.
No, that gives us the initial information about what we should be looking at. We'll follow up with further conversations with the employer. If we don't feel the medical evidence brings out all the information we need, we may request additional evidence or information from another specialist or from the GP if we feel the report's incomplete.
See, a common proposition which is often raised in relation to claims under the Workers' Compensation Act, that an employer who is engaged in a performance review of an employee then finds that the employee the very next day is off on stress leave and that liability is accepted for that claim. Are you aware of that scenario as being a common objection to the way that claims are being handled by claim service providers?
We are.
What do you say in answer to that sort of suggestion?
Okay, so there's a section of the legislation that references this in particular. It depends on how the... Okay, so what we'll find quite often is an employer will have very good practices around performance management, discipline, etc. It can be poorly executed by the supervisor, the manager, the leader, and not in line with what the employer's policies necessarily state, whether it's the way it's done, how it's done, or where it's done. Those factors all contribute to whether we actually accept the claim and whether it's considered to be a fair assessment from the performance management perspective. So there's other complicated factors rather than just the performance management.
Do you explore
process.
those other complicating factors?
We do.
Are you the subject of performance indicators yourselves in relation to getting people back to work?
We
as
are.
part of your contracts? Are you meeting the benchmarks that have been set for you in relation to back to work for psychological injuries?
We are.
Well, what's the benchmark that your that Allianz has?
They vary across the different CSPs.
Okay, well, give us the scale.
That's commercial in confidence. I'd rather have iCare respond to that.
It's commercial in confidence, you're telling me, what your key performance indicator is for getting workers back to work?
There's, at a broad level, there's certain cohorts that claims are divided into across the nominal insurer scheme and across the TMF scheme that are categorised by a 4-week cohort, so return to work within 4 weeks, within 13 weeks, 26 weeks, 52 and 78 weeks. Each of our portfolios are different, so the targets are actually set based on our portfolios. So whether it's a corporate, SME, the type of industries that we look after, so the targets are unique to each CSP.
Well, what's your target in relation to 52-week return to work?
One moment, Mr. Tudor.
And I assume EML and GIO have similar targets?
That's correct.
What's GIO's target?
52-week, I believe, is 92%. So that's a target, and then there's an entry point that we are required to also meet.
So 42% only of workers with psychological injuries are returning to work within 52 weeks. Are you not meeting your targets?
We are just shy of our target in the corporate space. We are hitting entry, so we're above entry, and we're just short of target.
In the psychological injury space?
In psychological space, GIO do particularly well, and we are significantly better than scheme.
What's the return to work rate for 52 weeks for psychological space?
They're not separated. They're not differentiated between psych and physical. So that target that I gave you
iCare's
previously.
website differentiates.
Yes, it does.
So
Just split it out.
Why don't you differentiate?
Internally, we measure it from the iCare website, but overall we look at the entry point and targets as a business. for both physical and psychological
And
claims.
EML are the best performers because they have the biggest number of
At the largest volume, that's correct.
volume.
Yes.
So what's the return to work rate
So
for
we-
psychological claims for EML?
Mr Vickers has just pulled it up on the screen, so I'll hand to Matt to go through for you.
The target is set on a proportion of claims across 40 different buckets based on industry and psychological v physical. We don't have access to the information to then put each claim into its own bucket to tell you what the psychological target rate would be.
Well, how does the government do the modelling in respect of return to work rates and the cost to the scheme in circumstances where you can't give us the figures relating to the various cohorts which are returning to work within 52 weeks, 78 weeks? How do they do the modelling?
I could sit here and tell you what the manufacturing psychological rate at a particular point in time is supposed to be, but when you're managing claims across the 12 different industry cohorts rolled into one, it's not possible to provide you that number. I'd defer to ICARE to explain at a total scheme level how then they roll that out when we have mixed adjusted portfolios.
Mr Tudor, we focus very heavily on looking at the return to work results across the different buckets as opposed to the targets per se. So our motivation is to continually improve period on period, and that becomes our focus rather than concerned particularly about target. So we are constantly focused on how we can improve our capability from our case manager perspective, support people to return back to work, and we do follow both the ICARE and the CIRA public data that's presented in regard to results. So we do look in detail about how we're performing, where we need to lift that performance, both in the psych and in the physical categories.
One of the issues which is commonly raised is workers who are being managed by different claims managers within your portfolio area at a particular time. If I'm potentially being managed by Mr Brown and I'm next week being managed by someone else and I've got to repeat my story over and over again, what's the turnover rate of claims managers within EML?
18.46% rolling 12 at the 30th of April 2025.
Sorry?
18.46% at the rolling 12.
You had that figure pretty handy.
If there's one thing about me, Mr Tudor, I hope I know numbers.
Well, in terms of addressing that issue, how are you providing consistency of approach for workers to be able to have their claims managed within your system?
As best as possible, we try to limit the need for a claim to move from case manager to case manager. When there is a need for a claim to move, whether that's someone leaving the organisation, being promoted, undertaking a different role, we work heavily to understand and conduct a clear handover. So as best as possible, when the next case manager makes their first phone call to a worker, they are across the background and history to the claim, and that they do not need to ask any questions that they should already know the answer to from reviewing the file.
Is that your experience also?
Yeah, Mr Tudor, I was going to say, I think the process is the approach I should say is fairly consistent. We'll triage the claim when it first comes in to see where we think, based on what we understand of the claim, the duration of the claim, what the barriers might be to the person recovering, returning to work. As much as possible, try to limit the number of times that claim would move between case managers. And so if we identify there's some triggers that this might become a significant or a longer duration claim because there might be a breakdown in the relationship with the workplace, might be financial stressors, might be psychosocial issues, then that will tend to be a longer claim. Then we'll try to put it with that case manager in the first instance.
Let me ask you this. Is there a link between the fees which you charge to the government and your KPIs relating to return to work for psychological injury?
There is, and it drives us to actually improve return to work performance. If we don't meet the performance metrics to improve return to work performance, that has a negative impact on our fees.
What is that?
The
negative impact.
So there's a potential maximum amount of remuneration you can achieve based on different metrics and for different performance areas. So there's, as Ms. Reeves mentioned, there's an entry point and a maximum. The entry point's different for the different performance measures across the different CSPs. So you have to achieve that minimum entry point to be eligible for any fees whatsoever. And then it's a graded step depending on the results you achieve.
Just on that then, so in the last session we were talking about how in the last 5 years the cost of the agency fees for CSPs has increased by 260% over 5 years. Given that the return to work rates have decreased, what is that increase in cost to government a result of? Do you know?
I can answer that from an AML perspective, Ms. Boyd. The AML performance has improved year on year. Just picking up on Mr. Tudor-Hope's point, there's a relationship considerably between the tenure of your staff and their ability to perform, which is a fairly logical sounding explanation. Retaining staff means ensuring that they have a work environment which is constructive to being able to work effectively. That's largely driven by caseloads. And so to be able to operate within this environment effectively requires having caseloads of a manageable size. And the remuneration that we receive allows an investment in caseloads in order to make sure that we can support people with enough focus on direct contact rather than having too many cases and not being able to get into the details of an individual case. The competition that was introduced within the scheme in New South Wales over the last few years is important in terms of introducing competition, but it also does come at a cost. There's no administration across multiple organisations rather than just a single organisation. The costs that the fees that we've received individually within the scheme have reduced year on year as our market, proportion to our market, we've received less, but we've also retained enough to be able to invest in order to keep those caseloads low and to see our performance increase year on year. And that's largely based on how long we've been able to support that lower turnover that Mr. Tudor-Hope was talking in order to have experienced case managers and able to deliver effective outcomes.
So we've had reforms that were supposed to increase competition that you would assume would have been good for the scheme, but instead have increased markedly the costs of CSPs to the scheme while also not seeing any improvement in return to work rates. Do the CSPs bear any responsibility for that, or are you also laying the blame at the feet of sort of injured workers with psychological injuries? Is that the problem here?
Chair, could I just say similar to what Mr. Ferguson was saying, one of the cost drivers, and EML mentioned that they've seen a year-on-year improvement return to work results. Allianz has seen the same situation. So we can only speak for our own organisation when it comes to return to work, particularly in the TMF scheme where there's a high proportion of psychological injuries coming through. We continue to see our performance against the scheme there. But to achieve that, we need to have an appropriate case load so that the case managers aren't just ticking a box, they're actually spending the time with the worker and the medical providers, the employers, to actually achieve an outcome. As Mr. Ferguson also mentioned, we want to make sure that our case managers, because we need to look after their well-being as well. We have a duty of care to our case managers. So once again, that factors into the caseload that they carry. So that has actually contributed to the expense.
So if your return to work rates have improved and GIOs apparently have improved, has EML's improved? Or have yours gone down? Because someone in the system has to have had a decrease.
I was speaking on behalf of EML in terms of our year-on-year improvement. As a long-term incumbent, we certainly had some challenging periods some 4 to 5 years ago. But since then, we've been able to continually improve our performance through having greater investment, lower caseloads, and that's driven return to work. So we've got a slightly longer term perspective on that from our experience at EML.
I might have to take that up with iCare as to why it's still apparently going down if everyone's improving. Can I ask though, I get a huge number of injured workers writing to my office with their experience with claims managers, and I know there has been a huge number of complaints. Are you aware of the number of complaints against each of you as organisations and how that has sort of tracked over time?
We certainly track complaints that we receive, as well as complaints that are directed via other mechanisms such as the IRO.
Yeah.
And we focus really heavily on responding to those proactively. We know as a proportion of our overall claims that we manage, the numbers are not large, but that's not to in any way take away from the impact and the experience of those individuals who have a frustration with the scheme. And so, although I'll ask Mr Vickers if he has the numbers to hand, and he may not, I would note that sometimes the complaints relate to the experience of working with the claim service provider, and we always need to make sure that we're focused on hearing that and lifting our game. But sometimes it comes down to frustration around what they're eligible for within the scheme, and we need to make sure that we can articulate those entitlements effectively and support them through those processes as we can.
Just in the interest of time, I might ask you each to take that question on notice as to how many complaints you've had and over what does that look like over the past few years. One of the main issues, and we've heard this a lot, is that the system is said to make people sicker, particularly when a person has a psychological injury because of the hoops that they're made to jump through. And one of the issues that keeps coming up from injured workers is the issue of surveillance. Now, this is surveillance of people with an injury to, I guess, confirm the level of their injury. Is that something that each of your organisations does? Do you sort of have surveillance of people? And how do you make the decision as to which people you surveil?
Any surveillance undertaken through either iCare contract is approved by iCare. If there is a need for that is something to be considered, it's referred to iCare for a decision and approval under the decision rights framework.
Okay, and how much money do you spend, each of you, on surveillance every year?
Extremely very little, because the number of requests is relatively small and the number that are approved is an even smaller number still.
Are you able to provide on notice how much you're spending per year and how many cases are subject to surveillance?
I will be able to provide the number that iCare have approved. I won't be able to provide the amount spent because the payment classification table underpinning workers' compensation scheme just uses a single investigation code, so factual investigations and surveillance are all paid through a single payment code.
And that's something paid for by iCare separately to your...
No, it's paid. It's paid through on the cost of the claim, but you're unable to separate the factual investigation
I understand,
or surveillance.
But it's not part of your agency fee.
No, it's not.
No. So I've heard of people having their family members subject to surveillance, for instance. So an example of a man who was severely ill, whose family members were being basically watched on social media to see if there was some sort of example of him being weller than the claim suggested. Is that something that your organisations sort of regularly do, that sort of surveillance of people?
Not from our perspective, Chair. The intention is to make sure the focus is on the worker and the worker's ability to actually operate based on whatever the injuries that they might have. As Mr Vickers said, there's very, very few instances of surveillance that are conducted by our organisation.
There was a review recently conducted by the Department of Customer Services in relation to quite a few people who had gone through the iCare system and had complaints. And I understand that review is yet to have its report released. But from speaking with some of the complainants and from what has been reported in the news, it's clear that there has even been sort of compensation payments made to people given their horrible experiences within iCare. Are you involved in any way, any of your organisations, in, I guess, you know, if that's costing the government money to compensate people after experience through claims handling, does that come back to you in any way? Are you required to financially compensate the government for that experience?
I don't think I have experience of that.
I'm not aware either.
No. Were you involved at all in that review, the Robertson review?
No.
No, Chair.
Okay. All right. Thank you. Also, the numbers of, I guess, when you decide to dispute a claim and when it goes to court, what is the decision making around that, and do you keep a record of your success rate when you're disputing a claim versus what comes back from the commission?
Personal Injury Commission.
Thank you. Yeah. Do you keep records of your sort of success rate of disputing claims?
Chair, yeah. We don't look things into, that would be anathema to our organisation to think that looking at a success rate for how many claims you've declined is the target you should be aiming for.
Apologies, I didn't mean it like that. Just to reframe it, what I'm asking is basically what your, as an indication of whether or not you have validly declined a claim.
As a learning experience.
As a learning experience, what is the percentage?
I don't know what the percentage is, Chair. I'd have to take it on notice, but certainly we'll look at if we've declined a claim, the claim has gone to the PIC, and the claim is, our decision is overturned, then we would investigate to find out internally what about our decision didn't hold up when it got to the PIC, and that would actually inform our practices as well internally.
If you could each provide that on notice, that would be excellent, just with your figures.
Thank you, Chair.
Go ahead.
Thank you. Mr. Pittman, I just want to pick up on a few issues that were raised during Mr. Tudor-Hope's line of questioning. You mentioned earlier that there's a process in your organisation to assess whether an injury is work-related or not. When it comes to psychological injuries, are you able to expand a bit more on how that process works?
That's reliant on the medical professionals, so that involves the GP and the psychologist, and then depending on the severity, whether there's a psychiatrist involved as well.
And is it fair to say it's more often than not the claimant's own GP, their family GP, or is it somebody that they're referred to by your organisation?
There are criteria under the various DSM as to what is considered to be a valid psychological condition and therefore is claimable.
Sorry, I understand that. I'm just asking at the moment, the GP that they see, is it their family GP?
Often, yes.
Yeah, okay. So that GP has the capacity to evaluate whether their patient could or should return to work within the next 12 months? Is that a fair assessment?
The GP has the authority to make the decision on the certificate of capacity, yes.
And how often are those assessments challenged? Do you ever get...
I don't have a percentage, no. I'd have to take that on notice.
Yeah, okay, that would be interesting. It seems to me like there's a lot of subjectivity along the way here in this system, particularly regarding different medical professionals. People have talked about doctor shopping and all sorts of things, but sometimes you might not even need to go doctor shopping if you've got a long-standing relationship with your family GP.
Yeah, look, that is a challenge. There is a process, independent medical consultants that we can access. If we feel that the GP's assessment is not appropriate, valid, or there's further questions we need to ask, then we can refer to an independent medical consultant to challenge the doctor constructively as one medical professional to another.
How often does that happen?
It's fairly frequent.
Okay, all right. Very good. Well, can I ask a bit of an open question, open to all? what other steps might we be able to take to tighten up the system in order to ensure that genuine claimants can be covered and those that might not be so genuine?
One of the things that we've been doing in AML is, and I think this is relevant irrespective of the criteria for access to the workers' compensation scheme. Interpersonal issues will happen in the workplace irrespective of what system is then appropriate for those issues to be dealt with. We're trialling a more proactive way of supporting individuals with interpersonal conflict at work with trained mediators and having some significant success with that. So being able to proactively work with an injured worker and the other parties with a trained individual to support addressing those issues quickly and diverting them from long-term. So this is irrespective of if they're in the system or not, but proactively supporting them to address those issues within the workplace is something that we've been focused on to try and improve outcomes.
Thank you. Very helpful.
Could I just further to that, one of the things that we've been looking at doing, because there is, as we mentioned before, a scarcity of qualified and accredited psychological practitioners in the scheme, but is working with different providers to see what they can actually do to improve access and speedy access to treatment, which includes them bringing on more trained staff into their organisation. So there is one organisation that we started using late last year, and we're seeing on average they're able to get treatment started within 2 weeks from the claim being submitted to us, and they've seen something like a 94% improvement in capacity for those claims that they've been looking after. And that's a combination of face-to-face and telehealth.
Thank you. Thank you.
Mr. Latham?
Yeah, thanks. Could I please ask, is there any data on how many GPs would just turn a would-be claimant away and say, no, you're okay, you're quite healthy?
No, Mr. Latham, not that I'm aware of.
How can that be?
We obviously only see a claim from the perspective of having received a medical certificate from a GP, so you don't have visibility over how many people an individual could have gone to before they get that certificate.
There's no medical research body or association that looks at this, so the figure may well be zero. What about those referred on to psychs? How many psychs will say, no, you haven't got a psychological injury, you're okay, you're healthy? What proportion?
Don't have that information to hand, Mr.
No.
Latham, but we know how many referrals are made by our case managers to psychologists.
Have you ever been curious about that figure?
We look at, it comes into how effective the treatment's been. So we'll look at how many referrals we've made to a psychologist and how many psychologists have upheld or not found it to be a valid psychological injury, but I don't have those stats at the scheme level.
And certainly, Mr. Latham, we've cut it differently or thought about it a little differently, but we have considered the outcomes that are attained by different clinicians over time. And so it's not necessarily a scientific level.
What does that tell you?
That it is quite...
If you're a psych rejecting claims, people just go somewhere else, don't they? And they'll find someone who'll attest to their anxiety disorder or whatever it is.
Certainly.
And the psych misses out on the counselling that would come up. And also word gets out on the street, no good going to Billy Bloggs because he's not going to give you what you need.
That is a risk and a challenge. What we've tried to focus on is how do we increase awareness of best practice across the clinical industry. So we funded the development of PTSD guidelines, for example, through the Black Dog Institute, which was about trying to raise the standard across the industry. There's a significant number of tremendous clinicians out there, but we are seeking to try and distribute best practice, so we have greater confidence that wherever somebody ends up, they're more likely to receive appropriate clinical treatment. So we've looked at it from a raising awareness, raising capacity, articulation of standards, as opposed to looking at the more binary who's achieved greater outcomes in terms of diagnostic criteria and confirmation of illness.
Right. And to the panel in general, in looking at this bill, is there anything you see in the bill that is likely to reduce new claims by 33%? Which is why we're here.
Yeah, Mr. Latham, I think, in my opening address I made the comment, it depends on the regulations that are usually put in place to interpret the bill. So the bill itself is one thing, but the operationalising of the bill through the regulations will determine how the actual legislation is executed in practice. So
you've got no confidence at this time of a 33% reduction in new claims?
We haven't been privy to the modelling that's resulted in those estimates, Mr. Latham. We'd certainly be able to confirm that with stronger entry criteria, that it will follow that there will be a number of people that
well,
there'll be less people on the scheme, but we don't have the modelling.
On the written definitions here in the bill, and
so
I'd be shocked if there's any worker anywhere in the state who can't, with appropriate training and reading the guidelines, perform in front of a GP and a psych to qualify with these very mild, low-level definitions that are in the bill. Is that an unfair statement?
I'd categorise it as an unfair statement. I think if you...
Excessive work demands. You know, they ask me to do too much, I've got anxiety. How hard is it to qualify for that?
I think if you look at the original intent as Section 11A as entered by Parliament 20th of December 1995, just in case anyone wants to go and read it, what we've seen over the near enough to 30 years has been a change in terms of the statute as drafted at the time, and there's been 3 significant common law decisions that have altered what is written in the statute. You've got Heggie and Northern New South Wales Area Health Service, you've got Hamad and Q Catering, and then more recently you've got McHugh's and Brewarrina local Aboriginal, apologies to the organisation, which have then introduced this concept of perception, whether or not the injury was wholly related, removed the wholly related from the actions of the employer. You've seen a big change when I sit there and compare the draft as is available and the original intent, and I'd recommend there's an article in Precedent by Josh Dale, who's a partner at Carolyn O'Day, and comparing that article, it's only written about 18 months ago, compare how a psychological claim can now be made to that 1995 definition. I think what is now proposed goes some way to reinstating the 1995 Parliament intent of introducing that section.
And that's in regard to the reasonable persons test, being able to not be just considering an individual's perception, but to have a standard above that. It's really up to Parliament as to whether or not the standard is appropriate, but it's certainly a step towards a more impartial approach to determining, for example, what you refer to in terms of excessive work demands.
Government questions.
Thank you, Chair. Just for a layperson, with physical injuries, if you fall off a roof, you can isolate the injury. The recovery pathways are pretty self-evident. I suppose what confounds custodians of the scheme with respect to psychological injuries, it's far more invisible. The diagnosis is obviously more nuanced. What challenges people overseeing the scheme is how people at the coalface like yourselves can apply to sort of personalised services in a consistent way in such a nuanced and invisible and complex area. So what sort of incentives and performance structures do you have in order to provide that sort of personalised service at scale in a way that's, I suppose, efficient and equitable for victims or claimants.
I think this goes a little bit back to the caseload that our case managers carry, because you can't provide a tailored or personalised service with a caseload that's too high. So that's one thing we do. We do have a set of strategies and practices across our organisations looking at complexity of the type of injury, whether it's psychological or physical. And there are initiatives that each of our organisations will put in place to try to drive better outcomes and better support for a worker through their recovery that are tailored to either the industry that the worker's working in, the nature of the injury that they've actually had, their connection to their employer. So there's a number of different factors that we've taken into consideration to make sure that that worker is being looked at as an individual.
And so in a sort of way that's probably not as relevant to physical injuries, the sort of reduction in caseload and the complexity of these matters would ultimately result in a more costly case management for psychological injuries.
I'd say that there are a lot of complex physical injuries that have no psychological element to them, that are quite significant, where the worker still needs significant support to be able to return to their pre-injury duties or to some sort of work capacity. So it's not just the psychological injuries.
Obviously, the issues and the deficits that the scheme faces is a factor of what's happening in the current financial year, but what's been happening historically over several years. There have been a number of criticisms of claims management in the past, which is no doubt contributing to the current state of the scheme. McDougall specifically noted that the inadequacy in claims management has had adverse impacts on injured workers on the financial position of the scheme, arising in part from declining return to work rates. What steps have been undertaken from the bad old days, if I can frame it that way?
So I'd like to start by acknowledging, as I mentioned a little earlier, that we are operating in a different environment. The significant drop in caseloads has been able to provide a good opportunity to improve support to people to get them back to work earlier. So one of the substantial changes since, to use your phrase, the bad old days, is definitely the case management volumes. The other is the focus on investing in the skills and experience of those individuals as well. So we've focused very heavily on developing capability frameworks, training programs that support people to continually build on their skills in order to progress through different levels of experience and seniority within the organisation. We have other initiatives that are specifically targeted at individual cohorts, such as I mentioned before, around early intervention for interpersonal issues would be another example from our perspective.
Agree. We've also invested heavily in capabilities, so ensuring that our claims advisors are supported, have the right skill set to be able to do that role, so that the customer obsession, the genuine empathy that is required with these psychological injuries is displayed. Caseloads, I agree, is particularly important in keeping them as low as possible, so that sets the individual up for success, in ensuring that the communication is the key component when talking to individuals who suffered a psychological injury.
And further to that, there's also, we've introduced, as I'm sure my colleagues have, specialisation based on the type of claim, because you cannot treat every injury type the same way. And you definitely can't treat a psychological injury in the same way as you can treat a physical injury. So we do have different strategies and practices for physical versus psychological injuries. And particularly in our team F business, we've got dedicated psychological case managers.
Just with claims advisors and case managers, I suppose the one thing that still concerns me is, did I hear correctly, there's an 18.6% turnover?
46.
0.46?
Not at Allianz. Ours is 10.8%.
Okay. I mean, with respect to EML, I mean, what would be the explanation, I suppose, for that discrepancy in turnover rates of staff?
In part, we've seen a reduction in the portfolio under management given the iCare tender process and introducing competition. So at our peak, we managed approximately 49,000 claims on behalf of the nominal insurer. As at today, it's just over 35,000 claims, so a 26.5% reduction. Competition has then seen a number of individuals move to other claim service providers for opportunities from there. So I'd then comment that the 18.46 is probably artificially inflamed as a result of those movements with the reduction in portfolio under management. Our average tenure at present from our 867 frontline case managers is 2.9 years, a median tenure of 2.4 years, so a large shift from where it was when we presented to a different committee in 2020.
Is there an industry average for turnover rates for claims managers?
Not that I'm aware of.
I don't believe so. Just individual.
We've provided information to iCare in the recent past, so if I would assume that they would consolidate that information and be able to provide it.
Okay. I've been advised previously that there's a sort of accepted industry figure of around 10 to 15% turnover, but clearly that's news to you.
I thought it was more like about 18%, but I don't have it on good authority, so have to be
notwithstanding
challenged on that.
Notwithstanding the turnover at EML, you're still confident that you can provide the sort of skills and experience that's necessary to handle complex...
Absolutely. So just to be clear, our turnover rate has reduced year on year, and commensurate with that has been our tenure rate. So the more experienced our staff are, the more capable they are. Those two things need to be looked at together. And with our reduction in market size from being very close to the sole operator in the market to having a much lower proportion, it's necessary that we actually have a smaller number of staff. So that is very much one of the factors with regard to our turnover.
I mean, again, for a layperson, it just seems like the complexity of these matters is you'll have claimants with their GPs, their surgeons, physios, employers, family members. There are a lot of people to bring together when you're managing a psychological injury, and very complex. If you have a case manager who's ostensibly overseeing that, who suddenly is then turning over, moving on, and there is someone completely new in the space that's trying to corral all these different moving pieces.
It's complex. It is absolutely complex. I think in terms of providing the committee assurance, the comparative performance of EML stands as testament in terms of how we're operating within the scheme. So irrespective of having high turnover, we've come from a different position within the market than Allianz, for example, and the performance that we are able to demonstrate relative, it's not meant to be a critical comment, but in regard to your concern of turnover and capability, the performance that we can demonstrate in terms of our relative return to work rates within the scheme, I think should provide some assurance around how we're managing internally with our performance.
I take it you're not resting on your laurels at the 18.46%?
No, we continue to focus on retaining staff and investing in our people.
Can I just take up Mr. Ferguson's point? I support what he was saying. As you said, the market share has shifted around with that competition, which Mr. Vickers referred to before as well. So you have seen employers make a decision to move around between CSPs. Naturally, there's a combination of having staff move from EML to other CSPs as well as bringing new people into the scheme. So that would probably contribute to what Mr. Ferguson is referring to.
Okay,
and we certainly have seen some staff from there will come over to our business as well.
We've also experienced that. So they're not leaving the scheme per se. They've chosen another CSP, and we track internally around, is the person leaving because they're going to another CSP, a better offer, better role, better career path, or are they getting out of the industry altogether? So we track that internally to what's important. Pardon?
Does remuneration play a key role here? Sure.
Yes, definitely. Yes.
There is a reasonable element of burnout as well, given the nature of what our case managers do. They are personally threatened quite frequently. They have to deal with threats of self-harm from workers quite regularly. So it's a challenging role to hold. And the only reason you do it is because you want to make a difference, you care about the people you're supporting. You won't always get it right, but that also contributes to the attrition in the scheme.
Okay, thank you, that's been quite useful. I might just change tack briefly, just with respect to, I suppose, fraud and claims leakage. Are you seeing for want of a better term, a sort of preponderance with the improper investigation or lack of investigation and assessment of claims, or a desire to avoid disputes at all costs? Is there a thread of that with your experience or not?
I can't say that we've seen any demonstrations of avoidance of making a decision at all costs, and
but taking the easy path and just accepting a claim.
Going back to Mr. Tudor-Hope's question before, one of the challenges we have at time is some employers, most employers these days are fairly focused on supporting their workforce, but there are still some individuals within some employers that still need some support and education through what they can actually do to support their staff as they're recovering from a work-related injury or illness, in which case we'll provide the necessary education and support.
Okay, so there's nothing obvious by way of, I suppose, unmeritorious claims or fraud, throughout the system?
There is a very minute element of fraud that we see come through, but it's negligible.
How about, I suppose, the unnecessary escalation of claims costs? And I suppose by that I mean, are you aware of plaintiff lawyers, for example, who might offer explicit advice on how you inflate your WPI numbers?
What do you say?
You
can have that one.
Thanks.
Don't name them, but are you aware of that taking place?
Look, one of the things that we, I guess, flagged with ICARE, which ICARE was already aware of, is that if the legislation, ahead of the legislation being passed, in whichever form it may be passed, if it is, we would expect to see an increase in psychological injuries come through the scheme to take the benefit of the current legislation that's in place compared to any new legislation that may be passed, and that some of that will be driven by plaintiff lawyers.
Going further, I think the thing we haven't touched on, you've focused on the psychological injury with that comment. The bill proposes the introduction of the joint assessment process, and I'm acutely aware that the worker community doesn't appreciate the independent medical assessment process and being required to attend multiple medical assessments. So I think that would be a good step that Parliament may wish to take. What we find is that, and we've tracked this data significantly, but in relation to the whole of our nominal insurer portfolio for whole person impairment claims resolved since the 1st of July 2023, 39.31% of them have resolved at least one threshold lower than the claim as made. So there is definitely something to be said in relation to whole person impairment as claimed, and then whole person impairment as resolved through the process that's currently established from there.
I suppose if I can just read to you one piece of advertising from a law firm, just to see whether or not this has been the experience that you have faced. if you have been unable to reach the 15% WPI threshold, we also regularly assist injured workers in appeals to the medical appeals panels in the PIC and judicial review applications in the Supreme Court of New South Wales relating to 15% WPI threshold disputes. Are you seeing an escalation in litigation at all?
I might just note that whilst ever the legislation has ambiguity around it in terms of subjectivity and assessment processes, it leaves open the door for individuals to be supported to get over a threshold. And that is something that occurs within the scheme currently. The less clear definitions are, the less clear process of assessment is, the more opportunity there is to be able to try and work through that grey for a particular outcome. What we don't want is to see a scheme that has financial incentives to keep people in the scheme longer. There's the saying, and apologies if I'm verballing you, Chair, I think you talked about the scheme making people sick, and I'm sorry if I got that wrong, but I think that is a legitimate concern around getting into a system that then incentivises evidence-based finding a threshold, beating evidence in order to continue to receive some sort of financial outcome. That the scheme has to be there for the people who need it most, and we need to make sure that the assessment processes and criteria enable that as best as possible.
Okay. And just with respect to medical costs, before I pass to my colleagues, the McDougall review cited a number of concerns with respect to medical costs and the cost of treatment, including over-servicing, payments for non-coverage, non-investigation of anomalous claims, overcharging, weaknesses in payment management. Are they concerns today?
Some of it can be quite complex, the fee systems that are charged by different parts of the system and different providers, and one particular example of that is the hospital system, who play a critical role in supporting people to recover. We have introduced a technology which we call a surgery sleuth, which provides a really efficient way to be able to ensure that the fees that are being charged actually align to the services that are being provided. So,
are you satisfied that the fees today do align?
Certainly, that helps to safeguard against some misaligning. There's no attribution of intention in terms of them being wrong. It's more of they're very complex systems, and so the more effectively we can make sure that the scheme is only paying for what it's meant to pay for, then it reduces what's known as medical leakage and overpayment.
If I could add, I think the reasonably necessary definition and the proposed in the bill, reasonable and necessary, aligning with CTP, has the potential to alleviate some of what's being alluded to.
Right. And final question from me, just with respect to the introduction or the broadening of the eligibility for commutations, do you welcome those in the reform package?
From my perspective, it's our role to implement the Act without fear or favour as empathetically as possible.
Do you see it playing a positive role?
I definitely I can identify a number of workers or cases in my time where the ability to relieve individuals from the red tape of the system by handing them complete control would be beneficial to them as an individual, and hopefully to them getting back to life and health.
We'll go back to the opposition.
Yeah, thank you. Currently, how long do you have to accept or deny liabilities for a claim?
You'd like to think it was a simple question. In terms of provisional liability, there's a 12-week time frame. You then go into a whole host of other various nuances where it's 3 weeks from date claim made, as well from there.
Were you consulted in relation to a change in the Act to reduce that to 6 weeks?
EML were not consulted at all in terms of the bill as
Is
drafted.
anyone consulted in respect of
No.
reducing?
No.
So have you seen the current provision in the Act relating to disputing liability?
Yes, I have.
280 capital AC?
Yes.
Within 42 days after a claim is made?
Yes.
Do you think that that is sufficient time to be able to do those things which are necessarily required for the purposes of making assessments in respect of a claim?
If the assessments and information that are required to be obtained meet the same requirements as present, no, I do not.
And I take it that's one say all?
Correct.
Yes.
Then in those circumstances, would you be advocating that the current period for accepting or rejecting of claims be maintained? So 12 weeks, that is a reasonable period of time.
So what I'd like to see is a broader consideration of the reasons for the amount of time it takes currently, and a focus on trying to improve access to what's required in terms of medical assessment and so on in the first instance. I think would be really...
For the sake of clarity, I should be clear that the 6-week reduction is in fact in respect of bullying, harassment and excessive work claims.
Which the reason, if going back to if it is the same requirement on read, that then becomes a pure factual discussion. If you go back to Hamad and Q Catering, it was purely factual. Hamad and Q Catering then introduced this need to further explore the medical evidence. So if it's purely a factual-based assessment, 6 weeks should be sufficient. If we end up with a judge-made law that changes what's proposed in the same way as what's occurred over the last 30 years to needing a medical assessment, no, 6 weeks is not enough.
When you say that if it's just factual, there is still the requirement you've got to also make an assessment, assessment of the injury.
The order in which things need to waterfall through your decision-making process would change if it was purely factual. You'd have a medical certificate to make a claim. If you determine on my read it, and it could have changed in the time since the draft has been made available. If you've determined that it was resultant from an interpersonal conflict that didn't meet the definitions that are allowed, you don't need to go further in terms of exploring the medical condition.
Do you accept that when you accept a claim for liability, there is an automatic passing on of costs to the employer in relation to their workers' compensation premiums?
Absolutely.
Yes.
So at that point when you accept liability, the increase in premiums which you're passing on to the employer in circumstances where you're accepting the majority of claims which are being made, there is then a significant impact on their premiums. Yeah. So if you were going to reduce premiums potentially, one of the things that you would actually interrogate more closely is the extent to which the employer understands the acceptance of liability by the claims manager on their behalf. Do you go through a process with them to understand, so that they understand exactly what the impact on their premiums is going to be?
We explain to the employer what the impact on their claims cost can be. iCare is responsible for premium and policy management, so we can't have a direct correlation with premium, but we can certainly talk about the impact on claim cost.
A matter of principle, though.
If your claims cost goes up, your premium's going to go up. Yes.
That's right.
So, but we, on each claim, if we're going to decline a claim or make a decision that a claim may not be ethical in nature, might be around the treatment or the appropriateness of the treatment, we will explain to the employer what we're doing, why we're doing it, and what the impact will be, positive or negative.
So if there were tougher standards in terms of access to the scheme at all, that would have an impact on premiums, would it not?
It would. You would assume so, yeah.
So getting the definitions right, making sure that the categories of medical assessments were clearly defined would potentially have the best impact on premiums because there would be less claims.
Correct. Look, it comes down to how the legislation is framed, but yeah, the most black and white it can be and straightforward, then yes, that would make it easier to manage.
What I'd add to that, if you make a decision, workers' compensation is solely driven by trust between worker, employer and claim service provider, insurer. From there, if you make a decision and you get that wrong and it is then overturned 6-9 months later, you've significantly impacted on any ability to restore that trust. You've got to get that decision right from there, and that we have a common law setting at the moment that allows perception, eggshell skull from there, taking the individual as they come. Both parties wish to be believed, and we're at the centre of trying to determine which is the correct version of events.
And apologies if it doesn't need saying, but we would never want our staff to be concerned about impact on premiums in making the right decisions under the legislation in terms of injury or access to treatment.
Sorry, may I understand that again?
So we would not be seeking to make decisions based on impact on liability with regard to eligibility for the scheme or access to treatment. The focus is on the needs and the tests in regard to whether it be reasonably necessary or reasonable and necessary, and the definitions for access to the scheme. We don't want case managers sitting there going, gee, this is going to cost that employer more money, so I will deny it. That's not appropriate.
Well, I think the reasonable and necessary point is.
Can I ask you, just from a practical perspective, if as a claims manager, to what extent are you helping an injured worker get the treatment they need? So if there's, just from a very practical perspective, so if somebody is saying, this is my injury and it's been accepted, liability has been accepted, and we're trying to get that person back to work, but they're saying that they're not sure how to navigate the medical system or they don't know who to go to, is that a service that you provide for those people in trying to assist them into treatment?
Yeah, as far as we're concerned, that's the role of the case manager, is to navigate. The case manager does have access to other specialists within our business, whether it's injury management specialists or technical specialists who can also support them and how to navigate, because it isn't a straightforward system.
Yeah, that's what I thought. So, to the question of what I'm thinking about here is, we've heard a lot about the potential for these proposed reforms to have a gendered impact because of the types of industries that a lot of psychological injuries are arising out of. But one of the things that you mentioned earlier was in relation to the regional impact of a lack of access to the treatment that you need in the regions. If people were unable to use the workers' compensation system to get psychological support for a workplace injury, in the regions in particular, would that mean that they were less likely to be able to receive support because they don't have the benefit of a claims manager? Would that be a fair thing to say?
They would receive treatment and they would receive support. They may not, historically, they may not have been able to get in to see the psychologist as quickly as if they're in a metropolitan region. I know that from an Allianz perspective, and I think across the scheme more broadly, we do use telehealth to try to close that gap. There is, as I said before, a shortage of qualified practitioners.
So if these reforms go through, and these people, we heard from the Secretary earlier that, they will, have other access to other health systems or other health services outside of workers' compensation, but they'll lose the benefit, won't they, of having a claims manager to help them navigate and get the support that they need.
Could I just note, unfortunately, there are practitioners who elect not to provide services to people in the workers' comp system because they see it as too complex, too cumbersome, you wait too long to get your pay. And so I don't know that it necessarily follows that people outside of the system are going to have more difficulty in accessing treatment than those within the system. I've had a personal experience recently with somebody who needed access to psychological care, nothing to do with the workplace whatsoever. The GP was tremendously helpful I drove them there within 2 hours. They were able to get an appointment the week after. I'm not sure that the workers' comp system necessarily opens doors in terms of treatment. It does provide some funding associated with it, but so does a mental health plan provided through your GP in terms of access to psychological treatment under Medicare as well. So
you've raised my time is done, unfortunately, but you've raised a very interesting point there about the obstacles people are facing to providing treatment under workers' compensation. Could you just elaborate what you mean? What are these? Why would someone be less wanting to give support to somebody within workers' comp?
I think the simplicity of being able to take payment on the spot rather than deal with any system that requires submission, review, approval, pre-approval, those sorts of things. It's just added administrative burden for a clinician that would otherwise be able to tap and receive payment on the spot.
I'll just check.
Yep.
Yeah.
Thank you, Chair. I suppose given your market dominance as claims managers, you'd be regarded as an oligopoly. On the 7th of March, iCare announced they were opening up new entrants and competition, which in principle you'd welcome. How's that been going?
From perspective of competition, we absolutely welcome competition. We stand by our record in terms of our performance. We're pleased that performance is made public by iCare. There is performance metrics provided by iCare as well as CIRA, so employers have an opportunity to choose based on their understanding of performance as well as other things they might seek in terms of alignment with values or household name versus not. So from our perspective, we are welcoming of competition. We recognise that it means we have a reduced market share, but we focus very heavily on supporting.
But within a few months, under Ms Applin, who for many years up till February ran EML, hasn't the competition only lasted a couple of months? It's now been knocked off because of some problem with the guide wire, and a company like DXC has been told there's no new entrants.
Is that in relation to Treasury Managed Fund, Mark? Yes, I'm not familiar with that news.
This cartel has got limited competition, hasn't it? And limited desire to open up and address fraud, welcome new entrants. iCare's knocked it off now, haven't they? And can anyone explain how Ms Applin ever became the head of iCare?
So just to...
I suppose that's a question for the Treasurer later on.
To start at the beginning, Mr Latham, we at EML are welcoming of competition, and I think you've heard from this panel that there is competition that is active within the schemes.
Well, probably not.
Very capable.
But new entrants haven't come in, have they? Because Treasury, iCare's reversed that 7 March decision under Ms Applin.
Does anyone?
No, is that news to you?
News to me.
Yes, what time did this occur?
Well, I'm told in the last couple of weeks. They've sat down with new entrants and told them the earlier 7 March edict has been reversed because of a problem with a thing called guide wire.
I think...
the system can't handle new entrants.
Yeah, I think...
Is that your understanding?
The decision for the decision in regard to who provides accommodation with a scheme is not one that we take any role in. We provide the services that we're allocated to provide and compete accordingly with the other providers within the market. In terms of...
but Ms Applin ran at EML, didn't she, for 7 years?
She was
And
not...
jumped straight over to then running ICARE.
No, in fact, Ms Applin ran an entirely separate part of EML, so
What part was that?
in partnership provided the services in regard to the large government contracts, which included the New South Wales TMF and nominal insurer. Ms Applin was operating a very different set of services that sat under a different company within the group.
Thank you.
Okay, and back to the government.
I just have one question, if I can. There's been obviously some social media this morning about this hearing, and I know one comment is that your sector is riddled by industrial scale medical, legal and claims fraud. End quote. I was wondering if you'd like to comment on that, please.
Certainly from an Allianz perspective, we don't see the system being riddled with fraud. As I mentioned earlier, we take fraud very seriously, both internal and external fraud, and we don't see that situation. It depends on the interpretation of whoever's making that report of their definition of fraud.
How many psychs or GPs have been deregistered because of fraud? No one will tell me because there's none.
Yeah.
None.
Well, put it on notice, Mark. You're taking.
Well, it's no. Well, you're quoting me without mentioning me.
Well,
I don't want you to
wouldn't
yell
do
at
that
me
to
as you
you,
normally
Mark.
do, but the answer's none.
Could I note that that's possibly a question for the regulator in terms of registration?
Chair, could I just get a sense of, obviously there's, I think there's general agreement that the system should be predisposed to return to work. Now, in terms of the psychologist, the practitioners making the assessment on the return to work, do we have a sense of the quality of those reports and how good they are and consistent across the board, or does it vary dramatically between the practitioners?
There is variance across practitioners. I think most of us have done quite some work to partner with some of the practitioners to also improve their knowledge and what the expectations are, because at the end of the day their reporting is there to support us having a factual set of information to make a decision on and to inform our decision making. Where the claim's been accepted, then we obviously expect that to support us in helping the worker through their recovery. But there is variance.
And in terms of the treatment planning, CIRA recently updated from AHRR to AHTR and undertook some changes to what was required to be developed in terms of the plan from a treatment perspective. So you'd like to think that they've improved the standard of what's being provided by those treatment professionals.
So what's your overall impression of the degree to which that is dysfunctional in terms of that predisposition to return to work that I referred to, in terms of that being the overwhelming KPI, if you like, for psychologists? Is it a chronic problem?
I'm sorry, I wouldn't say it's a chronic problem. I think it's variegated. I think you end up with some providers who are very adept at providing high quality clinical care for particular conditions, and they would achieve better outcomes than others that aren't. I feel like I'm stating the obvious there, but I don't know at a systemic level that I would call it chronic. I would say there's always opportunity to raise the standard in any profession, and we applaud organisations like the Black Dog for providing leadership in those types of areas for specific treatment.
Is there any formalised process of screening that to make sure that standard lifts?
CIRA accredits each psychologist that operates within the workers' compensation system.
Is that enough?
I suggest it's a question for CIRA as to what steps and training and continuous improvement that they seek from those who provide the service.
Okay. Any final question over there? No? Okay. That does bring us to time. Thank you so much for appearing, and we really do appreciate you coming at such short notice. To the extent there were questions taken on notice, the committee secretariat will be in touch. But that concludes this session, and our next witness will be via video conference. Thank you.
Thank you, Chair.
Thank you. Andrews.
I can.
Excellent, thank you. I think we'll get started. So I now welcome our next witness. Dr. Andrews, if I could ask you to please state your name and position title and then swear either the oath or the affirmation.
My name is Dr. Douglas Andrews. I'm a senior medical assessor with the PIC, and I'll do an affirmation. I solemnly, sincerely, and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Excellent, thank you. Do you have a short opening statement that you'd like to make?
Yes, a very brief one. First of all, I'd like to thank the committee for the opportunity to appear before it. As I said, I'm a senior medical assessor with the PIC. I have extensive experience assessing claimants and sitting on appeals panels. And the role is one of resolving dispute, primarily about permanent impairment. And of course, we must approach each claim without bias. Late last week, I was approached by the PIC asking if I would make myself available to the committee. In doing so, I'm not representing the views or positions of the PIC. I'm offering my personal views within my area of expertise, and I'm happy to take questions from the committee. Just for your information, I have contributed to the submission made by the RANZCP to the previous committee.
Thank you. Can I just clarify before we go to questions? Sorry, you say you were approached by the PIC to make yourself available. Who at the PIC?
Marianne Christman.
Okay. Thank you. I think we'll begin with questions from the government. Mr. Nampa.
Thank you. Thank you, Dr. Andrews. Just wonder if you could step through the process that you're particularly involved in with respect to the provision of claims in the system.
Yes, of course. When I receive a referral that comes from the legal members of the Commission, they make a determination that an injury has occurred in the workplace, and they refer them specifically for the determination of permanent impairment, whether the claimant has reached maximum medical improvement, and any previous contributing or subsequent contributing illnesses. I receive a brief of documents, which is typically several hundred pages long, sometimes runs into the thousands of pages, contains statements, invariably statements from the claimant, but other statements as well. Clinical records are provided from general practitioners, psychiatrists, psychologists, and any independent reports that are being relied on by either party from previous assessing psychiatrists. Sometimes there are surveillance reports or bank statements and things of that nature that I need to go through. And that's the process of how I receive, when I'm doing an assessment, how I receive appeal panels are slightly different.
Thank you. Obviously, this committee is looking into concerns with respect to the growing deficit, both with the nominal insurer and the TMF. One area that can be explored, obviously, that's a non-legislative fix is a preponderance of fraud or claims leakage. Are you seeing any of that in your line of work?
Look, that's an interesting question. I think any system that's set up for compensation or for reward is likely to be gamed by somebody. Occasionally, I will see people that I feel are not authentic. Often that comes out in the large number of documents that we're able to see how they have presented over an extended period of time. They've often been in this system for several years before they get to me. They've said things to their psychologists, to their GPs, to their psychiatrists, which allow me to corroborate. My feeling is that the vast majority of people who come to me are sincere. They're not committing fraud in the sense of trying to present an entirely false image. I think, like anybody presenting for an assessment, they're trying to put their best foot forward and to make their case. But I don't think that I don't see fraud as something that I'm detecting a lot of. I'm not saying that people never get it past me. I'm sure they do. I don't know how prevalent it is. I couldn't put a figure on it, but I think it's a minor problem.
But so from your personal experience, there isn't a significant increase or incidence of unmeritorious claims or fraud that you're aware of?
I'm sorry, would you repeat that, please?
So just from your first-hand experience, there isn't a sort of a significant number of unmeritorious claims or cases of fraud that you're aware of?
I certainly wouldn't use the word significant. I would say that there's a small number from my personal experience, that the vast majority of people are sincere and fairly honest with me. When I assess them, I spend typically 75 to 90 minutes with them. I get to ask my questions in a variety of different ways, and I'm, through my 45 years in medicine, I think that I'm reasonably good at telling when people are being fair with me.
Are you aware of plaintiff lawyers that offer explicit advice on potentially inflating their WPI ratings?
But I don't know that happens. That would be outside of my expertise to know that. I am aware that people increasingly over time are aware of the criteria that are used within the peers categories, so that when we receive a claimant comes before me, they've already had 2 at least assessments with other psychiatrists to determine impairment. They've read those assessments and they're aware of what the criteria are. I don't think that there's necessarily coaching going on or people fraudulently trying to inflate, but I think that people are aware of what criteria are and what they might say.
I suppose we've got a similar question with respect to medical costs and treatment.
Yes.
The McDougall review or report noted that there were degrees of over-servicing, payments for non-coverage, non-investigation of anomalous claims, overcharging, and weaknesses in payment management. Is that still a factor that you are aware of?
Look, I couldn't really answer that. That's entirely outside of my area of expertise. I don't know.
Okay. Just with respect to coming back to the deficit in the scheme, again from your first-hand experience, what are you seeing as being what are the main trigger points for the sheer volume of people that are coming into the scheme and staying in the scheme through lower return to work rates?
From my perspective, I see an ever-increasing volume of work coming my way. Why that is occurring, I'm not sure. I'm sure that there's increasing awareness in the community of the opportunity to make claims when they're unwell, but I don't know why those claims are increasing in a manner which seems to be almost exponential.
And just with respect to, just a final question for me, just respect to the use of the WPI to determine thresholds.
Yes.
From your experience, is it an appropriate indicator of capacity for work, and is it an appropriate indicator of the need that the benefits in the workers' compensation system is designed to address?
There is always a degree of uncertainty and ambiguity in psychiatry, whether we're looking at diagnosis or whether we're looking at impairment. It's the best measure that I'm aware of. If we accept that people get injured in the workplace, and I do accept that people get injured in the workplace, then there needs to be a way to try to assess them. It's an imperfect system. It requires on subjectivity where, I know that other people claim that it's an objective measure. I don't accept that that's entirely true. It requires subjectivity. It requires the application of experience and expertise, and by their very nature, experience and expertise are subjective.
Are you aware of any other assessment model that would be more accurate? The Victorians use a different measure of impairment.
Yeah. Look, I don't know. I am aware that other jurisdictions use different measures, and I don't have enough information to give you an answer to that.
Okay, thank you.
We'll go to the opposition.
Thank you. Of course, work capacity is there is a work capacity assessment as opposed to a WPI assessment, isn't there?
Yes, there is.
Yeah. So, in respect of a person with a a WPI of 21% or more, how would you characterise that person in terms of their functionality to be able to return to work?
If someone had impairment of 21% or more, they are likely to be severely unwell. They are likely to have no capacity.
In those circumstances, of course, then if you cut off benefits to those people, they would have to go and benefit somewhere else, would they not?
Unless they have independent wealth, yes, indeed they would.
So the current number of people who are within the system who have 21% or more who would have some work capacity would be very limited. But if they did have some work capacity, say they could work, say, in some occupation of, say, 20 hours per week, that would be...
Senator, I've been doing this for many years. I've done many, many hundreds of assessments. I can't recall anybody who had more than 21% impairment who was able to work.
I've got no further questions.
It's fairly compelling. Any questions from the no? Yep, do you want one? Yep.
Yeah, thanks, Dr. Andrews. In your time in those many hundreds of patients you've had, how many of them have you said, you're fine, you should go back to work tomorrow?
Look, remember, these are not patients of mine. They're people that I'm assessing. And they've mostly been in the system for several years. Some of them are working. Some of them, occasionally we will see somebody who is working full-time. That's rare. Often they're working 10 hours a week, 20 hours a week, often not in the role that they might have left. They might have left a reasonably high-level job or a professional job, and they're working in something less demanding. But many, not most, but many people are working in some role.
Right, but how many of you sent straight back to the workplace?
I don't send anybody back to the workplace. That's not my role. I'm not working as a clinician. Their clinicians are their general practitioners, their psychiatrists. Those are the people that write their certificates of capacity that we receive and have to make judgment on. All I do is I will write out an assessment of impairment. If I think that they are fit to go back to work, then I will give them, I will say that they are unimpaired, class 1, and that goes back to the PIC. That gets taken into consideration in the totality of their assessment in terms of their total WPI. That goes back to the insurer, that goes back to their own lawyers, and the insurer, the findings of the PIC are binding unless appealed or go to high court or go to the Supreme Court. So if I say that someone is fit to go back to work, then they probably are scoring below 15% WPI.
Right. And one of the criticisms in this space is that while we have X-rays for a snapped spinal cord, we don't have an X-ray of the human mind, and it's all imprecise. And that some people just go and read the guidelines of what you need to say to get your impairment level certified, and there's no checking process that follows. So if I came to see you and said that I can't sleep at night, I worry a lot, I can't go to the supermarket, I feel incapacitated, anxiety disorder has overwhelmed my life, what do you do to check whether or not that's true?
Okay, well, and I assume you're asking it from my perspective as an assessor, not as a clinician. You're asking two questions. One is about diagnosis and one is about impairment. They're not the same thing. They don't even correlate very well. If I have somebody come to me telling me that sort of story, I take a detailed history of their symptoms. I ask open-ended questions. I try to understand. By the time they arrive at the commission 2 years after their injury or 5 years after their injury, it is very likely that they have a DSM-5 condition. The DSM-5 is an imperfect tool. It's subjective. There's a lot of overlap. If you see 5 different psychiatrists, there's likely to be more than one diagnosis that you finally see. If you reach a DSM-5 diagnosis and you've been, it's been agreed between the parties that you have an injury, then it's my job to assess impairment. And what I do is I look through all the documents available to me. I take notes from them so that I'm aware of what I might ask the person. I interview them at length, and I ask them extensively about their activities of daily living. I don't ask them whether they think they can travel or whether they can look after themselves. I ask them what they can do. I ask them what they do over the course of a day, a week, a year, what holidays have they gone on, where have they traveled outside of their own, why did they travel, who did they travel with. And this allows me to build up a picture. It's an imperfect picture, but it's probably the best I can do.
Is that all you do? You just ask them questions?
No, I said I have a brief of documents, which sometimes extends into hundreds or thousands of pages. I go through that in detail. I go through their statements. and I interviewed them as a psychiatrist, as I'm trained to do.
Okay, so after all
My
that,
interview might last an hour and a half.
after all of that, why did you say earlier on you don't know why these psychological injuries are increasing exponentially? You must have some feel for what's generating this huge problem.
Look, that's a very complex question that has to do with culture, our society, changing expectations, people's sense of within the workplace, their sense of powerlessness, perhaps. People, for example, feel that they've been treated poorly in the workplace. Whether they have or not is another question, but they feel that they've been treated poorly. They feel humiliated. They want justice. They feel that they've lost their role. They feel that they've lost their reputation, their place in society. Whether and why that is happening more in 2024 or 2025 than in 2015 or 1995, you're as expert in that as I am.
Yeah, well, in the Legislative Council, we feel all those things every day, of course, and our mistreatment by the Premier. But
Exactly.
Michael Cootes-Trotter earlier on made the claim that people are getting higher WPIs all the time. Is there any guide as to why that's happening?
I'm sorry, who made that claim?
Michael Cootes-Trotter, who's the head of Treasury.
Right. I do not see that. That's not my experience as assessor over the last decade. That's not my experience as somebody sitting on appeals panels, that the things are getting higher all the time. That is information that could be discerned from a proper study. I haven't seen that study, so I don't know the answer to the question.
Thank you.
Can I just ask you, thank you, your evidence has been very useful. Just in terms of, we had a short inquiry on a different committee into a proposed version of the bill that we're now looking at. And there were submissions to that inquiry that were talking about the work that's been done over the last few decades to reduce stigma around psychological injury, and expressing concerns that some of that work might be undone by these reforms. I guess seeking workers' compensation for a psychological claim requires a level of involvement of other people that it wouldn't do if you were sort of just going and getting help yourself. So if I felt that I needed to see somebody in order to deal with my mental health, that would be a matter for me and my GP and my psychologist or psychiatrist. But once you involve somebody from a workers' compensation perspective, you're necessarily talking to more people than that. Do you think that it's possible that some of the supposed increase in, well, there has been an increase in psychological claims, is as a result of people feeling more, that it's more socially acceptable, I guess, to be able to talk more openly about mental health issues? Is it a reduction in stigma, do you think?
Yeah. Look, that's an interesting perspective. It makes sense. I don't know if it's true, but it certainly could be the case. And I guess when you are bringing a claim in workers' compensation, you're making an allegation that you have been harmed in the workplace, and this isn't something that's going to be kept private. That's very challenging for people.
Thank you. That's really interesting. As I say, I think it does sort of accord with some of the anecdotal evidence. So, for instance, since these reforms were proposed, many of us have received emails from injured workers who have been setting out their stories. And again, it's only anecdotal, but I've had information from people saying that, 30, 40 years ago, they suffered, for instance, armed hold-ups or other things in their jobs that they didn't at the time think that they had any sort of cause for compensation in relation to. It was just something that happened to them at work that resulted in them having a psychological injury from that. Those people wouldn't have thought to go through workers' compensation then, but if that happens now, it's one of the avenues you have in order to get the help you need. it sort of makes sense, I guess, that that sort of opening up of the conversation around mental health could lead to this increase in psychological injuries. Would you agree?
Yes, I think I do agree with that. For many years, I worked as a general practitioner in a rural area. So I worked with a lot of farmers. These farmers would have never come to me and said that they were suffering from mental health problems. They might eventually shoot themselves, but they wouldn't tell me that they had mental health problems. There was stigma associated with it. It was harmful stigma. There was a tremendous sense of shame of admitting that there were problems that you had. It was more acceptable to turn to alcohol. I'm sure there was domestic violence in some of the families as people unraveled, but they weren't putting up their hands and they weren't admitting to mental health problems. So there has been destigmatization. I suppose with that, people are going to be more willing to come forward and say, this has happened to me, and make a claim. I suppose that I'm not going to say that that's the entire reason. I think it's much more complex, and I'm not even pretending that I understand the complexity of why the increase is happening to that degree.
So if you look at something like the construction industry, which we know has high rates of suicide and is also primarily men in that industry, the message that mental health advocates have been trying to get across is, if you're injured, if you're suffering an injury, and you are otherwise taking to alcohol or domestic violence or making yourself sicker, it would be better to sort of take control of your mental health issues and actually get it sorted. One of those options at the moment is sort of admitting that you've been injured at work and going and getting that help. Do you worry that these proposed reforms will leave people feeling that they won't get the support they need to feed themselves and their family at a time when they're sort of taking that step of getting help, whereas at the moment they might sort of feel that with the cover offered by workers' compensation they would take those steps?
Look, it's the reforms that are proposed aren't simple. There's many strands to them, and on one level I think that the barrier and the very high threshold which has been proposed is going to be it's going to shut down mental health, frankly. I can probably think of 2 or 3 people who have gone above 31% during my career. So that's a tremendous barrier. I think that what must happen, if it can happen, is more rapid resolution. I think this process, which drags on for 2, 3, 4, 5 years, is entrenching the problems. I have very little hope for somebody who has been seriously ill for 3 years, 4 years, that they're going to recover. It's too late. I think some aspects of the reforms are important. We do have to balance the costs. We do have to, I think when people are claiming bullying, harassment within the workplace, it's good if they have a way where that claim is tested. And one of the questions that I always ask people is, at the end of my interview, I ask them if we covered everything we should, and if there's anything else they would like to say. What they invariably, not invariably, but most people will say, the most common comment is how damaging the process of seeking workers' compensation has been for them.
Yeah, thank you. Were there final questions from government
If I
members?
can,
Yeah, sorry,
if I can just
go
ask,
ahead.
Thank you. How often does medication in regards to psychological injuries, how often does medication help get a person back to work where they definitely might not otherwise without medication?
From the perspective of a clinician, and I'm not doing so much clinical work now, but when I was working extensively with police officers and other emergency service personnel, I ran a program in a private hospital for some of those people. If we got those people early, we often got them back to work. They didn't get into the system. They were coming to us while they were still employed. They were coming to us and getting restricted duties and going back to work. Medication has a role to play. I don't pretend medication is perfect, but it has a role to play and it does help people get back to work. By the time they come to the Personal Injury Commission, they've had so many medications that haven't been effective for them. They're so entrenched in their illness and their symptoms and in their impairment that I fear that many of the medications that are being used then are useless.
And if I can just follow up, as an assessor, is that a big part of your assessment, all the different medications that have been tried and the history?
Look, yes, indeed. I take a comprehensive psychiatric history, which is canvassing all of the treatment that they've had, and of course, anything that might have happened to them before the work injury occurred as well. So in a standard way, I take the psychiatric history I was trained to do decades ago.
Thank you.
Any final questions from government members? No. Thank you so much. That's been really incredibly useful and just also so important to bring it back to the focus on injured workers as individuals. And yeah, it's been a very useful session. Thank you. We're going to take a lunch break now and we will return at 1:45, but that concludes this session. Thank you.
Thank you. Okay, goodbye.
Thank you.
Excellent, and we're back. Thank you. If I could ask each of you to please state your name and position title, and then swear either the oath or the affirmation.
My name's Mick Franco, and I am an honorary solicitor of the Self-Insurers Association, and I'm also a partner at the law firm Bartier Perry. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you very much.
My name is Rebecca Sokolovsky. I'm the chairperson of the New South Wales Workers' Compensation Self-Insurers Association. I swear that the evidence now I'm about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you very much. I'd like to invite you to make a short opening statement if you care to.
Thank you.
Yes, thank you. I will do that. So as I mentioned, I'm Rebecca. I'm the chairperson of the New South Wales Workers' Compensation Self-Insurers Association. I've been in that role since June 24, where I was the acting chair and then nominated on the 1st of November in the full role of chair. As part of that association, we represent multiple self-insurers across New South Wales. We are a not-for-profit organisation representing licensed self-insurers who manage their own risk. The association was established in 1979, and the association now has 98 full members. 13 of those are associate members, 21 affiliate, and the remaining self-insurers. The current amount of self-insurers in New South Wales, according to the CIRA website, is 71. We were approached by CIRA in September last year to start to work with them on the improvement of case management. So at that time, we started collecting feedback on a general scope from our members. And as part of that, we have been working very closely with CIRA on case management improvements, and we've been able to collect some feedback which we're here today to present on behalf of those members. Otherwise, I will give it over to Mick Franco to provide a full overview of that.
Thank you. I won't take up the committee's time by reading all of my notes, but I'll just skip through the topics. And if you want me to address you on some of these topics in more detail, I can. I'd just like to preface the remarks that we are about to make, or the evidence that we're about to give, to say that our members absolutely want to support injured workers. They want to prevent injury, and they want to positively contribute to early return to work and recovery of work. But today, I think we're largely dealing with psychological injury, and our evidence today will endeavour to showcase some of the obstacles or barriers that our members face in achieving those positive outcomes. I'd also like to advise the committee that the association does not collect data or statistics. However, every member who is a self-insurer is obliged to provide data to the regulator, and I'm sure that the committee can extract from the regulator data relating to the performance of self-insurers when it comes to claims frequency, claims duration, return to work, and cost of claims. So what we're about to say to you today is based on anecdotal information that is given to the association by members at various gatherings and forums. So that's the best we can do, unlike some of the predecessors who gave evidence today who could speak on the basis of hard data. Psychological injury is the topic for discussion. The association accepts that there is an urgent need for reform in this area. The association members view psychological injury in two broad categories: injury born out of traumatic exposure or trauma, such as violence, and injury born out of workplace conflict, performance, conduct issues where often there are two competing narratives, a narrative of unfairness by the worker and an alternative narrative by the employer dealing with managing the workplace issues. And it's this second category of psychological injury that is proving troublesome for the members of the association to navigate and manage. I can talk to you about some of the difficulties that members have in talking to workers, particularly if they're legally represented. They have significant difficulties in talking to treating doctors, and all of that contributes to an inability to find common ground. I can also talk to you about other problems that members have in managing the situation. So there are co-workers, for example, who are remaining at work, who have to take on the work of the absent injured worker, who may even be the subject of complaints of bullying directed to them by the injured worker. I can also talk to you about the CIRA standards of practice. You may or may not be aware that there are two standards of practice, 33 and 34, that govern the management of psychological injury by insurers, in our case self-insurers, and some difficulties posed there. I can also talk to you today about the proposed bill. I can say to you that the association broadly supports the bill, but it has some difficulty with the proposed version of Section 11A and the use of the word predominantly. I can go into some detail about that if you like. And I can tell you also that the members of the association are opposed to the single assessment of permanent impairment, and I can give you some reasons. But I also wanted to leave you with some other food for thought, some areas of possible reform that the bill does not deal with at all. So I'm open to go through all of those, but I realise that this is an opportunity for you to question us.
Thank you, and I will say that we did get a submission from yourselves for the previous inquiry that was on Law and Justice, obviously in relation to a different version of these reforms, but similar, and that's been very useful.
Well, in fact, it canvasses a lot of ground that the current reforms also canvass.
Yes. So what we'll do is we'll start with questions from the opposition, and then if we don't cover everything that you've mentioned just now, we can come back at the end and give you a chance to state some.
I'd like to talk about the things that aren't in the bill, if I have a chance.
Yeah. Let's start with questions from the opposition and see how we go.
Mr. Franco, thank you for coming this afternoon.
Thank you for the opportunity to
pronounce your name. So let's start with 11A and the use of the word predominantly. What do you say is the issue relating to 11A, because effectively that is a provision which allows an employer to, I suppose, challenge a claim being brought by...
So the current version of 11A uses the causation formula of wholly or predominantly, and our experience tells us that employers rarely succeed in having the statutory defence upheld with that causation formula. The injury narrative of the worker claiming psychological injury in this second category that I defined at the beginning usually involves a cessation of work in the context of some employer management action with respect to performance or conduct issues. And that narrative, in our experience, in the experience of members of the association, tends to evolve and change over time to bring in other potential causative events. So, for instance, if a worker notifies an injury and makes a claim in the context of being asked to participate in a performance improvement plan, that could well and truly come within the domain of Section 11A. And that points to the application of Section 11A. But what tends to happen is that the story of the injury changes over time to bring in other factors that fall outside of 11A, such as allegations of excessive workload or conflict issues with other employees or co-workers or superiors. And when that happens, it makes it virtually impossible for the employer to succeed in arguing that the predominant cause was the performance improvement plan. So if the worker's narrative is accepted, ultimately the 11A defence fails. And what the use of the word predominant does in the proposed version of 11A, it leaves us in the same place as we are now with the current version.
You've been involved in this industry for a long time. How many applications under Section 11A have been successful in your experience?
Well, in my personal experience, probably in matters that I've handled, and I've been doing this work for 38 years, although 11A hasn't been with us for 38 years, I would say less than a dozen.
So,
in my experience.
We heard from claims managers previously who are managing claims, and they say that they accept liability in relation to most claims brought because their experience is that most claims generally would be accepted in circumstances where they are litigated.
Yeah, I don't think you can say that for self-insurers. I think they look at every claim on the merits, yep. And if there is a challenge that is appropriately made to the claim and it fits into 11A, or if there's no injury at all,
yep.
Then they'll look to challenge it.
So just take me through the process. When a claim is made on a self-insurer in respect of a psychological work injury, what's the process that the self-insurer goes through, and how do they handle psychological injuries, if they do, differently from, say, physical injuries?
So the process is, on notification of injury, within 7 days they have to make a decision on provisional liability.
Yep.
There are usually limited there's a thing called a reasonable excuse that prevents the commencement of provisional weekly payments.
Yep.
They are limited and they are defined by CIRA guidelines. Usually, but not always, provisional liability is accepted, and that triggers the payment of weekly compensation and medical expenses. There is focus on return to work, but the claim is still investigated. So there may be a factual investigation, there may be the collection of clinical material from treating medical providers. It is not automatic to go to an IME because there are CIRA guidelines that prevent going to an IME.
IME being, for the purpose of the record?
It's an independent medical examination, a consultant psychiatrist, and you're only entitled to go automatically to a consultant psychiatrist if it's a permanent impairment claim or a work injury damages claim. Other than that, you have to interrogate the treating doctor to get the information that you wish, and it's only when the information is not provided at all, or inconsistent or unresponsive information is provided, that you're allowed to go to an IME. And so what happens in that provisional liability period of usually 12 weeks, the self-insurer builds up factual and medical evidence and then is able to make a claim liability decision at some stage. Often it doesn't have enough evidence to make the liability decision at 12 weeks, so that forces the self-insurer to accept liability.
So at what point in that process is an assessment made in relation to whole of person impairment?
It's not done at that early process. At that early stage of provisional liability, it can be anywhere from between 6 to 12 to 18 months after the notification of injury, probably closer to the 18-month mark.
And in relation to the manner in which those claims are being handled by you, or by the insurer, what percentage of those claims are resolved within that period?
That's hard to say because we don't collect. The association doesn't collect statistics, doesn't data. But look, I can say this: if an early, and this is anecdotally, if an early return to work can be achieved, even on a part-time basis in suitable duties, that is a good indicator of recovery and ultimately resolution of the claim. The longer they stay off, the chances are they won't come back.
So is it your experience that self-insurers have a better return to work rate than the NI or the TMF iCare in relation to return to work for psychologically injured patients, employees?
I don't think I can answer the question with regard to psychological injury, but I can't speak for the iCare segment, but the feedback that we get from CIRA, the regulator, is that the return to work rates of self and specialised insurers are better.
Why is that?
I don't think I've got a conclusive answer to that, but I can say that because the self-insurer is the insurer and the employer and is indivisible, you can envisage the left hand knowing what the right hand is doing. So the insurer and the employer is one. The self-insurance unit has direct contact with the business unit, if you like. And so there's no delay in orchestrating opportunities for return to work.
You may not be able to answer this either, but what is your experience of the characteristics of a person who is classified as having whole of person impairment above 21%?
Well, if it's a non-psychological injury, I think I know.
Not a psychological injury.
You're talking about a psychological injury only? Okay. Well, if it's more than 21%, there's the PIRS rating scale. Usually, one of the items on the scale always is employability, and at 21%, usually the worker is rated as a 5, which means totally unfit.
Yep.
That's what it means, but I've got some concerns about how the PIRS scale is applied in practice.
Well, that's, I don't know.
There was some evidence this morning about that,
Yep.
but there's a comment that I'd like to make about that that was not canvassed.
Yeah, go.
The difficulty with how the PIRS scale is operated in practice is that it relies on the presentation of the worker on the day of assessment. So if the worker is aware of what that scale provides, the worker can present in a particular way.
Sometimes coached.
I don't know about that, but I've heard that said, but I don't have any examples of that. But what I would say is that the assessment should not be limited to the presentation on the day, but should have regard to evidence that exists in the file before the doctor of functional ability previously. So there may be other medical reports, there may be rehabilitation reports, sometimes there is surveillance evidence that shows a higher level of functional ability than what the presentation on the day indicates.
Can I just ask one more question? So in relation to that, if you go to the PIC and there is a doctor who has all that information in front of them in terms of the history and the observations and the statements, that doctor or that assessor, they would be the best person to make that assessment in relation to their ability to resume work given all the requirements of the PIRS.
Well, they have to make that assessment at that time.
But they have more information available.
They do have more information available, and they should look at that information. And if it's contrary to the presentation, that should be canvassed with the worker. It should be tested.
Yep.
In my opinion.
Can I ask, although you don't keep data yourself, the data that's been provided by Treasury shows, and by iCare, shows that there are some aspects of self-insurers that seem to be operating more effectively than some other parts of the system, particularly in relation to return to work rates. Now, obviously, the same legislation applies to self-insurers as applies to the normal insurer, but you run your own funds effectively outside of the nominal insurer. What do you put it down to? Is it this insurer and employer as one concept that you think leads to that greater return to work rate?
I think so, and it's the ability to identify what the real issues are, creating the workplace problem in a faster time frame or quicker time frame, and to act on what you find out.
Yeah. So if I can put that into, I guess, a practical example then. So if I'm Woolworths, who have their own self-insurance, I believe. Yep.
They're one of the members.
Yeah. So if they've got someone who is injured, whether it's psychological or physical, it's in their interest to deal with that claim as quickly as possible and get that worker back to work.
Absolutely.
What have you, I guess, heard of that maybe is a different sort of culture then within that sort of claims management process to what you would get coming out of the nominal insurer?
I can't speak for the nominal insurer, but for self-insurers, they can get more up-to-date and relevant information about what's going on in the business unit where the worker is working, and they can talk to management about what the issues may be, and they could look at ways of resolving those issues, such as, transferring people within the business unit to remove the aggravation that might be causing the alleged injury.
What are the things not in the bill that you would put in the bill?
Yes, okay. So I touched on one, the PIRS scale. Don't limit the assessment to how the presentation of the worker manifests on the day of assessment. And that really means have regard to previous evidence that shows a higher level of function. One of the issues is the employer communicating its narrative not only of how the injury occurred, but what it has to offer in terms of suitable employment to the nominated treating doctor. It just can't get its viewpoint across. And often our members are confronted with a nominated treating doctor perhaps being the advocate of the injured worker and only having that narrative. I think we've reached the stage where the legislature should look at training and accreditation of NTDs.
NTD being?
The nominated treating doctor, the GP, and even allied health providers who are involved in the treatment of the worker, to have that accreditation to enable participation in workers' compensation, to improve their knowledge of the legislation and the regulatory framework, improve content and quality of medical reports, consider both the worker's narrative and the employer's narrative, both perspectives, to help drive the return to work and understand what the benefits are of return to work and recovery of work. So accreditation. And if you want to take that one step further, if there's a disagreement about fitness for work, consider introducing a return to work medical assessment process in the Personal Injury Commission, where disputes can be determined on capacity for work. We already have that for permanent impairment. There's no reason to prevent it for incapacity disputes. And that process can also contribute to better structuring suitable duty possibilities. Currently, we've got an injury management dispute process in the Personal Injury Commission, which is governed by Part 5, Division 3 of the 1998 Act. The disputes are dealt with by a delegate of the President, but there's no power to make any determination. The delegate can only make a recommendation. And the final thing is reform of Chapter 3, which governs all of injury management, and that includes return to work. At the moment, it lacks a mutuality of obligation. Most of the obligation is on the employer and the insurer. The worker is not without obligation. Section 48 of the 1998 Act deals with that, and non-compliance by the injured worker is meant to be dealt with by Section 48 capital A. But that involves a convoluted process of warning upon warning, and it takes a long time to get to a position where payments, for instance, can be suspended. It's hard to work through. It's hardly ever used. So those are the things that I would advocate are worthy of consideration for reforms.
Thank you. Mr. Latham?
Yeah, thanks, Chair. Thanks to the witnesses. Could I just get your opinion on looking at the definitions that have been placed in the bill before the committee? What impact do you think that will have on new claims?
I think I haven't studied them closely lately, but I think some of them are a good idea. The definition of around psychological injury, that makes it clear or clearer. The definition of reasonable management action, except for the use of the word predominantly, I think will probably have an impact on reduction of claims.
Right. What about the provision for excessive work demands?
Look, I'd like to take that on notice, if I may, because I haven't brushed up on that today.
Okay.
Well, would you agree that that would potentially increase the exposure?
Potentially, yes.
And the bullying definition, that all you need is someone behaving unreasonably towards a worker and it qualifies as bullying. Shouldn't it include the real purpose of bullying, and that is to intimidate someone? With the intent of intimidation?
Again, I'd like to take that on notice, but by way of brief response, I think the bullying definition should align with other definitions of bullying, say in the Fair Work jurisdiction.
Well, that's a different parliament, so...
Well, in the IRC then, for state government employees.
Right. Even on the definition of psychological injury that you cited, the Victorians have added the word significant. So theirs reads, causes significant behavioural, cognitive or psychological dysfunction. Wouldn't that be stronger?
That would be stronger.
Yeah, like any level of dysfunction is pretty low level.
That's right.
It needs to be significant, doesn't
I agree
it?
with
Like
that.
impairing your capacity to function. And have you looked at the definition of racial harassment?
Not in the last couple of weeks.
Yeah, well, this goes to one, that place in Canberra, where the inclusion of offend and insult is very, very low bar and repeats the mistakes of 18C. So wouldn't you think that that's going to be an easy one for claims qualifying?
Potentially.
And sexual harassment goes to an unwelcome sexual advance in the eyes of the victim. That could mean anything, couldn't it? In the workplace rules that now govern that particular issue.
Potentially.
Yeah, and have you looked at the definition and inclusion of vicarious trauma?
I'd like to take that one on notice.
Yeah, but in principle, say you're working in a fire station, not that they'd be self-insured, but something similar. Why do you get to have a psychological injury so people come back and tell you about their experience in the workplace when you haven't actually seen it or been directly affected? You're just hearing repeated exposure to the traumatic experience of others. That's going to open up a very broad jurisdiction, isn't it?
Yes. But it's an emerging area in medical science.
Well, this whole thing's an emerging area of lots and lots of psychological injury claims that defy Australian traditions of resilience and getting on with the job. You know, we've become a snowflake society that has all these problems, and they're now costed in terms of workers' compensation. So can you believe with these definitions we're going to have a 33% reduction in new claims?
I don't think you can make that assessment until you see cases come through the system.
Well, that's right. This is hypothetical, isn't it? Because none of these definitions have governed the system previously.
No.
So how can you really know, other than subjective judgment of the wording? Would you agree that the wording can be strengthened in a lot of areas, and that would protect employers and premium
Yes.
levels, right? Yeah,
I mean,
well,
with my comments in relation to the amendment to the proposed 11A with the the use of the word predominant, it just takes us back to where we are now. So it weakens what was proposed in the first place.
So the self-insured association aren't sort of part of the Business Sydney type cheer squad for this type of legislation, where if you get invited out of the box at the SCG, you automatically cheer for any old rubbish that comes before the Parliament.
I never accept those invitations. I've got my own.
No, I don't get them anymore, so you and me. Thanks, Chair.
Government questions.
Thank you, Chair. Thank you for your evidence today. You mentioned in your opening statement that you had some concerns around CIRA guidelines, or was it?
Say that again, please.
You said you had some reservations with CIRA guidelines or standard practice
so
in your opening statement.
Let me just preface my evidence on that point. The association in the last year or so has been working very closely with CIRA on a whole range of issues, but guidelines and the standards of practice in some areas continue to be a problem. So guidelines 33 and 34 that specifically deal with psychological injury focus the insurer on completely understanding the perspective of the injured worker, which is not a bad thing, but they also invite the insurer to go into the domain of the worker's private life, and there's a line there that perhaps shouldn't be crossed. Now, if you look at the guideline, you'll probably see what I mean. But what it lacks is inviting the insurer to also understand the perspective of the employer and the difficulty that the employer encounters with dealing with the worker, the injury and the return to work.
Right, okay. With respect to, I suppose, your membership base or your stakeholder base, how would you describe them? Are they small businesses, small to medium enterprises, large?
It's across the board. It's a whole range. So we have small self-insurers with small operations, but we have large publicly listed companies. There's a list on the CIRA website of all the current licensed self-insurers. I counted them this morning. There are 71. Right. So there are big companies like the Chair mentioned, Woolworths, BlueScope, Steel, Qantas. They're on the larger side, but then there are small and large local government authorities. There are a range of industries covered. There's no standard self-insurer.
Just anecdotally, the return to work rates, between sort of smaller members and your larger publicly listed members, are the return to work rates fairly similar, or do they vary?
We don't have statistics on that, but intuitively, if you're a large self-insurer, you would be it would be open to accept that there are more opportunities for return to work
by virtue of redeploying people outside of the place that's causing injury,
and other vacancies, even for a short term. Just having someone come back to work to be accustomed to going to work every day and building themselves up and recovering in that way, with a view to returning to their appointed role.
So would your view be that we should be careful to not extrapolate too much between the varying return to work rates amongst self-insured and the nominal insured schemes?
Well, I'm not a data expert, but all data's got to be viewed with caution.
Have you sort of surveyed your members at all with respect to why they left the nominal insurer? Were there issues with claims management?
Some members were never with the nominal insurer to start with. So, for example, one of our members, Unilever, I think was awarded the first licence for self-insurance in 1926. So we've got members from inception, and we've got members who have transitioned from the scheme to self-insurance, but we have not surveyed them.
Have you got any feedback from those members that have transitioned as to why they have transitioned to the self-insured scheme?
Not to my knowledge, no.
No. Just with respect to, I suppose, fraud or claims leakage, are you aware of plaintiff lawyers that do offer explicit advice with respect to how they might inflate their WPI?
I don't have direct evidence of that. It's been said, I heard it said this morning in some of the evidence, but not direct knowledge. And in my work, in my practice, I deal with the same lawyers often, and I believe they have integrity, and I don't think they would do that. But I don't deal with all lawyers in the system.
I suppose the only other question I've got is just with respect to your views on what impact, more self-insurers might have on the nominal insurer. Now, you may not be able to answer this question.
I don't think that's a fair question for us to answer. How could we answer that?
Well, would you accept that if you have larger companies with good WH practices that have the funds, obviously, for good governance, to reduce their risks in a risk-based industry, which is what this is, you effectively make the nominal insurer the insurer of last resort?
I don't think I can answer that question. I just don't have the information to be able to answer that question.
Okay. Thank you. That's all from me, Chair.
Just a follow-up to that one, then, because obviously CIRA needs to approve you as a self-insurer. You don't just get self-insurance because you've asked for it.
That's right.
And there is a provision in the legislation that says that to the extent that it would undermine the financial independence of the nominal insurer, then that CIRA wouldn't be approving that. So is that seen, do you see that there's going to be some big rush of additional self-insurers on the back of legislative change?
If the bill as currently framed goes through, I think there's a potential significant reduction in claims, and that might be a contra-indicator to moving to self-insurance. I can tell you that in the last 4 or 5 years, there have been more self-insurers who have obtained, more applicants who have obtained a self-insurance licence than there have been in the past.
Yeah.
I don't know how many applicants are in the pipeline. That's something that you could ask the regulator. You could ask them, how the incidence of self-insurance has changed over time. We don't have that information.
Yeah, okay. Thank you. Did the opposition have any?
Just one thing. One of the provisions which has been introduced by the government into this bill, which wasn't previously there, was in respect of bullying, sexual harassment and excessive work claims, the period for the acceptance of liability has been reduced from 12 weeks to 6 weeks. Were you aware of that?
Look, I'm aware of those timeframes, but I don't think that's quite right. I think, as I said at the beginning, the provisional liability regime requires an insurer to make an initial decision on liability within 7 days.
Yeah, well, that's provisional acceptance.
Yes.
If you go to section 280, capital A, C, of the amending bill, page 45 over to 46.
Yes.
The evidence you gave earlier about collecting all the evidence, is that time frame?
Okay, yes, I heard you ask that question to one of the previous witnesses. I don't think in a psychological injury case where there are competing narratives, where there's a long story as to how the injury happened or didn't happen, I don't think 6 weeks is enough time to collect the evidence.
Thank you. that's all the questions I have.
One of the things I didn't see in the submission that was made to Law and Justice inquiry was the self-insurer's position on the 31% threshold increase.
Yeah, look, well, I think I said at the beginning that the association broadly supports the amending bill with those two exceptions, the single assessment of permanent impairment and the use of the word predominant.
And has there been any assessment that you know of by each of the self-insurers then as to how much cost savings they would make from these reforms?
I don't think so. No.
No. Okay. Anything further?
So just to be clear on that, there's no assessment or modelling that you've done or any of the self-insurers have done about...
Individual self-insurers may have done so, but as I said, the association doesn't collect data and doesn't engage in that sort of exercise.
Just one of the provisions in this, in the amending bill, provides for the removal of benefits for people over 21, in the range 21 to 31% WPI. The evidence is, and I think you've agreed with that evidence, that subject to your reservations about the PIRS scale, that no one would have a capacity to return to work in that range.
What I said was that in that range, the rating on employability under the PIRS will be a 5, and by definition, that's totally...
So what would happen to those workers?
They would fall under the Commonwealth schemes.
Commutation.
Okay. Anything else? No. Thank you. Thanks very much. That's been incredibly useful. To the extent that there were questions taken on notice, the committee secretariat will be in touch. But otherwise, that concludes our session.
Thank you very much.
For now.
Thank you for having us.
We now welcome our next witness, Mr. Garling. Thank you again for making yourself available. If I could ask you to state your name and position title and then swear either the oath or the affirmation.
Thank you, Madam. Kim Garling. I'm a solicitor and I'm taking the oath. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you. And in addition to being a solicitor, you're the previous IRO?
I was the inaugural WIRO, as it was then called,
yes.
in September 2012 till December 2019.
Thank you. We've got your inquiry, your submission that you made to the inquiry that was held by the Law and Justice Committee, and we also have the benefit of the testimony you gave there as well. Did you have a short opening statement you'd like to make?
I think it's easier if I answer questions, and if something comes up in the course of that, I can refer to something that would help explain. But I think it might be more valuable for me to do that.
Excellent.
Thank you. And thanks for coming back, Mr. Garling. I think part of your earlier evidence was that you'd like to buy up the liabilities of the of iCare. and potentially market those because you think you potentially become a very rich man because the liabilities never materialise in the manner in which an actuary might view the same liabilities. Do you want to expand on that proposition? Because what we obviously are hearing is that this is a fund in absolute dire need of reform, and it is technically insolvent.
Thank you. I suppose it was my Donald Trump moment, but leaving that to one side, as I understand the actuarial evidence given generally and also today, the estimates are front-end loaded. So if there's an injury, X injury, it doesn't matter whether it's mental health or physical health, the long-term cost of that is estimated, and that is put into the reserve. So firstly, you set the reserve on existing injuries, existing claims up to that point. Then that reaches a figure, so you keep that figure in. It may or may not be correct because it's a mathematical exercise. It's not an exercise based on the actual claim. It's based on looking at the types of claims and a broader mathematical approach. Very clever, not denying that, but it's not necessarily on an examination of every claim carefully. It's done on a mathematical basis. So secondly, having done that, you then have to estimate when the money is going to be paid. Because if someone is seriously injured, a person of highest needs, and they're 20 or 30, that could be 40 years before the money has to be paid. So it's a much more complex exercise, and I suppose I was being cheeky a little bit, but I don't think you can say that, or looking at it a different way, are we really saying that the actuary is really telling us that we got it so wrong up to now, as at the 30th of June 24, when we did the accounts, we got it so wrong that we have to fix it now. And we got it wrong the year before, and the year before that, and the year before that, because there's been no hint of any disaster coming. There's no hint of any explosion at all, as I understand it from the published accounts. So surely, if there is a major disaster ahead of us, that is because of the failure in the actuarial calculations. The two can't stand. You can't say at the 30th of June 2024, as confirmed by the signatories to those accounts, that everything was fine. There was no hint of any problem in the future, and then 6 months later in December say, oh look, we got this completely wrong, there's a complete disaster on the way. Now, I'm not trying to be an expert actuary, I'm just making the point that the two don't stand together, and if you were a public company, you'd be in serious difficulty. If you suddenly found in December, 3 months after you signed the accounts, that in fact you were insolvent, I think you'd have some difficulties in explaining that.
Well, one of the things that has been put to us about the dire need for reform, of course, is increasing premiums. And again, I think this is something you addressed in your previous evidence, but the Treasury is advising the Treasurer, I assume, that premiums will need to increase by 8%, 12%, 12% to reach a position whereby the ratio for the nominal insurer reaches 100%. Do you agree with that analysis?
I can't agree or disagree. I can say this. An 8% increase over $1,500, according to my calculation, is 50 cents a day. I'm not sure it's going to break the bank of any employer. Secondly, I don't know how you can calculate into the future until you see whether these reforms are successful or not. Thirdly, if what you're saying is that the actuaries and the management of iCare and CSIRA failed to correctly assess premiums for the past 3 years, then maybe they should tell us.
Well, it may have been that, CSIRA effectively set the premiums, but potentially government overrides a provision or a premium filing by iCare. There can, and in fact, I'll make this admission here and now. When I was the minister, I overrode a premium filing by CIRA during COVID because businesses were not operating, and I thought it was an impost in relation to it. But I think my question goes to the goal of actually getting to 100% of assets to liabilities, and that's in the case of the NI, it is premiums collected to potential liabilities.
It's an interesting question because it raises some other issues. As you've said, business practicality on the day, COVID, some other issue that is sensible, but there have been studies, and it might be appropriate to introduce this. There is an international forum for workers' compensation, which I won't try and tell you the name, but it's referred to as the IABC. And that's been around 100 years, and they produce a wealth of information and data across the States particularly, and Canada. And they've addressed all of these questions in depth over many, many years, and they produce an enormous amount of paper. Leaving that to one side, isn't the question rather what is reasonable to get us back to a reasonable funding stage, given that we have no shareholders and we have no underwriters? So unlike an insurance company, which has to do the accounts on the 30th of June and then account to the underwriters for their share of profit, account for the dividends to the shareholders, and all of that, we don't do any of that. The Workers' Compensation Insurance Fund is just a continuing lot of money. Now, it may be wise, it's a philosophical issue. Do you want more money? Should you go up to 110% so that you know your future costs are all going to be maintained, or do you go to 90% knowing that probably that'll be enough? I don't think it's an easy question to answer.
Can I take you to another? So in the previous inquiry, you made this observation that the legislation is quite clear that an injured worker with any work capacity is obliged to return to work or not get compensation. And then you went on to observe, we've dropped that practice or procedure, in my humble opinion, which would address a lot of the comments that have been made. Do you want to elaborate on that?
Yes. The 2012 reforms were landmark reforms. They might not have been popular in some areas, but the landmark part of those reforms was to change everything from fitness to work to capacity for work. Now, they may seem cute little terms, but they're very important, because what happened was the bricklayer, whose back went at 55, not unreasonably, was able to get permanent pension because he was ruled to be unfit for work as a bricklayer. And we had in 2012, I think the figures are right, and some 60,000 workers on pensions. And they were reassessed or liable to be reassessed, and remarkably most of them went and found something else to do. So the idea was not what you can't do, it was what you can do. And I confess, and some people might remember it, making a statement somewhere, that it really meant if you weren't in a coma, you had capacity to work. Now we've dropped that. We just don't seem to fuss about that anymore. And the concept was that you would have a work capacity decision every 28 days. And that would enable an insurer, a claims manager, to look at what's happening and work out why you're not back at work, because you have to go back to the doctor and get another certificate for the next 28 days. And those work capacity decisions are crucial. The Work Cover Authority decided they weren't going to do that. So they did very few work capacity decisions, and it slowly dissipated. So there are not the number of work capacity decisions you would expect. So if there are 70,000 new claims, you would expect at least 70,000 new work capacity decisions. And I think you'll find that it'll be minimal, because the insurers don't believe in doing that. And that is a very important check and balance as to how the injured worker is progressing.
Just taking that further in relation to psychological injuries and the work capacity tests which you would make in relation to that. Generally, I think it is accepted that the return to work for a psychological injury is almost like part of the recovery process from that psychological injury. I just wonder whether you see anything in this piece of amending legislation which positively embraces that principle of return to work to positively encourage recovery.
Without the detail, if I can reflect on the statements that are made by the government or on behalf of the government, I thought they were pretty blunt in saying that they didn't want to have any psychological claim. They were more interested in prevention than compensation. So they were relaxed about the fact that someone would not get compensated and therefore return to work really wasn't a factor in that decision. If you can't get compensated because your injury is not a compensable injury, then return to work is irrelevant. But again, going back to 2012, another fundamental principle there was return to health. And I've always personally struggled with the return to work concept because the first thing you have to do is get the injured worker back to health. When you get back to health, then the next step is return to work. And again, referring back to the IABC experience, Canada, or one of the provinces in Canada, looked at this and went, look, we're not interested in how the injury occurred. Someone puts in a claim, our aim is to get them back to work, health and work. They employed, if it was 200 extra workers in their the comparative eye care system, and they said those 200 or 300 are only interested in getting you back to work. They're not interested in the claim, in the injury, in the health. They just, here you go, here's X, you've got to get him back to work. And it cut their rate of not getting back to work significantly. I mean, by 30 or 40% within a year, because they were concentrating on nothing else. In our system, to be fair to the claims manager, you often have someone that's quite young, come out of university, is in this area for the first time, and they're worrying about the claim. Is it technically right? Is the health? What about this? There's a lot of talk about whether you should have this operation or that operation. They have no concept of getting people back to work. It's not their focus. And if I could make just one suggestion, it would be to concentrate on return to work as a function. So yes, you're better, you can go back to work now. We are going to find you work. Rather than leaving it to a claims manager who's worrying about everything else, who hasn't any skill in returning to work.
Well, you probably haven't had an opportunity of reviewing this, but there is a document that there from April this year where the government has adopted a New South Wales government return to work strategy.
Yes.
Wouldn't you suggest that if in fact embraced, that strategy, according to the evidence you've just given, would be the best tool for getting people back to work?
Absolutely.
And reducing the cost to the scheme?
Absolutely, but bear in mind that also under the employment rules that operate in the public sector, if I advertise in my agency, anyone can apply for that job. So I had a character who I complimented, who was from the ferry, and he used to say, mind the gap. And he came in and wanted a management role at Wairo, and he was entitled to. And I thought it was a terrific step by him. But so that already exists, the opportunity to move between agencies. And it's only a matter of implementing a program to make sure that happens. I don't understand why it isn't embraced.
Can we go to when we're talking about the normal insurer, and we were talking before about the funding ratio, can you explain to us what the difference is between the funding ratio and the insurance ratio, and what that means and why we have two different I've got those right, haven't I? It's funding and insurance ratio. I keep getting the names mixed up.
There's all sorts of mathematical assessments for different purposes, and I don't think I can easily explain the difference. It comes back to, this is a compensation scheme. It is not an insurance scheme. It is not a fund that has to generate profit, nor is it a fund that has to pay anyone else. There's no underwriting, there's no shareholder dividends, there's no other way, there's no money going to the government. It's a separate independent fund. And it's managed by iCare at the moment, but it's also held by iCare on trust. So, you know, to the extent that there's concern about the funding ratios of any part of it, then maybe one answer is to separate the trustee role from the management role. And that would enable a further overview of the performance. But I'm not suggesting that as a serious answer, but it's something to contemplate.
So if it's a compensation fund, then it's a bit more like a bank account, or like a. So if people are putting in, so if employers are putting in money, there's an estimate then as to how much the fund will pay out over time, and because you don't want to go to employers in, you know, one particular year and say, oh, actually things have been a lot worse than we anticipated, so this year you're going to have to pay 50% more. What we do instead is try and spread that input out from employers over time. So when the government's saying, without reform, we need 8%, then 12%, then 12% on top of our premiums for the next 3 years, how are they deciding that? And why is there not a suggestion, for instance, over the next 10 years we'll increase it by 2% a year, or over the next 20 years? Like, why is it that we're saying it has to be 8, 12, 12 within 3 years, and then we're back to 100%, and apparently that's a desirable place to be? Who makes those decisions? On what basis?
I can't answer that except to point to the regulator and to the actuaries, who are the experts in that field. But the question really that underlies what you're asking is this, that history is important, and it often gets forgotten. The reason we have a compensation fund is because at the time in the 1920s, it was going to be impossible for an employer to get liability coverage for the injuries caused to workers for which they were liable. The social contract that was done, that was really arose from the 1880s in Germany, the social contract was, we will relieve you, the employer, of any liability for any money for any reason to an injured worker, and therefore, quid pro quo, we will set up a compensation fund, and you will make annual contributions to that fund to ensure that the injured workers are paid, and therefore you'll continue to be relieved of liability for injuries. And that's the situation we have now.
So we've replaced common law liability
with a compensation fund.
With a compensation fund. Now, we had for example, an article came out last night saying, oh, the government's revealed that the nominal insurer has gone from I think a 4 billion to a 14 billion deficit. And I think it originally said debt, but now it says deficit. So that implies that somehow the fund owes somebody something, or that it's in some sort of dire trouble. What do you make of that, and how would you reframe that into a slightly less catastrophic framing?
It puzzles me as to how that can arise in what was effectively 90 days, but putting that to one side, the answer is that the premiums paid in previous years were underpaid. So the employers had the benefit of less contributions in previous years and now face more contributions, depending upon your philosophy of how funded you want it to be. It's as simple as that. As to the size of the deficit, it's a mathematical calculation, and if you go back to 2011, and I'm sure some of the members here will recall, that the government of the day after the election suggested that the deficit was over $4 billion, and it was a disaster. Well, the disaster didn't happen, even though there were reforms to cut the potential deficit. Same argument. You can have a deficit however you want to calculate it. And I'm not being cute like that. I mean, statistics can always be managed. But if that's the case, then the employers have got to kick in the extra. And the answer I have is, well, you're not being sued personally. So it's a balance for you. It's a lot less than the premium you'd pay for liability insurance. And if I can just, there is starting in the insurance game to be claims lodged for bullying that would normally be workers' compensation claims. They're precautionary. They're notified on the basis of, look, we don't know what's going to happen, but here's the claim made for bullying by Mr. X, and he's insured by us for liability purposes. So that's just shifting from one pocket to another if in fact we exclude mental health injuries altogether. Now, I'm not saying that's wildfire, but once it starts, it will gather momentum.
So does that possibility then still exist outside of this scheme, that if you're an injured worker who is not covered because of reforms excluding you, but you've been injured at work and you can show that in a court of law, you could still take an employer to court for compensation, or has that been excluded?
Under this bill it is.
One of the interesting things about looking at workers' compensation and the reforms is the unintended consequences and then what actually happens. So if you go back to 2012 again, there was a dispute about a particular section. It ended up in the High Court. The High Court made a ruling which was not consistent with what was believed to be the case, and was inconsistent with what the government thought when they brought in the legislation. And that affected every worker. So those that followed course A got benefits, those that followed course B didn't, and it was all interpretation. So the question you're asking is, it'll depend upon the facts and what actions are taken. So yes, one option is you don't have an injury, therefore you're not excluded from suing your employer, therefore you have the right to sue your employer at common law.
Right, to which they won't be insured against.
Well,
necessarily.
One of the questions then arises is if under the employment practices policy it excludes bodily or mental injury. So it's a very complex issue. I'm not trying to give you no answer, but my point being that we can't be too definite about what the various sections will do because there'll be a different interpretation.
Thank you. Mr. Latham?
Thanks, Chair, and thanks, Mr. Garling, for your evidence, and in particular mention of international experience. Is it true to say that in economies comparable to ours, that other nations are grappling with this issue of rising workers' comp costs with psychological injuries?
Taking the 50 states of America as a starting point, they're all different, and they're extraordinarily different. So in some states, they don't compensate psychological injuries at all. In other states they do, but to a different extent. And it's almost impossible to give you a complete answer on that, but this may assist you. There was a study done by the London School of Economics about 5 years ago where they looked at whether we need workers' compensation. And they were doing it specifically in relation to Austria, where they said, well, Austria's got a very healthy Medicare system, it's got a very healthy social security system, so why do we need workers' compensation? The end outcome of that was, very academic, and it didn't flow through because it was probably going to be unpopular and all of that. But one of the really well-run compensation schemes is Russia. So we had exposure by going to those meetings to Asia, to Europe, to Russia, to a whole range of international information, but the 50 states information is overwhelming because they're all different.
Right. It's a bowl
But
of
they're all
sweet
very
mate.
conscious of all of those things, and
Right.
the iCare experiment back in 2015 was regarded very closely by the members of the IABC to see whether it was successful.
Right, and for a jurisdiction that's introduced an attempt to contain psychological injury costs, who'd be regarded as best practice, and what was the level of their success?
I couldn't answer that.
No.
Because I don't know that I specifically went through every 50 state.
No, outside of the United States. You know, you mentioned Austria and
I think
Russia.
Austria was one. I think that a number of the other jurisdictions were looking at it. I mean, certainly a lot of the jurisdictions don't compensate for psychological injuries.
Right. And comparing us to Victoria, what's been the Victorian experience in reducing the number of new claims with their definitional exclusionary approach?
I have difficulty in comparing states and their performances because they're different systems. So Victoria's system is not the same as ours. It differs substantially. So it's not comparing apples with apples. It's
Right.
comparing two different aspects. What you're talking about, which is valid, is what difference does the definition make? And I can't personally answer that.
Right. Well, if we're an apple, who else is an apple?
We are the biggest, the nominal insurer is the biggest compensation scheme in Australia by a long way, and one of the biggest in the world. So there are not too many comparable apples.
Right.
For a number of reasons. So, for example, in the state of Texas, they have 250 insurers insuring workers' compensation.
Wow.
So complete, if you like, competition. You can go to
Yeah.
any insurer you like.
Bit more than our oligopoly.
Slightly.
Yeah. Earlier on, sage words, you said, I don't see how you can predict the future until you see the impact of these reforms. Is there any actuarial basis on which you can say that these pretty soft definitions are going to reduce new claims by 33%?
Well, they must.
What do you mean?
They must. These reforms, if they are in the current method, are going to have a significant impact on injured workers being compensated, because you can't get through the gate to get to the compensation level, and if you're going to be forced to go to another jurisdiction to get a ruling on whether you're actually injured at your own expense, then I've no doubt that it will reduce the numbers claiming.
Well, I think that gateway is optional now, isn't it? It's not an enforced...
We haven't finalised the legislation yet.
Right.
But as to, I expect the other question of the threshold, it will make a difference, but we're not talking about thousands of people in that gap between 20 and 30 or 21 and 31. It'll have a huge impact on them personally, and it may well save some money, but I don't think you can talk about that in the broader scheme. There's one other thing I noticed no one's mentioned, and that is another puzzle. Whole person impairment has nothing to do with capacity for work. So there are plenty of people who can work who have very significant whole person impairment ratings. And there was an example given at a conference in Melbourne of a tetraplegic who was working. They rigged up some computer stuff so that she could move ahead and make phone calls, and she wasn't being paid necessarily, but was working.
What's a tetraplegic? Like Stephen
Tetraplegic. That's
Hawkins?
you can move your head.
Right, that's it.
That's it. So when you talk about capacity for work, that has nothing to do with impairment. So we have plenty of impaired people with high ratings of impairment who could work but choose not to. And that is a bigger issue that overrides these reforms. No one wants to really deal with that because it's convenient to say you're 23%, therefore you don't have to work, you don't have capacity. The further problem that arises from that in claims management is if you are 22% and deemed having no capacity, no one follows you up. They don't ring you up and say, are you working? Can you work? Do you want to work? You're just crossed off and not followed up at all. And there's a terrific example of one particular character, if I can use that word, who taunts iCare in his Facebook posts because he's fixed for life. And he tells you.
Yeah.
And he's having a great time.
No. Okay, thanks for that.
Government.
Thank you, Chair. Thank you for your evidence, Mr. Garling. Certainly since the reforms in 2012, and I'm going to go to actual numbers, not projected figures, which are, inherently unreliable because they're based on models and assumptions, which may not be accurate. But since the 2012 reforms, we have received evidence that the funding ratio, and I'll just focus on the nominal insurer, the funding ratio has dropped to 82% in 2025 from 130% in 2015. The net asset position of the nominal insurer was $4.4 billion in 2015. It's now negative $4.9 billion in 2025. We've heard evidence that that the number and cost of psychological claims has doubled or trebled over a not too dissimilar period of time. Did you see evidence of this sort of? Well, firstly, do you have reasons to dispute those numbers as opposed to projections?
Yes, I do.
Why is that?
It's very simple. It's mathematics.
You wouldn't agree?
So you're talking about net numbers. So if you look at the figures in 2024, there were 5,411, I think the figure is, psychological claims lodged with iCare. We're not told how many were successful. We're only told about the number of claims lodged. Secondly, that is 7% of the total claims lodged in that year. So 93% of the claims are non-mental health claims. They're physical. If you go to the year before, it was 5% of total claims. And if you go back to 2014 or 2015, whichever it is, it was 6%. So it dropped from 6% to 5% to 5% to 7%. So look, there's just no basis for those statements. What you're talking about...
The actual numbers with respect to the net asset position and the funding ratio?
I'll move on to that. You're talking firstly about the number of claims.
Yep.
They're factual. They're in the iCare annual report. The numbers of claims and the percentage. So let's not get carried away. Second start is you say, well, the assets are minus, whereas they were $4 billion in positive in 2015. 2015 was a period of enormous change, and a lot was put on hold because it was a transfer between the Work Cover Authority and iCare. And one of the problems in that year was that the Work Cover Authority was not prepared to hand over all the information to iCare until the Minister stepped in and said, you will provide the information. So there was quite a bit of background issues there. And secondly, when you talk about it being $4 billion in deficit, it's not $4 billion in deficit. There's no suggestion of it being $4 billion in deficit as at the 30th of June 2024. If you project ahead and say, if all of this happens, you will be $4 billion in deficit, I accept that.
What would, in your view, be the best indication of financial health and sustainability of the scheme?
I'm not an actuary.
I mean, if it's not as crude as asset over liabilities.
But the question is, what's the ratio between premiums and the fund potential liabilities? And it goes back to what I've said earlier. The premiums have been underfunded for 3 or 4 years. If this is the case, when you look back, you go, well, we should have had more. To get to the 82%, premiums should have been higher 3 years ago. Then we'd be at 100%. So a decision was made to make the premiums less than they should have been.
So can I
We're
take
now
you?
paying for that.
Can I take you up on that point?
Yeah.
During your time as the IRO, 2012 and 2019, did you see aspects of a deterioration in the financial sustainability of the scheme during your time? Did you make recommendations with respect to that? If you did, and what was the result of that? Were premium increases or being underpaid one of those concerns?
Not for the WIRO, but I can tell you an incident. I had the external actuary come and see me early on, probably 2013, and we had a discussion about the WIRO statistics, which are extensive and really haven't played a role in this inquiry. They're much more assistance than any other statistics. And we had a discussion, and he was talking about his recommendations, and he said, well, the good thing is hearing loss claims are going to disappear almost. They're going to come a rapid decline in hearing loss claims. And we said, that's interesting, because our figures show a rapid increase in hearing loss claims. So it's a question of what figures you use and how you massage them into the system. You will find you should be able to find significant data on psychological claims in the IRO figures, because you don't get a psychological claim going beyond the weeklies unless the person is legally funded. And that'll give you a real indication of how the system is operating. And they should also be able to tell you the outcomes, because the outcomes are all recorded.
I suppose one concern that I do have, and I'm not an actuary, I'm not a financial expert, but I'll take the advice that is provided to me by regulators and Treasury, that the funding ratio provides an indication of financial health and sustainability of the scheme longer term. That significantly increasing premiums in the context of the nominal insurer and continually injecting funds with respect to the TMF is simply not sustainable, and that these schemes ultimately have to become self-sustaining to remain viable. Is that a view you share or don't share?
I think it's more a view to comment on. Would the employers prefer to move back to the common law system where they obtain their own insurance rather than participate in the compensation fund? And I could guarantee you to 100% they would not want that. So sustainability of the scheme is relative to what your alternative is. So yes, it may be expensive. Premiums might have to go up because they've been underfunded. But would you rather go to a common law system where you obtain your own insurance in the current market? It might not be very pleasant to learn what the insurance premiums would be. So it's a comparative. Should we be somewhere around 90% or whatever the figure is? Obviously. But it's not a matter of sustainability. As to the second part of the TMF comment...
Mr. Garling, for that to hold true, wouldn't it have to be the case then that one of the central objects of a compensation fund, like this as you put it, is to provide confidence to employers, to provide confidence to workers that short-term, long-term injuries can be fully funded under a scheme like this? And if you can't provide that confidence, then your proposition wouldn't hold true, would it?
I don't think there's anything relevant to confidence. The fact is, you
Can
have
you take
two choices
confidence
to
if
employ.
assets don't exceed liabilities, if your funding ratio is 82 cents in a dollar, not...
Well, you simply need to increase premiums. It's been in deficit for most of the time it's been in existence. I don't recall very often when the fund has been in surplus, and I would hope it's never in surplus because it's a non-profit fund. So you would always operate below the level of 100%, I would have thought. Logic tells you. If 82 is too low, put some more money in. Certainly cheaper than getting a common law policy with Lloyd's, if you're an employer, so you're getting a good deal. The premium's $1,500 a year. It's not going to break the bank on an average premium per worker. If you go up to $3,000, it may have some impact somewhere. But that's the average. Now, obviously, there are people pay more and people pay less. So that's the best answer I can give you. I don't agree with these comments about sustainability. I think they're misplaced completely. The answer is, hello, your premiums have to, if that is the financial position, your premiums have to go up. Now, no one likes to do that.
Did you make that recommendation in your prior role?
I never had the opportunity to make that recommendation because it wasn't part of my function at that stage, as I recall. And as I recall, it was a pretty stable period, subject to the fund being up and down over that period for different reasons. And unfortunately, it's a political issue as to what premium should be. So it really didn't matter what I thought.
I suppose I'm just interested in your thoughts on an observation in the McDougall report regarding, I suppose, threats to the scheme. And I'm sorry, apologies, but I've lost my notes, but it referred to Compton Sargent review regarding threats ranging from premiums to the underwriting position of current and future claims, the returns on investment. Are any of those relevant from your perspective to the sustainability of the fund?
Well, I can only come back to, it's not the sustainability of the fund. The fund will be sustainable. It's there for the next 40 years because premiums or contributions have been put in to cover current injured workers, some of whom are in their 20s. And they won't retire, or they may go through retirement age. So it has to be there for 50 years. The question for the employers, not the government, the question for the employers is, how much do we need to pay to keep it sustainable in the future? Because otherwise, if it's not sustainable, we're in difficulty. So it really doesn't matter how much you increase the premium in one argument, because it will be less than what the employer would have to pay to get alternate coverage. So it's a very simple exercise. It's more a question of whether the government wants to put that in play. At the moment, they would rather cut the benefits, which is one way of reducing the contributions made by employers, and a valid way, or increasing premiums. That's a political decision.
Would your proposition be to support premium increases of 32% over 3 years?
Well, 32% over 3 years is 8 or 9% a year. I don't think that's significant. Your energy prices are going up. Every other price is going up significantly. I don't see why the insurance premium's not going up. Medical costs have gone up. Treatment costs have gone up. I mean, we can't avoid increasing costs. I don't think any employer is going to balk at an 8% increase, even for the next 4 years, because it's cheaper than the alternative. Ask them, what's the alternative? How much are you going to pay Lloyd's for your policy to cover injured workers? And you'll find it'll be a multiple in the zeros.
I think we're just about out of time, unless there's a final question.
But that's your forecast, 8% per annum.
That's what we're told.
Right.
Yeah. Can I make one just very
Please.
quick, and I know we're over time.
No, you're right.
Can I make a plea? Can you look carefully at the IRO funding of workers' legal costs? There is an interpretation, and I use that deliberately, that a result of the reform proposal will be that workers will not be funded for their legal costs. Now, you've got to understand that has to be compared to the employer, who's totally funded. But I'm not sure, I come back to unintended consequence, I'm not sure that was an intended consequence. But it sits
of
there.
This bill, of the
of this
amending
bill, yes. Down the end, about 45, 46.
Okay. I'll have a look.
It's there.
Yeah, okay.
And it's a question of interpretation.
Yep.
Sorry.
No, thank you. Thanks very much. Again, thank you for making yourself available to us on such short notice. Your evidence has been very, very useful. That concludes this session. We'll now take a quick afternoon tea break and we'll be back at 3:30.
Thank you.
Thank you. Let's get back on broadcast. And we're back. Thank you very much. I now welcome our next witnesses. We have one witness in the room with us and one witness on teleconference, or video conference rather. If I could start in the room, if I could ask you to state your name and position title, and then swear either the oath or affirmation.
I'm Michael Robertson. I'm a consultant occupational and forensic psychiatrist, and I will take the affirmation. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you very much. And Dr. Epstein.
My name is Dr. Michael Epstein, and I'm a consultant psychiatrist. I'm going to give the oath. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you very much, and thank you to both of you for making yourselves available at such short notice. I'm sure your evidence will be very useful for the committee. Did either of you want to make a short opening statement? I'll go to you first, Professor Robertson.
I do. Distinguished members, thank you for the opportunity to speak to the committee. I'm a consultant psychiatrist working primarily in occupational mental health and civil forensic assessment. I have concurrent roles as an associate professor at the School of Public Health at the University of Sydney, and I am the Chief Psychiatrist for the MedHealth Group. I seek to emphasise that the views I express in my advice to this committee are my own and do not reflect the views or policies of the university or MedHealth. I've worked in psychiatry for more than 30 years. My areas of expertise are in psychological trauma, ethics in psychiatry, the philosophy of medicine, and occupational mental health. Until recently, I provided instruction and training in the assessment of whole person permanent impairment on behalf of the then State Insurance Regulatory Authority. This, in combination with my extensive experience in conducting assessments of permanent impairment related to psychological injury in multiple jurisdictions over decades of practice, qualifies me to provide evidence to this committee on the specific issue of assessment of injured workers. There are two substantive issues I see as pertinent to this inquiry. The first is the validity of the current process of assessment of permanent impairment in injured workers. The second is what I consider to be the main sleeper issue in this debate: how to best assist injured workers at the milder end of the severity spectrum of work-related psychological injury. As this committee would have heard, for the last quarter century, the assessment of permanent impairment emerging from psychological injury has been conducted using the Psychiatric Impairment Rating Scale, or PIRS, for brevity. I think it reasonable to state that this instrument is deeply flawed and much unloved within the medical legal profession. The main concern held within my professional group is that the PIRS measures disability as against impairment. This is akin to diagnosing a fractured femur by asking a patient to run 100 metres. Compared to the AMA 4th edition guides, the PIRS routinely underscores psychosocial disability at the milder end of the severity spectrum. This appears to indicate that a PIRS score of 15, the current threshold, is much higher when measured by other methods. An injured worker assessed at 15% WPI using the PIRS has an array of problems, but well-conducted intervention can and does yield a greater measure of success in terms of clinical improvement and return to economic participation. In contrast, an injured worker assessed at 22% WPI is a situation of a severe and debilitating psychiatric disorder. This is typically seen in first responders. The proposed threshold of 31% per the PIRS depicts an injured worker that I have seldom encountered in 30 years of psychiatric practice. This brings me to my second point: what is the optimal approach to the care of an injured worker with a mild to moderate level of psychological injury? Occupational psychiatry focuses on the diagnostic assessment of an injured worker and providing advice about treatment and ultimately redeployment to the workforce. This is one of several components of sound occupational mental health. Return to work outcomes are greatest in the first 4 to 6 weeks after injury. By 6 months, successful return to work is minimal. This indicates that there exists a window of opportunity in the 6 to 12 week timeframe to effect successful intervention for mild to moderate psychological injury. For me, the most gratifying scenario as an occupational psychiatrist is to avoid unnecessary medicalisation and the deleterious effects of prolonged litigation on a worker's condition. Effective early intervention in this setting in New South Wales should be routine, and addressing this is a golden opportunity for meaningful reform. With that, I yield to the committee.
Thank you. And Dr. Epstein.
Distinguished members, it's a great privilege for me to be able to talk to you. I might say that I agree entirely with what Professor Robertson had said. I thought I'd give you some idea of my background so you understand where I'm coming from. I've been involved in psychiatry for a little more than Professor Robertson, and also have a particular interest in stress-related disorders. I've worked with children, adolescents, adults. I've worked in prisons. I've worked in hospitals. I started Melbourne's first crisis service, and for some years I've been extensively doing medico-legal assessments of people who had workers' compensation claims and have been involved in transport accidents and also personal injuries. It was in that context that in 1985 a new Work Cover Act was introduced in Victoria, and this brought into being the use of the American Medical Association guides. This was then the second edition. The second edition, Chapter 12, had significant problems. This is the one that deals with mental and behavioural disorders. It had eight measures to be looked at, two of which were to do with disability. One of those was potential, and the other was the term ability, in other words, disability. There was also no method of combining the impairment. So as a result, myself and two others got together and developed something we then called the User's Manual, and this had the immediate effect of bringing different assessors much closer in their assessments of the same individual. Subsequently, AMA4 was developed and published in 1993 and came into use in Victoria in the mid-1990s. We looked at Chapter 14 of this and we thought, as Professor Robertson had said, that this was an instrument that mainly measured disability. There are four matters there, that activities of daily living, social functioning, concentration and adaptation, and only one of those, concentration, is to do with mental status, is to do with impairment. We decided not to try and make it. There are two other problems with it. One is that it did not provide any percentages, and the reason for not doing so was laughable. The reason for not doing so is that it might cause arguments in jurisdictional settings, and for that reason they didn't do so. And that meant that everybody who used AMA4 and it's then following AMA5 had to develop their own means of making this workable. There was also no method of combining the scores. And for these reasons, when New South Wales decided to move to using AMA5, I was asked to come to New South Wales and talk to a reference group that I suggest be established about the problems with AMA4 and AMA5 and suggest some possible solutions. And basically I was suggesting that they might want to continue using what we were doing, which seemed to be quite effective. Anyway, they decided to go ahead with what they wanted to do, and so they put percentages on the various levels. They added descriptors and they added a method of combining, and this has had some unfortunate effects. They've had a combining table, and the odd thing about it is that, for example, class 2, which ranges from 4 to 10%, if somebody scores in all 6 areas class 2, the maximum score they can get is 7%, which seems to me a bit odd. Anyway, so the PERS was then developed by these particular psychiatrists, so I might say had never done an impairment assessment before, but so it goes. And this instrument has now been used in Queensland, Tasmania and Western Australia, and for workers' compensation in the Northern Territory. In the meantime, in Victoria, we refined the impairment guide, and now we have something called the GEPIC, the Guide for Evaluation of Psychiatric Impairment for Clinician. In 2013, this was adopted in South Australia. So over the years, I've trained at least 400 psychiatrists in the use of the GEPIC, both in Victoria and in South Australia. And oddly enough, I've also at one time was asked to run a training program for the PERS, which I did. So that it's interesting when one looks at the difference between the measures used in New South Wales. So that Class 1 in New South Wales is 0 to 3%. Class 2 is 4 to 10%. Class 3 is 11 to 30%. Class 4 is 31 to 60%. Now, I make that point because in New Zealand, they also use AMA 5, and they've put in different percentages. So the Class 1 in New Zealand is 0 to 9%, Class 2 is 10 to 35%, Class 3 is 36 to 60%. So you can see that every jurisdiction has modified AMA 4 and AMA 5 to try and make them workable. In New Zealand, they haven't even put together a method of combining the scores, but the PERS has certainly done that. So the point that Professor Robertson made about person being in Class 3, in Class 4, 31 to 60%, which is what the government is suggesting that this be the minimum, the threshold. I might say, in my experience, this is, and you have to bear in mind that we're not looking at whole person impairment. What we're looking at is impairment that's not secondary to physical injury. So that somebody who's injured at work and may have, for example, a degloving injury of their arm, will possibly have post-traumatic stress disorder and probably also have a chronic adjustment disorder with depressed mood. The impairment from the chronic adjustment disorder with depressed mood does not count. The only impairment that counts is from the post-traumatic stress disorder. And in my experience, and certainly it sounds like the experience of Professor Robertson, for somebody with a primary psychiatric impairment to reach the level of 31% is, I can't remember seeing somebody in that situation. It just doesn't happen. So I don't think that anybody, I think it's going to be extremely few people that ever get to that threshold.
Thank you.
That's all I have to say.
Thank you very much. We'll just start with questions from the opposition.
Thank you. Professor Robertson, I think the starting position you adopt is that a proper approach to return to work scenarios is early intervention rather than cutting off benefits.
Yes.
And the early intervention which you embrace is in that 4 to 6 week gap, or 4 to 6 week or up to 6 week opportunity where you would see a worker getting in front of a relevant psychological assessment team with a view to A, assessing them, and B, potentially mapping out an opportunity to return to work.
Yes, this is an approach that dates back to the First World War, shell shock, proximity, immediacy, expectancy. In the circumstances of the shell-shocked soldier, it's treatment delivered at the front, straight away, with the expectation they'll go back on the line. Unfortunately, we don't do that to our soldiers anymore. However, I think applied to the approach I would advocate for early intervention is that to get the problem assessed quickly, get whatever intervention is appropriate to that situation implemented straight away, independent of compensation and litigation and the like, with the expectation that this process will return the injured worker either to their pre-injury duties or to appropriately modified duties. So people will go into that process with the expectation that there will be improvement in their mental state, with the ultimate outcome being returned to some form of employment or economic participation.
Yeah. Does New South Wales currently have the capacity to deliver that early intervention model?
It's sporadic. It's essentially clinicians like myself or others working in a particular setting, but occupational mental health or occupational psychiatry is an idea that hasn't quite found its expression, and I think one of the great opportunities about reform would be to establish a process at scale within the scheme to have early intervention. I've had attempts at this with various employers. I won't disclose due to commercial confidence, but I've seen this attempted in various settings, and the initial outcome is good. If you can essentially remove the litigation and compensation and the so-called nocebo effect, which is sort of the opposite of the placebo effect, you'll get a better outcome because it's not about a piece of the pie or getting square with the employer or any of these other kind of peripheral issues. It's about what's going on with this person, how do we help them, how do we get them back on their feet and back into the workforce or whatever participation is needed.
And I think you identify that cohort as being up to 15% of the using the PERS model of whole of person impairment.
I've tolerated the PERS for 25 years. What's another few minutes?
Yeah,
but,
might be a bit longer.
The point I sought to make in the opening statement was that this isn't a uniform cohort. There is a group of very, very injured workers, mainly who I see, police officers, first responders of other stripes. You will see them in other aspects of the workforce, disability care workers, for example, some healthcare workers. That north of 22% category, the rehabilitation prospects are much less. I've had a few successes with some patients who've found work in other fields or, in a far diminished role. But that's been 3 or 4 years down the track. But the group that are in that sort of 0 to 15%, there is significant salvageability if you can get in early and sort the problem out. So if you're talking, for example, about an interpersonal conflict in the workplace or some sort of setback or adversity or affront, if you don't medicalise that, identify what the problem is, have it sorted out by the appropriate HR process or whatever, and then essentially solve the problem at source and have the person go back to work with the expectation of a psychologically safe workplace, the outcome is going to be much better. Where the tricky issue is you will have people who have vulnerabilities to psychiatric disorder because of genetics or developmental trauma. To know which of those workers are going to be the at-risk mental state where a seemingly benign workplace problem precipitates, switches on the epigenetics or whatever it is, that creates a much more severe problem that is, in a sense, more constitutional. And that's really where someone like me, who sees the most severe, maybe 5% of the problem, comes in. So I would need to be able to pick who is going to get into trouble and why, and how do we mitigate that, versus whose problem is best solved by common sense, therapeutic common sense, if you will.
Potentially one of the overlaps is this work capacity assessment.
Yes.
And are there models for work capacity which you use?
I've developed my own, but it sort of suffers the same lack of verification as Dr. Epstein says of the PERS. I do what I call the IKEA test, where it's a thought experiment, gives you some qualitative data. A visit to IKEA is a universally unpleasant experience that most people identify with, and essentially getting through the test being identifying a piece of furniture, finding it, dealing with a busy shop floor, finding a park, a whole array of interpersonal and cognitive tests that, to get through this thing. It then it will identify someone where their interpersonal functioning is the main barrier. It might identify people where their emotional regulation is the problem or their cognitive function. So you might have people say, if you deliver me the thing, I can build it at home, which will tell me, well, that person may have some capacity to work at home. And then I can relate that in the context of that qualitative data so that any reader says, oh yeah, I get that. But if you talk about things like vocational assessments, I've often struggled to see they're actually talking about the same patient. There are these sort of theoretical constructs of what this person might be able to do. For example, I saw a man who actually was a civilian, if you will, 40% WPI, former police officer.
40%?
Yeah, former police officer who then got into trouble with some morally injurious problems in an Aboriginal health corporation. This man lay in urine-soaked sheets all day and had to be brought food and the like. He was probably the unicorn, sort of 31%. I saw a vocational assessment said he could return to work as a university lecturer. Now, there are very few university colleagues of mine that would probably fulfil that descriptor. So sometimes the process of work, vocational assessment is done almost decontextual to the patient. And they'll say, these might be the ideal outcomes, however, his clinical state is that he's not there yet. And then the whole thing just dies.
In the 21 to 31% cohort, using the PERS, imperfect PERS scale, what's your assessment of the capacity of that cohort?
The north of 22%?
North of 22%.
I think the majority would not be capable of more than 1 or 2 days per week of sustained economic participation over the long term. There will be those who, through their own efforts or resilience or like that might find some place at a slightly higher level of participation, but that is a very damaged group who have often had a very long pathway into their psychological injury, and it's more a challenge of care rather than cure. Where I think the opportunity exists is that group where these are otherwise resilient, well put together people with fairly normative life's journeys who encounter some misfortune in the workplace, where inappropriate medicalisation and litigation makes a bad situation much worse. That's where I think...
So that's where the savings to this scheme would be, if in fact you were going to make savings, is not in relation to the 21 to 31% WIPs, but in the 0 to 20%, where there are real expectations with early interventions and a proper return to work strategy.
I don't make comments about savings, Mr. Chair, I just treat the patient, but you would think that...
well, if they got back to work earlier, you would think that would intuitively mean that there would be savings in terms of continuing payments.
Yes, and I think also less morbidity in someone's life.
Yeah.
A minor incident needn't become a major affront in one's life's journey.
Dr. Epstein, in relation to the comparison of the two scales, where does 21% on the PERS scale fit with the GBAC scale? If I'm pronouncing it correctly.
So, 21% on the PERS as opposed to where that would fit on the GEPIC, is that what you're referring? Yeah, well, you'll notice that that's about mid-range in class 3, between 11 to 30%, and class 3 in the GEPIC is 25 to 50%. So we'd probably be looking at something like 35% or thereabouts in the GEPIC, the one we use in Victoria.
Yeah, so if in
that
fact...
would be roughly an equivalent. The problem we have is, and if I can just make this point, the problem we have is that since the GEPIC refers to disability, comparing the two scores is sort of impossible in a sense, because the GEPIC is focused on a person's mental status. Let me just give you an example of that. One of the items that's looked at in that PERS is travel. Now, somebody who's had, or let me just go back a bit, workability is one of the matters that's looked at. Now, somebody who's had a post-traumatic stress disorder may not be able to go back to work as an Uber driver, but if they're working from home, doing, for example, bookkeeping from home, it would be no problem from them at all to do that. So the person's got the same level of problems from the PTSD, but couldn't work in one area, but could work perfectly well in another environment. And that's the difference between disability and impairment. The classic example, of course, is the person who's lost their little finger. That doesn't matter to a labourer, but it matters to a concert pianist.
Yep.
So that difference between impairment and disability, and it's very important, I think. And that's why the GEPIC is intended to be a measure of impairment rather than a measure of disability. Yeah. And that's why it's difficult to compare the two.
Did you have any role in assisting the Victorian government with the design of their scheme?
Well, yes, I was one of the three co-authors
of the
GEPIC.
Of the GEPIC, but in terms of the overall scheme, did you have any role to play in that?
No.
So the actual gateway events which would lead to the compensatable or relevant event for the purposes of being entitled to compensation?
But perhaps it's fair to say I've had some input in as much as wearing a different hat. I'm a member of the American Medical Association subcommittee on workers' compensation.
Yep.
And in that context, I have dialogue with people from WorkCover at Victoria and talk about these issues. And you raised the point about people who are maybe mildly impaired. and because of the delays in getting treatment and so forth, it becomes more and more impossible for them to go back to work. And we're very much of the view that not only should there be much earlier medical intervention or psychological intervention, there also should be some contact with the employer to assist them in arranging for appropriate pathways for that person to return to work. I can just give you an example. I saw somebody who had a psychotic illness in a factory making various products, and he worked in a team, and so he was hallucinating and delusional and sometimes saying very odd things. And so the HR person spent a lot of time getting him back to work and did a terrific job in lots of ways, but nobody had ever talked to his team. So that when he came back, he was still a bit vague and unusual and odd, and they didn't know what to do with him. They didn't know how to deal with him. And because they tended to ignore him and ostracise him, he ceased work soon afterwards.
Yep.
Whereas if they'd brought into the whole process, it's likely he would have stayed there.
So if in fact there was a comparison between the scale adopted, say, in South Australia and Victoria for the purpose of assessing compensatable claims, would you say that that would be a mistake to compare the PIRS with the GWIC?
Yes, I would.
I've got nothing further.
I might just sort of take off from that point then. So we've seen now Treasury documents that were provided to us last week and have now been published online, I understand, where they acknowledge that there are differences between the scales used, the GEPIC and the PIRS. So the GEPIC being used in South Australia and Victoria, and then New South Wales using the PIRS. From the evidence you just gave, Dr. Epstein, you say that a GEPIC of 25 to 50% would be a sort of a class 3, and
that's correct.
And you're saying that that's equivalent, roughly, with all of the riders that you've given, to that sort of 21 to 30% in New South Wales. Was that the evidence that you were giving? So we're looking at potentially almost double.
Yes, what we're looking at with class 3 in a sense is a moderate level of impairment, and class 3 in the PIRS is also regarded as a moderate level of impairment, but of course the percentages are very different. So that class 3 is 25 to 50% in the GEPIC, and in the PIRS it's 11 to 30%.
Right.
So it's like the impression I get is that, I must say, when it was first developed, the impression I got was that people were squeezed below the threshold by which they could make a claim.
So 31% then in New South Wales using the PIRS would take it up into a class 4, which then would be a class 4 under the GEPIC would be a 50% plus. Is that
55%?
55.
55%.
Right. So that is a significant difference then. So when we've had members of the government saying here that this 31% threshold for WPI is effectively the same as in South Australia, that's just not correct then?
Absolutely not correct.
And would it be fair to say then that that would make us the harshest of the states when it comes to the threshold at which people would be cut off?
Yes, about 3 or 4 years ago, I looked at all the jurisdictions in Australia and indeed New Zealand to see how they compared physical injury and mental and behavioural disorders, and it was clear every jurisdiction discriminated against people with mental and behavioural disorders by having much higher thresholds. South Australia would top the list at 30%.
Wow.
For,
yeah, okay.
So, but now New South Wales is going to take the crown.
Yeah, by being almost double, if we allow those reforms to go through. Okay, that's incredibly useful. The other I guess the other part of the reforms, particularly in South Australia, and I'd be interested to know from both of you what your experience might be with what's occurred in Victoria as well, but is in relation to the reforms I understood were undertaken around claims management. And as we know, claims management and the I guess a person's experience within the workers' compensation system can have quite an impact on their ability to get better and return to work. Have you seen any reforms in the other states that have improved that claims management? Has that had any impact on managing claims of a psychological injury?
Well, I've been involved in this whole system since at least 1985. That's quite some time. And during this time, periodically, the measures are brought in to try and improve the return to work rate because it's not great. But for many years, the percentage of mental health claims was only 6% of all claims. In the last 5 or 6 years, it's crept up to about 11 to 15% of all claims for reasons that are unclear. But I might also add that one interesting bit of statistic is that 15 years ago, the number of police officers making a work cover claim dropped by 50% in 1 year. And the reason why is because the superannuation scheme became much more liberal. So people were exiting the police force either through the workers' compensation scheme, but when the superannuation scheme became better, then they exited the work through the superannuation scheme. So that one of the issues, of course, is that what we've noticed more recently is that there's been many more claims with regard to bullying. There's been many more claims that with regard to people feeling that they haven't been dealt with properly in terms of promotions or bonuses and those sorts of issues. Although, in fact, there's a part of the legislation that says you can't make a claim on the basis of that.
Mr. Robertson?
I have nothing to add.
No. Just in terms of, I guess, this concept about the difference between whole person impairment and capacity to work, and the conversation before about, it's contextual. Are you able to give us any insight or additional insight into, I guess, what we could do in New South Wales to improve the ability of people to be sort of contextually put it back into a place of work that is more appropriate for their particular level of impairment? I'm not sure that makes much sense, that question. But if you please, go ahead.
There's two aspects to that, in my view. One is that with small employers, they often don't have the capacity to provide modified duties and reduced hours because it's not possible for them to do that unless they get some support elsewhere. With larger employers, they often have that capacity, but it's often not done, if you like, on the shop floor. It's done through the HR department. And the HR department's working for the employer, not working for the employee often. And that does cause, in my view, that causes problems because people feel like they're being badgered to come back to work when they're not ready. And there seems to be, they seem to be, become into an oppositional situation where they have to, if they often are in a situation where they're told you can only come back to work if you've got a letter from your medical practitioner saying you're fit to return to pre-injury duties. So they sometimes get that because they're desperate to get back to work, but they're not fit, and it doesn't work.
And I guess just anecdotally, I've had people contact my office saying that they're sort of stuck in a bit of a cycle where they are unable to provide a certificate of, and I get this terminology wrong, so correct me if that's right, but a certificate of capacity to work or to return to work, but their employer is yet to provide them with a particular role that is appropriate for them. So they kind of get stuck where they don't have a role that they can go into because they don't have a certificate saying that they can work, but they can't get a certificate saying they can work because no one's been able to identify what the role is that they're going back into. Is that something that exists in the other states as well, or is that a...
Yes, it does. It does. The problem often is that many employers are sceptical about people making mental health claims, and they regard them as rorting the system, which is really a problem. And certainly in some environments, like in the police force, ambulance service and so forth, the ethos is still suck it up. And that also causes problems because people often then keep going until they reach a point where they break down. Whereas if they had earlier intervention and an earlier opportunity to have a break, they would be able to last much longer and be able to recalibrate, if you like, and get back into what they were doing before.
Thank you. Mr. Latham, do you...
Yeah, thank you, Chair. To either of the witnesses, in terms of the extent of the problem with psychological injuries, here in New South Wales, 30% of our corrections officers are on workers' compensation with psychological injury. So this is not just a question of cost containment within the schemes. It goes to the capacity of the New South Wales government to provide frontline services, policing, corrections officers, paramedics, nurses and the like. In your experience, how did we ever get to a situation where 30% of our corrections officers are on PI workers' comp?
I start, Mr. Dr. Epstein. I can work actually from the courtroom backwards in terms of, say, a work injury damages claim for a police officer, and I think the comments can generalise to the frontline workers you're talking about. What we don't do well in any jurisdiction is secondary prevention of psychological injury. The analogy I use is an NRL or AFL player. There's an assumed risk when you play a collision sport and you might get whacked in the head. The duty of care of the code is to make sure that they've got procedures to minimise the effect of the injury, so the 11-day stand-down rule and all those sorts of things that we now see. In several of our first responder organisations and the corrections, we don't do things like trauma preparedness training when they come in. We don't monitor their mental health throughout their service and have processes in place by which we can identify early emergent or signs of emergent psychological injury and appropriate that early intervention I was talking about. We then inappropriately legalise and medicalise their injuries when they do emerge. They get litigated, often in an adversarial way. The sorts of comments that Dr. Epstein made about the culture within various organisations, which I suppose with the New South Wales Police Force goes back to the Rum Corps days. We then exit them with fairly modest payouts, and that's sort of it. They're either on Centrelink or finding their way elsewhere. So I think the opportunity for a flourishing of occupational mental health would be, part of that would be that secondary prevention of psychological injury, so that we don't get to a point where we have a whole lot of severely injured or psychologically injured prison officers, ambulance, paramedics, school teachers and the like. But that's, I think, what is missing in this conversation.
Right, you mentioned screening.
Yeah.
Training at the point of recruitment.
Yes.
What about screening and testing for resilience? Because undoubtedly, as a police officer, they're very pleasant cutting people down from the rafters who've hung themselves, or paramedic pulling dead kids out of a car, or corrections officer, prison guard, having feces thrown at them through the bars and threats to their mother and their cat and their dog and everything else. So, self-evidently, these are socially necessary functions, but also self-evidently they require a certain level of personal resilience. So why aren't we, are we screening for that?
Perhaps if I could comment on that, Mr. Latham.
Yeah.
in Victoria, the very issues you've mentioned have been thought about, and so what's been developed both in the police force and the Victorian Ambulance Service has been peer mentors and who receive training in looking to their colleagues to see the early warnings that people aren't coping, and that they can intervene at a colleague to colleague level without it being tainted by being regarded as psychological or psychiatric or whatever. And my experience has been talking to people in both in the police force and in the ambulance service and fire rescue, because they do some of that work themselves, is that's been a benefit. But you would have known that you hear of a police officer who's seen just one too many deaths, and that was it. And so one of the issues that I'm very concerned about and very interested in is that many people come to me saying they've had a breakdown, and yet I've looked through the medical literature and the term breakdown is virtually not there. And yet it's very clear that people reach a point where their capacity for coping becomes damaged. We give them all sorts of labels: PTSD, major depressive disorder, adjustment disorder with mixed anxiety, depression, a whole variety of labels. But what we often miss in that is that this person's capacity for coping has been damaged, and it's like somebody who's had their leg shot off. They're not going to walk again like they used to. They're permanently damaged.
If I could,
is to try and help them live the best possible life they can, including finding some work for them, helping.
Yeah, well, that's commendable, but why don't we screen for resilience at the point of recruitment?
We do pre-employment screenings in some aspects, but resilience is not a static phenomenon. It's something that you help to build. The Canadians have been quite successful in building resilience in their training. So it's an area of, again, occupational mental health that is underdone, and I think would go a long way to mitigating these injuries. We can't prevent police officers or prison officers from encountering the things that you've described. What we can do is identify their injuries earlier, intervene appropriately, so that when they do end up exiting the police force, there's more salvageability to their work capacity.
Right.
That's always been the kind of taught issue that the services struggle against.
Thank you. Dr. Epstein, the Victorian reforms have been in place for 15 months now. What impact have they had on the number of claims? I saw some lawyers in the papers there complaining that people have been kicked off the scheme. What's the
Yes, that's right. At the end of 130 weeks, in the past, people had to be regarded as not fit to be able to return to work. Now what's going to happen, or now what's happened, is that they also have to reach a threshold of 20% to retain benefits, and they have to reach that threshold of 20% for impairment that's not secondary to physical injury, and I emphasise that. So it's and sorting that out can be quite tricky, but that's the point of it. So, for example, a police officer who's shot at but not wounded may be in a worse situation than a police officer who's wounded and also has PTSD, because they have both of them manifest. So that the threshold for somebody with a physical injury is only 10%.
Right. And what about the number of new claims for psychological injury?
Hasn't changed a lot.
Hasn't changed a lot. Right. And their definitions are tougher than the proposals in this bill.
Sorry, I missed that.
The definitions used in Victoria about psychological injury and entry to the scheme effectively are a lot tougher than the ones proposed in this New South Wales bill.
That's not my understanding.
No? What is your understanding?
My understanding is that people have to be certified by their GP as having a DSM-5 diagnosis. which is not hard to get.
No, not hard to get here either. Okay, thank you.
Thank you. Government questions?
Probably just one question from me, Chair. Just in light of the reservations that have been expressed around the psychiatric impairment rating scale, given it's been used in a compensation context for many years for thousands of workers, has there been much research on the scale at all that you are aware of?
No, there's been none.
One paper published in 2012 by Gordon Davies that tried to compare it to a couple of gold standards, found that it was routinely underscoring people on the first three scores, and it just performed poorly. But it is one of these instruments that lacks any robust validation of its validity or reliability. It's just been something that's been there long enough to essentially have just become the norm, even though it is a much unloved and ugly instrument.
Now, apologies if I've misunderstood or if you've answered this, but in terms of the downstream impacts of using that scale with respect to, I suppose, the number of claims, the costs of claims, the management of claims, what downstream impacts does the use of that scale have, or what are your criticisms of it?
But the introduction to the scale, by my recollection, was in the context of the CTP scheme. It was estimated that about 50% of claims wouldn't reach the threshold with the new scale. That was from one of the authors of the scale, made that statement at a College of Psychiatrists meeting. So essentially it does what it was designed to do. Pushes a lot of people out of the threshold, particularly at the lower end.
Okay.
Keep going.
Any other? No, I think we're done. I think you've answered all of our questions very well. Thank you very much. And again, thank you for your attendance at such short notice. That concludes us for now. I think we'll take a short break until 4:30 p.m.
Okay, thank you.
Thank you. Broadcast on. Thank you. Welcome back. We're now joined by the Treasurer. Treasurer, you do not need to be sworn in as you've sworn an oath to your office, but you are able to give a short opening statement should you choose to.
Thank you, Chair. I would love to. Chair and honourable members of the committee, thank you for the opportunity to appear before this inquiry into the workers' compensation system in New South Wales. To support the committee's work, the government has voluntarily provided hundreds of pages of documentation in response to requests from the inquiry. This material covers scheme performance, financial data, governance arrangements and other key areas of concern. All of them collectively describe the failure of our existing WHS laws, industrial relations laws and our workers' compensation systems to prevent psychological injuries and return those with psychological injuries to their health and to their work. Today I can provide the committee with some further information. It is about the nominal insurer's financial sustainability. I can report that iCare has advised me that the scheme deficit is expected to rise from $4.9 billion at 31 December 2024 to nearly $6 billion in the absence of reform by July 1. The nominal insurer is likely to hold 78 cents in assets for every dollar of future liability, meaning it is plunging further into insolvency at a faster rate. Or, to put it even more simply, the scheme is no longer going backwards by $5 million per day, it is going backwards by more than $6 million every day. As I said to the Law and Justice Committee, you can have the best workers' compensation scheme in the world on paper. If it has no money, it helps no one. The government's reform package makes a decisive shift towards fostering a culture of prevention. Ultimately, the best workers' compensation scheme is one no one ever needs to use. Until that is possible, I again urge Parliament to act to save the scheme we have and fight to stop people from being injured in the first place. I look forward to answering your questions.
Thank you, and we'll start with the opposition.
Thank you, Treasurer. You've had the benefit of a proposal for amendments to the Act which you have.
Sorry, Mr. Tudor.
You have, yeah, that's okay. You've had the benefit of amending provisions which have been submitted to you in relation to changes to the Act which has been submitted to the Parliament.
Which amendments are you referring
The
to?
ones that I have submitted to you.
You and?
Mr. Latham.
And do you have a copy of those amendments?
Do you have a copy?
Not with me, no.
Well, do you recall receiving them?
I do.
Have you costed them?
They are in the process of being modelled.
When will that happen?
I'm advised as soon as possible. We have certainly encouraged iCare to undertake the modelling of your proposed amendments, which I believe are proposed with Mr. Latham, as soon as possible.
In the circumstances, do you accept that the majority of the changes which have been submitted to you by way of amending the bill which is currently before the Parliament provides savings to the scheme, except for the provision relating to the 21 to 31% incapacity?
Do you wish to itemise the particular amendments that you're talking about so I can respond?
No. Do you accept that the...
Well, Mr. Tudor,
it's a yes or no. It's a yes or no proposition. Do you accept that they provide savings to the scheme or not?
I'm sorry, Mr. Tudor. I can't...
Okay. Do you recall receiving a request for particulars in respect of various items from this committee relating to the manner in which the scheme currently operates? And there were 15 specific questions which have been raised.
Sorry, Mr. Tudor. I want to like the opportunity to answer the first question that you didn't give me the opportunity to answer, if you don't mind.
Well, I put to you a proposition that it was either they provide savings or not.
Mr.
Right.
Tudor,
order.
You need to give me the opportunity to respond.
Sorry, order, Treasurer. There have been two sets of questions now asked. If we could have a response on the first set, and then we can talk about the second set.
So, Mr. Tudor, in respect to your first question, which is about the amendments that you've proposed to me with, I believe, Mr. Latham's support, I said, and I've indicated at all points, we are costing them. You asked me whether or not they are going to deliver savings to the scheme. I'm saying that it would be premature for me to answer that in the absence of advice. Can I also say the actual nature of the changes that you and Mr. Latham have proposed resemble, I believe, a Victorian-style approach. But I would simply point out that let the work happen. We will provide the information to you and Mr Latham and to the other committee members if the committee members are interested in the amendments that you are pursuing as well. But at this point, I can't answer your question because I think, in fairness to me, you've provided me these amendments on Sunday. It's now Tuesday. We have been spending our time on Monday making sure that we're in a position to assist this inquiry. We intend to and very much would like to be able to have a fact-based response to your question. But I think to be fair to Treasury, to be fair to iCare, to be fair to CIRA and all the others who are involved in providing you and me with expert advice on those questions, I think it's pretty reasonable that we give them more than 24 hours.
Well, thank you, Treasurer. In respect of the supplementary questions which were asked of you in relation to the bill which arose as a result of the briefing last week.
So when you say supplementary questions, what are you referring to?
Supplementary questions for the Treasurer arising from the briefing given on the Thursday, the 12th of June. Have you seen that document?
I'm aware that a request has come forward and I believe a response is coming forward too.
When?
I believe probably tonight, this afternoon, I suspect.
It was ready last night, wasn't it, Treasurer?
Was it ready last night?
Yes, Treasurer.
Sorry, Mr Tudor, the answers were provided to my office last night. My capacity to then assess them and provide them to you was likely to happen today. I think, again, that's pretty reasonable.
Well, it would have assisted this hearing today, would it not, if the answers were made available, as you undertook to provide in an expeditious manner, if they were available to the committee before we actually started?
Well, Mr Tudor, we've provided this committee with hundreds of pages of documentation. We've responded to your modelling requests. We've responded to the requests of other members. I think it's pretty fair that the government is cooperating with this inquiry. I think it's fair for me to also be sure that if I'm providing the answers to you directly under my name, I think it's pretty reasonable that I have the opportunity to inspect the answers because they are answers to Parliament.
You wouldn't want to be accused
Sorry, Mr Tudor, just let me finish. They are answers to Parliament. I take it seriously. We are providing it to you in an expeditious manner.
And you'd prefer, and it would have been helpful to you accept at least that if we had had those answers today?
I leave it to you to judge what's helpful or not.
Well, do you accept from me then, in the same way as you're doing your duty, it would be helpful for me to do my job if you had provided those answers either...
I can't speak for you.
In the circumstances, as a proposition, do you accept it would have been helpful?
Mr Tudor, I can't speak for you.
I asked you as a proposition, Treasurer.
Well, Mr Tudor, I'm sure that you would prefer the information...
Treasurer, we've heard evidence today that the cohort of people who have a psychiatric injury who are assessed on the PERS scale of between 21 and 31% have no capacity to return to work. Have you been advised of that evidence?
I saw bits of it, but to be fair, Mr Tudor, a proper rendering of that evidence, the parts that I heard as well, is I don't think you're providing a complete summary of all the evidence. I certainly heard the evidence that amongst some that's their conclusion. I've also heard the same people say a conclusion that those people have work capacity. And I also just point out that this particular question was also at the core of what's informed the Royal Australian College of GPs. And I would refer you to what the President of the Royal Australian College of GPs has said. Dr. Hoffman has said that RAGCP endorsed guidelines clinical guidelines for the diagnosis of management of work-related mental health conditions in general practice reflect that an earlier return to work can lead to an earlier recovery. Dr. Hoffman said that this includes patients with severe symptoms, but with less than 30 points of impairment.
Dr. Hoffman hasn't given evidence here today.
I'm also making a point.
Treasurer, I was asking you about the evidence which was provided here today.
Order. I need to hear the point of order.
Chair, I just asked that under the procedural fairness resolution, the Treasurer be permitted to complete his answer, and he hadn't completed his answer.
To the point of order, the Treasurer is trying to introduce into evidence someone who is not available to be cross-examined or at least answer questions in relation to that evidence. What I am asking the Treasurer about is evidence which has been given to this committee.
As always, it is within the Treasurer's right to try and answer the question. However, it is also within the member's right to redirect if they feel that the Treasurer is not being relevant to the question. If we could have a bit more give and take for Hansard, that would be very good.
So as I was saying, Chair...
Just redirecting you to the evidence which was given to this committee today, which you are suggesting was not complete evidence. I refer you to the evidence of Dr. Doug Andrews, who was a witness called at the instigation of a government member who gave evidence that the capacity to return to work for a person in the range of 21 to 31% was 0.
So, firstly, I'm not sure that I would agree that that's the inference that I would draw.
Good, thank you.
Second point I'd make, Mr. Tudor-Hope, to that point, is I think Dr. Andrews and other doctors have made the point, which to be fair, so have you, which is impairment is different from work capacity. And right now, the way in which the two are treated is almost as though they're the same. And I think part of the evidence that we heard just before this inquiry, just literally in the sessions that we were hearing before, is that disentangling impairment from work capacity is a complex task for which medical professionals disagree. So whilst I accept your point, Mr. Tudor-Hope, that you might not weight the evidence of people like the RAGCB,
no, I haven't heard
but I would simply make the point to you that quite clearly medical professionals disagree.
Well,
so how are you expecting a workers' compensation system to have unanimity on that question?
Let me put this to you, Treasurer. If there are people who have no capacity to return to work in the 21 to 31% category, which we have heard today and with which you suggest there might be disagreement, what do you expect to happen to those people?
Can I just say, firstly, you're talking about 21 to 30. Under the Pearce scale, that is classified as moderate. And under the Pearce scale, that is assumed that people have work capacity. The irony is that under the Pearce scale, at 30 is when people, and above, is when people are deemed to have no work capacity.
Well,
and
that's
part
not
of
the
the
evidence
reason,
which we received.
Well, but no, that's not the evidence you've accepted. There's a difference.
It's the evidence we heard.
But again, we're providing you, I'm referring to the documents we've provided this committee as well. And this is the point which I accept where you're coming from, Mr. Tudor-Hope, which is amongst that category of injured people, it's complex. And I accept completely that there is complexity. But your point is that if you're saying that the scale says a person from 20 to 30 has no work capacity, you are not correct. The scale says a person from 20 to 30 under the New South Wales system has got work capacity. But you're quite right to say the manner in which the system currently distinguishes between impairment and work capacity is complex and hard to predict. And that is even more so when it comes to psychological injury, which is the point that I've been making consistently and arguing
No,
for
you
this
haven't,
reform.
Treasurer. But let me just go back to my original question to you.
Can I just complete?
No, Treasurer,
Order,
there's limited time here.
Yeah, and we're waiving government time to give you more time, Mr. Tudor. So if you allow me to complete...
Hasn't been the case today.
Well, we are now.
I think you just heard from the Treasurer that
we're waiving time to give the opposition and crossbench more time. So if you could just allow me to complete on this point. The other point which, Mr. Tudor-Hope, you may wish to recognise is the fact that even over the last 10 years, the number of people who have qualifying as above 15% has tripled. Same scale, same tests. And you are seeing that people who are entering the scheme today are far more likely to be scored at a higher level than they were even yesterday or last year or the year before or the year before that. So
what do you put that down to?
Well, I put that is an interesting question. Which
no, answer.
Yeah, but I'm simply pointing out the facts, and I'm pointing out to you that there has been a continuous increase in the proportion of workers with psychological injuries that reach the 15% threshold across both the NI and the Treasury Managed Fund. And incidentally, over the last 8 years, there is triple the number of workers who have qualifying as above that threshold.
Thanks for the speech, Treasurer, but I have to say, come back to the question, that cohort of people who have no capacity to return to work, what's your view in relation to...
What definition are you applying that?
What is your proposal in relation to those people?
So, Mr. Tudor-Hope,
No, just answer the question,
I'm
Treasurer.
trying to, Mr. Tudor-Hope. The reason why the bill sets the threshold at 31 is because under the scale, that is where people are decided to have no work capacity.
Do you accept that there will be some well, that's not the evidence we've heard, but in any event, in the event that there are people in that 21 to 31% category who have no capacity to return to work, what do you expect to happen to them?
So, at first instance, under this proposal, particularly with the reintroduction of commutations, we are wanting to change the incentives to return to work earlier. The big change that I would nominate in response to your question, Mr. Tudor, between the exposure draft and the bill, is that we absolutely accept that there is a need for there to be commutations reported to the system. What that's likely to do is to encourage a person to get a WPI earlier. That actually means that they're more likely to access treatment earlier. That's also more likely to be on path to return to work earlier. And then ultimately, should they then find themselves in a position in which they choose to want to leave the scheme, they have that right. And can I also make the point that, as has been made by the RAGCP and lots of everybody else, including today, contact with the scheme itself is more likely to compound psychological injury. Often what you are seeing... Sorry, Mr. Tudor, I am answering your question. But Mr. Tudor, what you are seeing
clear
now...
What do you expect to happen to them? Your Treasury secretaries today said that those people will move on to Commonwealth benefits. Do you agree with him or not?
I think people have access to Commonwealth benefits.
Thank you.
Treasurer, what we have heard from the psychiatrists today is that obviously there is a clear difference between impairment as judged on the...
Sorry, Chair, again, I'm struggling to hear you.
That's right. Is that better?
Yes, it is.
We've heard from psychiatrists that there is there's different scales on which a level of impairment gets assessed, and that is different depending on... that is different to capacity to work. And we heard from the previous witnesses that I understand you were listening to, that often it depends on context and depends on other things. But those scales are not necessarily fit for purpose, particularly the PIRS. Given the evidence from the previous witnesses that a 31% PIRS score under your proposals would be equivalent to almost twice the 30% that they have in South Australia. Do you rethink or have any kind of, regret about suggesting the 31% in the first place?
So firstly, I should just say I didn't hear all of the evidence because I heard parts of it, so I just made that point. Secondly, do I have regrets? No. The third issue is when it comes to South Australia. And Chair, I think to be fair to you, we have covered this elsewhere in the House and in the other inquiry, but there's two dimensions about the South Australian experience which are worth pointing out.
Sorry, Treasurer, I don't want to interrupt you. I have limited time. I want to talk just about the WPI, not about the entire South Australian
I am talking
experience.
about specifically about your point.
Okay.
So I accept the point that you're making, which is that they use a different scale. But I also make the point that they also adopt a tighter definition around what's caused by work. And so if you look at the scale in conjunction with the second component, which is the scale tests impairment, the definition tests causation. You have to look at both together, is the first point I'd make. The second point I'd make when it comes to the distinction between the scales is when it comes to the scales distinction as well, they use a whole bunch of different guidelines. And a whole bunch of different assessments. And they are dealing with a different cohort of work too. So I don't necessarily accept the point that the previous experts were making, that the streams are strictly comparable. In fact, some of the early evidence I heard throughout the day from claims managers and all make it very clear that you can't simply apply the same scales between systems.
No, and so let me help you out, because that's not what they said. The previous witnesses... Sorry, you said you didn't hear the previous witnesses.
Chair, but I also would like to complete the answer. As well. The point that I am well and truly aware about with the South Australian Victorian use of GEPIC. Firstly, Victoria's use of GEPICs can't be ignored by the fact that they adopt a very different definition of who can get in the scheme. And so very few people get into the scheme. As a result, very few people even...
Sorry, Treasurer, you are now going off of what my question is about. Can we just be very specific? You have proposed that somebody needs a WPI of 31% before they're entitled to certain entitlements under the scheme, raising it from what we currently have. there has been attempts in the press and in the Parliament to say that this is somehow similar to the 30% that South Australia has. Now, in the documents you provided to this committee last week, there was a briefing paper that set out very clearly that they are not like for like. And we've now heard evidence today from psychiatrists who work in the field that an equivalent in South Australia to a 31% in New South Wales is about 55%, and would make
Chair?
us the harshest jurisdiction in Australia and one of the harshest in the world. Did
Chair?
you know that when you first proposed this?
So, firstly, Chair, I don't accept your characterisation.
Are you a psychiatrist, Treasurer? Or how do you not accept the categorisation when a psychiatrist...
So, Chair, again, I'd like to complete the answer as well. Firstly, I don't accept your characterisation. Secondly, you refer to the documents that we provided you. I'm referring to those documents right now.
Yeah.
Literally from these documents.
Mhm.
We've provided your committee with a whole bunch of evidence that makes the same point that I'm making to you now, which is you're looking at the scale without looking at the way in which South Australia applies it. If you're being fair to the record, you need to look at the complete application of the system. The second issue is, to the extent to which you are making political comments about whether or not I regret it, I don't.
Okay.
For the very simple point that what we are doing here in New South Wales is defining the threshold for people who can't work. How each state resolves who can work and who cannot work is inherently complex. And to be fair to the previous witnesses, that's the point they made. That's just not the point you're making to me.
Okay.
And
We
the
can-
other
we
point
can
I'd simply
disagree
make,
on
Chair,
that.
we are disagreeing. Clearly
Yeah.
we are.
Yeah.
But the other point I would simply make is that if you're looking at impairment
Yeah.
separate from work capacity, what
Yeah.
you're describing, I'm reading from the documents that we provided you, is that each scale is assessed using a class structure.
Mhm.
Class 5 is what's considered to be totally impaired.
Yeah,
Each state does that differently. Fair enough.
Uh-huh.
But equally, if you're fair to the proposal in front of us,
Yeah.
we've also accepted the point that people need to look at whether the peer scales is fit for purpose going forward. In fact, the review mechanism that, frankly, your assistants and other assistants makes it clear that New South Wales does need to look at whether or not these scales are fit for purpose.
Okay,
but
but
this
that's
scale
not part of
has
your
been used
proposal.
since 2002. It's been used since 2002 in New
Yeah.
South Wales. I think you're right. We should, 23
Yeah.
years later, see whether it remains
Okay.
fit for purpose.
But Treasurer-
Should we find ourselves in a position where GEPIC and others are useful to the state in making these decisions, and the
Yeah.
government's totally open from it?
Now,
but no one
Treasurer-
is proposing that we use the GEPIC scale in New South Wales.
No, and yet you've proposed a 31% WPI, which we know is going to cut off 90-something% of people who are currently
That's wrong, Chair.
entitled.
You're now absolutely distorting the data
Okay.
deliberately. You know as well as I do
Right.
that at 130 weeks, 88% of people are back to work with psychological
No,
injury.
I'm talking about the people who are currently... You've told the previous committee there will be 27 people left.
No, I didn't say
Okay.
that at all.
All right.
Again, Chair,
Yeah.
a proper rendering of the record
Mhm.
makes it clear
Right.
that at 130 weeks, 88% of people with psychological injury are already back to work. They're not affected by the test.
Yeah.
As we've repeatedly made clear to this committee in the documents that we provided you,
Mhm.
and to the other committee, and
Yeah.
publicly,
Yeah.
that when it comes to the assessment of people in numeric terms, with the NI, it's roughly 400 people per year out
Yeah.
of 76,000 claims.
Mhm.
And in the
We-
TMF,
Mm.
it is about the same on a smaller cohort. For you to continue to persist in this
No.
argument that 90%, Chair, you are deliberately misleading.
I
And you
take
are deliberately
Treasurer,
misleading.
Treasurer, order. I take objection to that. At no point have I attempted to mislead anybody. I'm talking about the actual statistics that you gave us. I'm not talking about everybody in the scheme. That was never what I said either.
Yeah, but Chair, when
Now, you are
use terms
wasting
like
my
that,
time
when you
in
use terms
answer
like
to
that
my
deliberately-
questions. I would like to ask you one more question before I pass over to Mr. Latham. When you signed the pledge for injured workers that you would actually remove the threshold entirely during the state election, what happened between now and then that you have instead decided to introduce the harshest threshold in the state? In the jurisdictions.
Again, I don't accept the manner in which
No.
you've characterised it. And I accept the fact that you and I just disagree on this issue.
We do, because people will die. Mr. Latham.
Yeah, thanks, Chair, and thanks, Treasurer, for coming along and if I can dial things down, as I tend to do, can I just point out that on the weekend, in a moment of insomnia, I was flicking around Foxtel and I came across the appearance of you and the Premier at the Sydney Business breakfast.
Yes.
And it was a beautiful, heartwarming moment of kumbaya on this particular issue, because you and the Premier said you'd love to have a consensus about these reforms, find bipartisanship with the opposition, and arrive at a position that's good for the economy, good for business, and you're happy to share credit with the opposition to that effect. Is that still your position?
Ideally.
It is. Right. So what response do you make in general, sans modelling data, to the proposals that have been put forward for that kumbaya consensus?
Well, do you wish to spell out the particular proposals you'd like a response to, Mr. Latham?
Yeah, objects of the Act, number one.
Thank you. Again, we'll consider it, but on the terms of the objects of the Act, I do think it's important that we clarify what the objects of the Acts are. Whether these are the right ones is an interesting debate to have in the Parliament.
Well, that doesn't sound like kumbaya to me. Moving on to excessive work demands, you didn't have them in the exposure draft, and it must help in cost containment to take them out now.
Well, to be fair, Mr. Latham, on that point, we responded to specifically the feedback of that committee, the representations, incidentally, of the opposition in that process, but fundamentally to the concerns that have been raised by the nurses and the teachers that we would be extinguishing all forms of redress for people who are exposed to excessive work pressures over time rather than in an acute sense. So I would make the point that I think that we've got the balance right in our Act.
So you're saying there's a cost saving there, but in terms of fairness, you'd rather cut people off at the 31%.
Well, I would simply make the point that I think we got the balance right in our bill, but I accept the point that people are putting forward different suggestions.
And at the briefing we had, your officials said it was helpful to go to the Diagnostic Statistical Manual of Mental Disorders. This is in number 7, meaning of psychological injury. What's your response there?
Well, again, I don't necessarily accept that is what the official said, but I take the point that we are examining that proposal and we'll take a view on it. On the face of it, again, I think a pure application of a manual that is used in other states as a pure transportation into our system may not necessarily achieve the purposes for which it's being put forward.
Well, I sat 2 away from him and he definitely said it'd be helpful. But anyway, items 13, 14 and 15, 14, 15 and 16, you didn't have these in the bill. Why did you accept the Greenwich amendments to remove the retrospectivity in the pipeline, which you had said to me and others was the guts of the...
Firstly, I'm looking at your amendments number 8.
No. 14, 15 and 16, which in the LA were Greenwich amendments 5, 6 and 7.
You don't want to ask me about your suggestions around changing the meanings of racial harassment, meaning of reasonable management action, the vicarious trauma suggestions that you've made, the meaning around changing the definition of sexual harassment?
No, well, as much as I love you, I'm going to ask the questions, not you.
Sure.
I'm taking you to the ones that I see in order of priority from my question.
So in terms of the particular...
14, 15 and 6, I'm seeking kumbaya as per your statements at that breakfast. Whatever they gave you to drink at the breakfast, we need more of it. 14, 15 and 16, which were the Greenwich Amendments 5, 6 and 7. Why did you agree to those when you had said to me and the Honourable Rod Roberts that lowering costs in the pipeline was the core purpose of the bill?
I didn't say that to you, firstly. And secondly, I made it clear both in the inquiry, the previous inquiry, when I was asked by Mr. Tudorhope, I believe. Mr. Tudorhope asked me directly whether or not we intended this to have retrospective effect. I said at the time, it's not intended to have retrospective effect. And what these amendments get to is the complicated class of people which are in the system now but are yet to have a WPI assessment. And that is the complicated part of the savings and transitional model. Insofar as the suggestions that were put forward by Mr. Greenwich on behalf of the crossbench, this was to provide effectively clarity for the cohort of people who are in the system now but are yet to have a WPI.
What proportion is that in the pipeline?
Again, it depends on, we can get you the exact numbers of the people who are likely to be affected by it.
Rough number's good, it's a lot, isn't it?
Well, but it goes back to the principle here, which is we didn't intend this to have retrospective effect. And we weren't planning for it to have retrospective effect. This is to clarify the savings and transitional parts of the bill. You make the point that this wasn't in the exposure draft. To be fair, it's because in the exposure draft it didn't contain the savings and transitional provisions that would be required. These particular amendments were put in place at the suggestion of the crossbench and were acceptable to the government because they provided further clarity around how the system would work. In effect, what these amendments do is that they say for a person who's currently in the system that you have in effect 12 months to get a WPI, which I think is reasonable in the circumstances.
Right. Well, they weren't in the first print of the bill as it went to the LA. That's the point I was making. And what was the costing that was provided on that?
Again, the costings on that is, to be fair, as I think you heard from the actuary this morning, a range was provided. And bear in mind, this goes...
No, he didn't say that. He couldn't remember. He didn't say there was a range. He said he couldn't remember, which I found remarkable. What was the range?
I'll come back to you on that, but just take one step back. The particular point this is getting to is effectively a point-in-time assessment of cost. And this is effectively a one-off cost, benefit or disbenefit, depending on your perspective. It's not a recurrent part. So it doesn't go into the recurrent, for want of a better term, avoided cost. This is simply a transition cost for which the range that was provided to me around that figure was that it was roughly in the range of somewhere between $80 to $150 million from memory.
Right. Okay, coming back to those other ones you mentioned, strengthening the definition on sexual harassment, because obviously it's got to be a prior knowledge of the person who's doing the harassment. Otherwise, under the Broderick-type rules, it brings in everything, steering.
Mr. Tudor-Hope, in your proposal around sexual harassment, my preliminary assessment of it, particularly when you read it in conjunction with your suggested Amendment 12, that is what you're suggesting, Mr. Latham, when it comes to sexual harassment, is, in essence, that it will become the responsibility of a person who is alleging sexual harassment to prove that it was the intent of their perpetrator to do so.
Knowledge.
Well, no. To be fair, you're suggesting... You're suggesting that in this act, sexual harassment in relation... And so is Mr. Tudor-Hope. In this act, sexual harassment in relation to a worker means an act that a person knows or should reasonably know is an unwelcome sexual advance to the worker, or an unwelcome request for the worker to engage in sexual activity, or any other unwelcome conduct of a sexual nature in relation to the worker. You and Mr. Tudor-Hope then propose that your amendment number... 12, that in relation to sexual harassment, racial harassment or bullying, the alleged perpetrator's knowledge and intent is the primary factor in determining whether a relevant event has occurred. What you are suggesting, the way I read that, Mr. Tudor-Hope, is that it's the responsibility of a person who is sexually harassed or racially harassed to prove that it was the intent of the person to do so. And I, on the face of it, see that as, in essence, you're extinguishing those categories as compensable events, which effectively means for a layperson that sexual harassment and racial harassment under your proposals would not be compensable.
No, that's not right.
Well, that's how I look at it.
Well, what about with bullying? Hasn't bullying got to have...
order? Well, I'm simply, sorry, when it comes to bullying. So again, when it comes to bullying, you and Mr. Tudor-Hope are suggesting that bullying in relation to a worker means an individual or a group of individuals repeatedly acting with deliberate intent of harming or intimidating a worker or a group of workers of which the member is a member. In our view, again, that seeks to extinguish bullying and harassment completely from the scheme. Now, I accept the fact that you and Mr. Tudor-Hope are, particularly Mr. Tudor-Hope, is critical of us in respect to the WPI change. But under this model, the WPI change wouldn't matter because no one would get through. And that's the point, which is you're adopting a different approach.
Okay, order. Just FYI, this is now the opposition's time.
I'm happy for until he finishes this.
Just want you to know that, this is the opposition's time.
So but isn't bullying an act of intimidation? You're trying to control someone else in the workplace by bullying them to the point where they're intimidated and they effectively do what you want, or they're passive.
Well, one question
Under
perhaps
your
I have
control.
for you, Mr. Latham, although I accept your point that I'm not here to ask questions, I'm here to answer them.
Fire away, I'd love to answer.
But I take the point that I don't know where you source this definition of bullying from, and I can't see it in any other law that defines it this way. And I'd be interested in if either you or Mr. Tudorhope can clarify where precisely did you get this definition of bullying from?
Well, real life, in that bullying is an act of intimidation, and your low bar definition means that basically anyone could qualify by saying they behaved to me in the workplace in an unreasonable way. I found it unreasonable, therefore I have a bullying claim. So for someone who came into this, breaking an election promise, cutting off at 31% and 2.5 years, there's incumbent upon you to find other realistic fair savings with realistic definitions of what something like bullying is. Bullying is not being unreasonable in the workplace, it's an act of intimidation.
I'd respond
So
to
that's
that in
my
two
answer.
respects, Mr. Latham. The first is I don't accept the way in which you've characterised the bill. And secondly, I would also make the point that if you're putting this forward with an intent that this is to provide a saving compared to the government's proposal, we can respond to that from a modelling perspective as to whether
Thank
it
you.
does or does not. But the other point I just make in respect to this suggestion about adoption of a definition of bullying is that the need for there to be an aligned definition of bullying between WHS law, workers' comp law and IR law is strong. That's where the government sort of has sourced its approach. But I would also make the point that I invite perhaps you and Mr. Tudorhope, if you can suggest to me, if it is the fact that perhaps the two of you have defined bullying this way, then that's fair enough. You are lawmakers. You're entitled to come and say, we are legislators, have come up with a definition ourselves. But that, from what I'm looking, when I look at the suggestion that you've provided, it would effectively render bullying completely non-compensable.
No, that's not true at all. And if you intimidate another worker, of course, that qualifies. But it's got to be intimidation.
But I think the key point of yours, Mr. Latham, that you've put in is deliberate intent.
Yeah.
And so you would be requiring
bullying
establishment a worker to prove that it was the deliberate intent of someone else. And I would simply say that I think our proposal gets the balance right.
Okay, well, your definitions I see as a very low bar. What precedent have you got anywhere in the world that these low bar definitions will reduce claims by 33%?
Well, I'll simply refer you to the advice of the actuaries this morning. I accept you may not accept their advice, but that is the advice that we've received. The other point
But that's not my question. My question is, based on the hypothetical, because you really don't know how it's going to apply, what other jurisdictions have used your low bar definitions and produced 33% reduction in new claims?
Well, I would simply say to that, Mr. Latham, you compare it to the status quo under New South Wales. And I would simply make the point that the definition that's been proposed in the bill is one component of how the bill works. The second component of how the bill works is the speed in which the claims are resolved for bullying and harassment. And I just take one step back. When it comes to the bullying and harassment issue, there are two issues. There's firstly the perception issue, which is dealt with under our bill. That perception question, I heard the evidence that was given on that respect this morning, and that is unique to New South Wales. And I think you heard from the claims managers directly that that's because the way New South Wales law has been interpreted means we're the only state that currently uses perceptions. So to the extent to which you ask me for interstate comparators or other jurisdictions, the reality is that no other jurisdiction has the same problem we have. The second issue that I would say when it comes to bullying and harassment is that the issue is equally interpersonal work conflict, is that they're just harder to resolve because people aren't coming forward with evidence, which is why we responded to the concerns that were in the original proposal that we would have effectively extinguished it by requiring people to go to a tribunal first. And we replaced it with a system that is a definition, an objective standard, but also allows for presumptions to be made. When you look at the totality of those as a solution is the reasons why the actuarialists have concluded that under our system, claims are likely to reduce by 33% compared to the New South Wales status quo.
Can I just ask?
Well, I totally have no faith in that guesstimate, nor the work that was presented earlier in the day by the actuarial estimate expert, so-called. But Mr. Tudor, I'm using his time. He's got a point.
You've told us earlier that there is a difference between...
Sorry, Mr. Chair, again, the microphone.
You've told us earlier that there is a difference between the WPI and a capacity to return to work. Yes?
Yes.
In circumstances where there is no capacity to return to work, what happens in relation to those people who have no capacity to return to work?
Under this scheme, they stay on it. It's just defined at 31, and they qualify for lifetime income benefits and medical benefits.
So if there is a person between 21 and 31 who has no capacity to return to work, what do you say happens to that person?
So again, Mr. Chido, it comes down to when do you define a person who's having no capacity to work?
Correct, but if there is a finding that there is no capacity to return to work for a person...
then they would be... I would assume that they'd be classified as above 31.
Well, that's not the evidence, Treasurer.
But to be
that's
fair
not the evidence, Treasurer.
But to be fair to Mr. Chido, a fair rendering of the evidence is that when you're applying these judgments for psychological injury, it's inherently difficult to assess.
Well, that's the problem, Treasurer. That is the problem. You have, in fact, said that a whole cohort between 21 and 31% have capacity to return to work. The experts say that is not the case.
You're saying...
You're saying...
No, so Mr. Chido. You're saying a person who has no capacity to work. The scale defines that.
I'm not. That's wrong, Treasurer.
Yeah, it's wrong.
Is there any chance we could actually hear an answer here?
But he just verbal me to say that I am saying that. I am saying it's what the experts we heard from today said.
So no, what you heard from today from the experts as I heard it, was that the experts said that the scale is difficult to apply. But the question you put to me is if a person has no work capacity, the inference...
That's what we heard.
Chair, equally... The point is, under the Pearce scale, a person with no work capacity is defined as at 31. In the event that a person is assumed to have no work capacity, and that is that they're totally impaired and cannot work, well, I expect them to stay on the scheme.
Well, and even if they are under 31%.
I think you're asking me what some would describe as a tautology, Mr. Chido, which is under that, if they're under 30%, by definition, they have capacity
That is
to work.
now your interpretation of the Pearce scale, that anyone under 31% has capacity to return to work, which is just contrary to what we have heard today.
I encourage you to read about
what you've heard
scale.
today is quite a lot of dispute amongst the medical profession as to whether the Pearce scale is fit for purpose.
Treasurer, what we've heard today, I would sum up in three ways. Three main things we've got out of today. The $2.5 billion figure that you've been bandying about is actually around $343 million per annum.
Which
we've heard. Sorry, let me finish. We've heard that there's no imminent danger of scheme collapse, despite what has been seen as some sort of hysterical comments in the media. And the third thing we've heard is that, as suspected, the 31% WPI is actually unbearably cruel. And would be almost double what they had in South Australia. Given those three main findings, why do you feel that this is a bill that should be brought back to Parliament before
Chair,
the
I
end
just disagree completely with your question.
Yeah, I'm sure you do.
And I just, and I'd also just make the point that you're entitled to vote against the legislation. And so you vote against the legislation. I accept the point, Chair, that you don't support the legislation. Fair enough. Parliament should vote.
But each of the statements that you have made to support the bill have not been made out. That's why we were having this inquiry. They have not been made out. The $2.5 billion...
Chair, you haven't accepted it. That's different from being whether it's been made out.
Well, that's why we have the evidence. That's why we have
and you're
the
entitled
people
to reach your conclusion and make a vote.
Fine. Well, maybe if you look back on the transcript, particularly around the PIRS, I think that would be quite illustrative.
And also your first part of your question, which was around the $2.5 billion, I don't know what you're referring to.
So the $2.5 billion, apparently that's over 5 years, and the bit that isn't exempt workers is around $343 million. This is the TMF. We're looking at $343 million per annum. Is the amount that you keep saying you have to sort of put in if these reforms don't go through.
So again, Chair, I think that reflects the fact that, I'm sorry to say this, but I don't necessarily accept the fact that you're interpreting that correctly.
Okay,
and
that's what they said this morning.
I would simply make the point that when the budget is released in a week, you will see, the budget will report a $2.6 billion deterioration in the last 6 months to the TMF, caused by workers' comp.
caused by workers' comp, by you not putting enough
No,
into workers' comp to cover your own liabilities for your employees?
Chair, you don't understand. I'm sorry to say this, but you just aren't understanding the way.
Do you understand? Because you've referred to it as a bailout. How do
Chair,
you bail out workers'
confusing-
comp?
You're confusing the cash side of the budget with the actuarial, with the accrual side of the budget.
In the documents you gave us, you talk about bailing out the TMF,
Yes,
which
they're
isn't a
separate
thing.
questions,
That's not a
Chair.
thing that,
Look,
that
Chair,
can
do you
occur.
have by any chance the IK annual reports with you?
I probably do, actually.
Let me get them for you. This is relatively straightforward. If you were to look at...
You say it's relatively straightforward, but then in your Treasury
I'm
documents
sorry,
you talk
but
about
I'm-
bailing out the TMF,
but
which
Chair,
is not a thing that
again-
happens.
Again, if you were to turn to the scheme, if you have by any chance the report, and I'm speaking specifically at the Insurance for New South Wales annual report, which
What is the point you want to make, Treasurer?
you will see that actually that what you're referring to is what's referred to as a grant from the Crown. It's on page 115.
No, I'm
That is
actually referring
separate
to
from
your
the $2.5 billion line that will be reported on the
Yeah.
accrual side of the budget.
I
They are
do
two
fully understand
separate
how
concepts.
that works, as I'm sure you
So
understand.
to the extent to which you confuse them, you're either doing, if you say that you fully
I'm not
understand it, Chair,
confusing
the
it.
logical inference is that you are therefore deliberately doing so.
No,
You
I'm
are,
not
I would
confusing
simply
it.
say,
I'm talking
Chair,
about
that you
what
are
you have
incorrect.
oh my goodness.
People are going to die
You
from
are
this.
incorrect.
This is impacting people's lives.
Chair.
Okay,
Chair, I
order.
actually call
There'll
the
be
audience to
yes,
order.
there will be no interjections. The Treasury Managed Fund would also be in trouble if it was not getting bailed out.
So,
this
Chair,
is your document.
Yes, but you're confusing that with the 2.5 billion.
No,
I'm
I'm
sorry,
asking
but they
no,
are
as a
separate concepts.
as a separate question. I was talking about this concept of you bailing out. What is this bailing out?
No, you're confusing. You didn't. That wasn't the concept you were referring
What
to.
is this-
The
what-
concept you were referring to is. Was
Are you
the
going to answer the
343
question? You
per
referred
annum.
in your documents to bailing out.
Which particular document are you referring to there, Chair?
This is the presentation that you gave us last week.
Which
you
page
refer
of the
in
Treasury
there,
Fund?
misleadingly, to bailing out the Treasury Managed Fund. Now, you've just tried to give me a lecture on
Sorry,
what
which-
happens
which
within
Chair-
iCare.
Sorry, I'm just going to. If you can give me 5 seconds, I'll find the document and then I can respond to
Yeah,
you directly.
bailed out.
The Treasury slides. And what page number are you specifically referring to on that doc?
So this one is page 6. It's just one example of the misleading language that's being used by your government when it comes to the way it talks about the TMF.
Page 6. The Treasury Managed Fund would also be in trouble if it wasn't being bailed out.
Bailed out.
Yes.
What do you mean there?
So the government has provided $6.1 billion in top-up payments over the 6 years to 23-24 to keep the TMF funding ratio above 105.
What
That's
is that
correct.
bailed out?
That is the injections that have been required.
From?
And that's not the $2.5 billion figure
No,
you're referring
what
to.
is it?
What do you mean, Chair?
What is the bailed out amount? What are you talking about? You're talking about amounts to cover your own liabilities?
So no, that is under the policy that I inherited from Mr. Tudor-Hope's government, which
So
was
that's the amount that
sorry,
tops
Chair,
it up
if
to
you
get
could
over
Sorry,
the
Chair,
105?
just on behalf of the Hansard.
You are correct. I uphold the point of order.
So under the previous net asset holding policy,
Mhm.
in order to maintain a funding ratio of 105%, this is the amount that's been required.
Okay, that amount, as you know, covers workers' comp and general lines.
Yes.
Again, how is it a bailout when you are just paying for your own liabilities as a government to your workers and under your insurance policies?
So if you refer to the iCare annual report...
Was it a mistake to say bailed
No,
out?
it wasn't. And can I just refer you to the iCare annual financial statements? And I'm referring here specifically to the financial statements at 30 June 2024. And I'm referring specifically to page 123 and 2.
Did they use the word bailout?
2. And Chair, you will see that the general lines gross claims rose in the 12 months prior from 2023 to 2024 on an undiscounted basis. It rose by approximately $115-ish million. In fact, even that might be, yep, that's about right. If you go to the earlier page, you will see that the same aspect with the TMF for workers' comp rose by 500.
How is that
So I
related
would
to
simply make the
bailout?
point, Chair, that you, to the extent to which you try to ascribe persistently that the issues with the TMF are caused by general lines.
No, that is not what I said. You've just decided that's what I've said.
I'm
asking you about a question here. You keep throwing figures around, it's all very Chicken Little, about how disastrous things are going to be after 1 July unless we pass your reforms. And you continue to conflate the TMF and the NI, you continue to conflate the general lines and the workers' comp side in all of the media, in all of the presentations. You've now used the word bailout in something you've given to this committee, which you know full well is not a thing the government does.
Chair,
I'm asking you just to admit that you got it wrong.
Nope.
Okay.
And I'm sorry, Chair, but on this point, I'd also make the point that the opportunity cost of continually to bailing out the TMF is
bailing
huge.
out. You would not have said that 3 years ago.
Huge.
All right.
Absolutely huge. And Chair, the point that you perhaps I would encourage the committee to consider
Government paying its
is
premiums
that
is not a bailout.
having to bail out the TMF
Pay
every
its
time
premiums.
comes at a huge opportunity cost. But equally, it's not effective. The issue that I also have with the TMF and I have with the NI scheme is that they're not returning people to work.
When I pay my
And I would
insurance premiums,
simply
I'm not
say,
bailing
Chair,
out
sorry,
the
if you
insurance
let me
company.
finish. Chair, I would also make the point that it's not a good use of public money. And I would also make the point there's lots of other better uses of public money when it comes to this as well.
Ms. Latham, did you, or Ms. Tudor, did you have
Treasurer,
any last?
your position fundamentally is if you cut off people's benefits, they go back to work. Isn't that the case?
Nope. My fundamental position is the entire system needs to be built around returning people to work.
A component of this scheme is predicated
off
on
and
the
killing
idea
workers.
if we cut off the benefits, they will go back to work.
Nope. I would make the point that the entire part of the package is to incentivise prevention. And the part that is attracting controversy is different from the entire package.
Well,
the part that is not attracting controversy, and to be fair, Mr. Tudor, it's because we agree, is that we do need to shift to prevention. And the fact that I've accompanied these reforms with, as the government has, with a $343 million investment in prevention, and the fact that equally on that, the
please don't
Parliament
make a
has
speech.
the opportunity to
Treasurer,
also establish a bullying and harassment
Treasurer,
jurisdiction would help.
have you ever said that part of the strategy around this bill is that if you get people off benefits, they go back to work? Have you ever said that?
I'm responding. Sorry.
Have you ever said that? Is that as a proposition?
Well, I've been speaking about this reform for more than
Have
6
you
months
ever-
now.
Sorry, point of order, Chair.
Oh, not 6 months.
Oh, hear the point of order.
Sorry. Firstly, courtesy to the witness under the procedural fairness resolution. Secondly, the government has said its time with respect
Yes.
to questioning. And thirdly, the Treasurer is here longer than
Yes.
he was anticipating to be here. So I think there's been ample time for members to ask
I
questions.
actually have to go, believe it or not.
Okay.
Well,
Just
I'll
finally, do you
just
think
finish.
the Premier still believes in Kumbaya with us and wants to commune and get a consensus, or are you the only one fired up?
No, I think that the government would always like to see this problem solved.
Can I just ask one too? There's a provision in the bill which in fact delivers or requires the insurer to, in fact, accept liability in relation to or reject liability within 6 weeks. Was that ever canvassed with the business community, that proposal?
But I believe it was. I believe the business community has some concerns about that as to whether or not that period is too short. As well, I think it's an interesting question as to see whether or not we got the balance right on that one.
Okay. I think we all need a bit of Valium and a lie down or something now. Thank you. Thank you very much for your attendance. To the extent that there were questions taken on notice, Secretariat will be in touch. But that concludes our session with you. Thank you.
Chair.
Well, you didn't have much worry about
I'm
looking forward to our last week.
We now turn to what I hope will be a calmer session. Thank you very much to our next witnesses. If I could ask each of you to please state your name, position, title, and then swear either the oath or the affirmation. And I'll start with the witness on my left.
That'll be me?
Yes.
My name is Tim Wedlock. I'm representing NEBA today. I solemnly and sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. Thank you.
Thank you.
My name is Rebecca Wilson. I'm the Vice President of the National Insurance Brokers Association. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you.
Richard Clippen, Chief Executive Officer of NEBA. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you, and thank you for making yourselves available at such short notice. Insurance brokers are not a part of the scheme we hear from very much, so it's very, very useful to have you here today. Would you like to begin with a short opening statement?
For sure. Big thank you to the committee for inviting us. A really important topic. I'll just share with you a very brief opening statement, Chair. Thank you, Chair. We appear before you today on behalf of NEBA, the peak body for general insurance brokers. NEBA represents approximately 420 firms with about 15,000 individual brokers, including large multinational organisations, national broker networks and small to medium businesses operating in metropolitan and regional communities across the country. Joining me today, as you've heard, is Rebecca Wilson as Vice President and Tim Wedlock, former National President. Both are highly experienced insurance professionals. They're successful business owners and they have over 65 years of combined experience supporting clients in the insurance sector, including in workers' comp. Their work assisting clients through the complexities of the New South Wales Workers' Compensation Scheme will provide a real-world insight into this inquiry. NEBA welcomes this inquiry and commends the government and the committee for their willingness to engage with these complex yet crucial issues. As trusted advisors to employers across the broad range of industries in New South Wales, insurance brokers have direct insight into how the scheme actually works and supports injured workers, employers and the broader economy. NEBA shares the government's concern about the current financial and operational challenges facing the scheme. The scheme's financial position has deteriorated sharply, raising concerns about the long-term stability of the scheme and its ability to meet future obligations. At the same time, employers are experiencing substantive and substantial premium increases, and whilst the average annual increase is approximately 8%, some sectors have been affected far more significantly. These increases place pressure on organisations providing essential community services and have broader economic implications. We acknowledge that the bill before Parliament aims to address the rising incidence of psych injuries and claims, and we support measures that strengthen early intervention and support for injured workers. However, we believe the proposed legislative changes are unlikely to resolve the broader financial and structural pressures facing the scheme. Return to work outcomes are a critical area of concern. Despite various initiatives to improve results, the scheme's performance in this area is trending in the wrong direction. These trends highlight the need for a renewed focus on early intervention, care coordination and effective case management. We also note concerns within the business community about the management of claims that might not have a clear causal connection to the workplace. This is a very complex area and one that requires balanced oversight to ensure fairness, consistency and sustainability. In light of these challenges, NEBA encourages the New South Wales Government to consider further reforms to strengthen the governance and oversight of the scheme. This should include a review of the regulatory framework with a focus on transparency, accountability and improved outcomes for injured workers. We share the committee's commitment to sustainable, fair and effective workers' compensation scheme, and we welcome the opportunity to contribute to this important discussion. Thank you for your time and we look forward to your questions.
Thank you very much, and we'll start with the opposition.
This will be a lot more pleasant, I'm sure, than that previous session. When was NEBA, or was NEBA, ever consulted in relation to input in respect of proposed amendments to the Workers' Compensation Scheme?
No. No is a short answer to that.
Yep.
So if I can add, with Mr Wedlock and I, we've been involved with iCare for the last 10 years. As NEBA, we have caught up with with iCare and CIRA on a regular basis for at least the past 8 years combined. We're always giving feedback to both organisations, albeit the meetings have always been separate, which we have, and would prefer to have a CIRA, NEBA, iCare meeting so that all information is in the same room. Unfortunately, we haven't been able to achieve that. But as far as this legislative change has come about, we were actually in a meeting with CIRA 2 days beforehand, and they then advised us that there were changes but didn't give us a lot of information. Hence, we did put in a submission, albeit it was late. It was in the time frame, but it was at the very depth of the time frame that we got that in.
Given what's occurred in relation to this bill, are there things that you would have preferred to have seen in this bill which would have improved the outcome for workers and potentially reduced costs to the scheme?
I think if we take a step back to the 8 years of communication that we've had with both CIRA and iCare, there's not just changes within the bill, there is changes within the performance of the scheme. And these are actual tangible changes, not just it'd be nice to do this. At the moment, my personal view is we're talking a lot about the budget and we're talking a lot about the financial consequence. However, the real consequence is how the scheme truly operates.
Take us through some of the practical things that you would say could have been adopted and which would in fact improved potentially preventative measures available in relation to the scheme and potentially improved the cost impact on the scheme.
I think to begin with, certainly the acceptance of claims. The culture within each organisation is that the scheme is a no-fault scheme. That is said on a regular basis. Well, at times injury and psychological injury are at fault or maybe have not existed at all. But because it's been no at fault, my observations are that it's a culture that we support any claim that is actually received by iCare or one of its agents. The second part is the CSP performance of having autonomy and accountability and authority to actually apply Section 11A. So it's seen firsthand by myself where agents are in front of a client, so an employer, and have said there's no point in us applying Section 11A, it will never get passed. So
even in circumstances where there is a potential serious factual issue relating to the circumstances of the claim?
Absolutely.
And
absolutely.
Is that a regular event which your clients identified to you where there are factual issues relating to the claim but they don't bother pursuing them because they are just never successful?
Look, I think there's 2 points to this. We're here obviously as insurance brokers, and Tim, it was something that you raised with me before. If you look at the employers that are in the scheme, approximately, and don't quote me, I will take notice on this number, approximately 50% of employers are with brokers and approximately 50% are without brokers. So the ones without a broker probably don't even know that 11A exists, and that's an assumption on my part. And those that do have a broker, the brokers are going in representing 11A, but we haven't had a lot of success.
One of the things that we have been dealing with today is in relation to the manner in which claims managers handle these schemes, handle claims. What suggestions would you make in relation to the relationship between claims managers and employers and employees potentially in respect of how claims are being managed?
Do you want to take that?
Yeah, certainly. Thanks, Minister. That's a very difficult one to answer because a lot of the claims management have been left to those insurers allocated to manage the claims, and a lot of the people that they've allocated the control of that claims management to are very young or inexperienced, because when the change happened to iCare and then all the changes that they've since made to try and improve the scheme haven't worked, a lot of the major insurers like CGU that were involved, QBE who are still involved, a lot of those employees left. So the people that have been left in charge of managing the case management on behalf of the scheme directly with employers are out of their depth, and then they're relying on iCare to come back and help them, and they're scared to make decisions that might be the right decision for the injured employee or the company to mitigate and to support those that need the scheme. That's my take on it. It's they just don't have the ability to. Well, there's not the people out there to be managing these claims the right way. And I think the other thing that, as a result of that, is that claims are being pushed through very easily without any denial whatsoever, and they're just feeding off each other.
So do you have much of a relationship as brokers? Do brokers have much of a relationship with claims managers on behalf of the clients that you look after, or the employer clients that you look after?
For those of us that are heavily involved in workers' compensation, that's part of the fundamental point of difference we try to add as value, and that is to try and align ourselves with case managers that work for the various service providers to make sure we can help them. And as Rebecca said, if you look at the larger employers that are using a broker to help them, the reason they want to do that is because they're very focused on risk management, injury prevention, everything they can potentially do to make a safer work environment. And it doesn't just sit on workers' comp. That could be to do with their general running of their business as well, to keep costs down. When it comes to the case managers, you could find a good one, but then they can only do so much before they're overloaded. And so then the claims service providers have to split that work up and try to find other people. Some will not allocate one person to one employer. So one employer might end up having 3 or 4 different case managers trying to run their workers' comp program, getting 3 or 4 different opinions every time there's an incident.
Well, that's an administrative matter which potentially iCare should fix. Let me ask you this: there, in respect of circumstances which are not covered by compensation or workers' compensation, it may expose potentially directors or employers to circumstances where they would be exposed to PI claims, might they not?
Minister, potentially more so directors and officers claims. So yes, we could potentially see employers that may have an employment practice claim due to, let's use bullying and harassment as a pure example. I feel, and I say this as a feeling only and a view only, if that was to occur, the directors and officers insurers would withdraw cover like they did with WHS harmonisation. So it could very well be that employers will be left without
cover
any protections.
Well, we heard from Mr. Garling already earlier today that there are already in the system, outside of the workers' compensation scheme, claims being made for negligence relating to the performance or the creation of workplace environments. In those circumstances, are those clients, or potentially clients of yours, exposed to additional insurance risks, either for which they are insured or aren't insured at the moment?
Potentially, yes, Minister. Yes.
And what would be the cost potentially of one of those insurance policies?
Well, that would be a question for the lawyers, because it would either depend on whether the insurer chooses to settle to save on costs. So a lot of the times you see employment practice claims and they come through. The biggest cost on employment practice claims is usually the defence costs. So it's usually
which costs?
Defence costs, so engaging lawyers.
Yes.
So a lot of the time it's commercially settled.
Yep.
But it doesn't remove the problem that we have here. The problem that we have in the workers' comp system is that if you put in a claim, it's generally taking up to 13 weeks for any determination to be made. Then for the first 6 months, an injured worker is paid 95% of their pay. After 6 months, for a period of up to 2.5 or 5 years, they get 80% of their pay. Now, we talk about return to work. iCare and its agents talk about recovery at work. From day one, they're saying, we need to get you to recover at work. From day one, they're saying something's wrong that requires recovery. It should be returned to work. And if you have a psychological injury, and I'm saying this for those that may not fit in the category of a true serious psychological injury, but one where you're not feeling great, if you're getting paid 80% of your pay to sit at home for 5 years without your cost of transport, without your cost of lunch and all the expenses that go with going to work, why wouldn't you? Do you want to go first? My mind's a blank.
Can I ask? So you've had experience in this system in New South Wales for many years. What is your opinion of the way in which the claims managers have been appointed by iCare and how that's working? Is there competition? Like, did it create some sort of great competition between these different claims managers? Has it had a better impact?
Chair, as I said before, I don't think there's been a great deal of improvement, which is a really sad thing to say. They've all got the right intention, and if you speak to them, they're under their own duress as well. If you speak to the claim service managers and you speak to the people in management positions about how they're trying to find staff and how their staff are dealing with the ongoing frustrations of brokers or direct clients dealing with them because they're frustrated they're not getting the right results, they're under just as much pressure, I think you will find, as we are acting on behalf of people trying to get a right outcome. What is the solution to that? That's a $1 million question. And I think it all comes back to the management of the scheme through my eyes. I'm glad we're sitting here talking about it. The site component is, again, just a piece. The whole scheme, through my eyes, is absolutely going the wrong way. And if it continues going the way it is, there'll be more than what was discussed in the previous session to bail it out. And it's not healthy because a lot of employers are shutting their doors because they can't afford to stay in business either. And it's not healthy for those genuine people that get injured and are looking for a scheme that's actually meant to be there for them versus those, and not just the employees, I'm talking about, unfortunately, doctors, psychologists, everyone else that's on the gravy train, clipping the ticket because the scheme allows them to do so unfairly.
Another part of the scheme that we sort of hear tangentially about, and I must admit I'm not as familiar with, is the rehabilitation people who are brought in. Is that what they're called, rehabilitation managers? What's their role? And I understand they're mostly sort of private entities as well. Are there problems with the way that they are sort of operating in the system?
Chair, I would say they have a lot of referrals. I think true referrals where it's required is very beneficial. But my instinct and my observations of what I've seen is there's potentially more referrals that are going that may not need to go to rehab providers, and obviously where rehab providers will play a part in that recovery / return to work. We couldn't do it without them, and the scheme couldn't do it without them. But I do think, again, re-looking at the scheme, there could be other solutions around, going straight back to what I said before around autonomy and authority. So case managers are terrified of declining a claim. So they'll pass that on to a rehab provider to say, well, what do you think? And I heard in evidence this morning we're talking about independent medical consultants. Independent medical consultants can give their view on the treatment, but they can't give their view on liability. And so this is where we've got the IMEs can, the independent medical evaluators can, but the consultants can't. The rehab can tell the insurers what their thoughts are on the injured worker, but the buck really stops with the agent as to who and when they accept a claim. Most claims will go to the death of 12 to 13 weeks. We very, very rarely see a decision within the first 7 days. So even with this new bill and going, we're going to reduce the 13 weeks, I think it was to 8 weeks, they can't even get it done in 13 weeks. So I don't quite understand how that can potentially work.
But Chair, can I just also add to that? New South Wales is a fair-sized state. So the other challenge that we find is, are these claims regionally based or are they metropolitan based? And there's a lot of great rehab providers out there, but sometimes we would need to, the one that an employer might use metropolitan-wise may not be the right ones for regional areas where there's better people suited for them. So there's a lot of consideration there that we have to look for to give the people the support.
And is there I guess, some sort of, maybe not a conflict of interest, but is there a problem with those rehab providers being employed by the insurer or acting for the insurer, but this idea that, and again, I'm sort of going off of anecdotal evidence where people have contacted my office saying that they've had real problems with these rehab providers who appear to be almost keeping an eye on them or surveilling them as opposed to helping them to get back to work. Is that a product of them being employed by the insurer? Is there an alternative where we could, look at the scheme?
I reckon you could say yes and no, depending on who they are. It's the same for the doctors, and also, like, why is it when you have a claim for somebody falling down some stairs, genuinely injuring their leg, and they've got to be off work until that's fixed, and then before they go to work, the doctor refers them to a psychologist just to make sure that everything's okay before they go to work. Then they find out that they can stay at home for another length of time because we've all got to wait for the psychologist. I mean, in a perfect world, that just wouldn't happen. And it's the same as the rehab providers. If they're genuine, working with the right spirit in what we're trying to achieve, you just wouldn't have a problem with them because everyone would be working together. A lot of large employers will actually employ the rehab provider themselves and ask the claim service provider or iCare if they will allow, because that's another thing they changed without consultation, like legal panels. A lot of people had their own solicitors, but all of a sudden a new panel was thrown out there without any consultation whatsoever, which upset people because these solicitors were on their side trying to get the best outcome for them and their own employees. So there are so many fundamental flaws from what we've seen over our journey that could have been fixed, which we've expressed, and could still be fixed to make a better scheme.
Chair, if I could please just add, the messaging that we really wanted to deliver to you today is that this is not just about psychological claims.
Yeah.
This is about case management, and I'm happy to share some information that we have here, but we put together between Tim's business and my business 5 claims that I think 3 were physical, 2 were psychological. They were all claims that should not have been accepted. And I'm very clear on saying I know which ones should be accepted and shouldn't be accepted. Those 5 claims alone cost the scheme $1 million. Just 5.
That's really useful. Thank you, Mr.
Yeah, thanks. The 2 psychological injury ones, why shouldn't they have been accepted?
But,
Minister Latham, I'll give you the one example. We had a truck driver. He had a genuine accident where he ran in the back of a car in front of him and the steering wheel hit him in the stomach area. Now, as a result of that, he had to have some medical treatment done, and under a normal course of a workers' compensation claim, that would have been maybe 6 or 7 weeks, maybe 8 weeks getting himself sorted out, and then that was it. When they went in to do the operation, they discovered this employee had cancer. So as a result of the cancer, that was obviously going to prolong treatment, so they had to put a colostomy bag on the person to help work out what they were going to do. Then there was some discussion that as a result of the truck accident, he's now got psychological nightmares and he'll never be able to return to work again. So 3 years later, the claim's still going. What should have been a 6 or 7 week, if the cancer wasn't diagnosed, if he hadn't had the accident, this fellow would be dead from his cancer. So the workers' comp actually saved his life, but as a result of that determination, he's now fleecing the system, sorry to say, in our eyes, because that should have been shut down and that should have been treated as a separate issue altogether. That's just an example.
Right, yeah, a normal person would have said silver lining if I didn't have the accident.
Correct.
I wouldn't have found out about the cancer, I'd be dead.
And
instead,
yeah.
Right. Yeah, well, I think this is the issue for employers. The contact I've had with people like Clubs New South Wales and other employers is the thing that really, really gets their goat, and you've just given one example of the joke claims, the ones that defy common sense, practical reality. Like Clubs New South Wales said there was a woman working for a club up on the mid-north coast and she couldn't get to the training day and claimed that it was a deliberate act of the club to bully her, to put a training day on when she couldn't attend, and she got a WPI of 24%, a $400,000 payout, because she said it was unreasonable and it constituted bullying. So my question is, don't we have to have some realistic definitions at entry point as to what is a psychological injury? Things like anxiety are properly defined and screened out as much as possible, and things like bullying, harassment need a realistic, real-life definition, not what, sorry to introduce politics, but over the last 20 years, the woke definitions of everyone, you know, being a victim of everything has led to this particular problem. Don't we need some definitions that match up to real life, like the example you just gave?
We absolutely do. If you look in the Comcare system with psychological claims, psychological claims or serious psychological claims need to have a psychometric test to back it up. There is also technology out there to back up psychological illness. And when did it occur? Because I could have a psychological illness from when I was 12, and if my boss tells me I'm not doing a great job at 47, is that because I've had anxiety all my life or because I'm doing a crappy job? So you've got to look at the proximate cause of injury. That's what we need to look at. But I would rather see true injured workers and true psychological injuries managed properly and with a lot of care, regardless of what percentage it is, how it impacts an injured worker's life, and ask for forgiveness if the case manager gets it wrong with the others. But at the moment,
I couldn't agree more.
I
think
around.
The joke claims, and in particular the medical fraud, is damaging genuine psychological injury claims, and we'll get to the point eventually where it starts to hurt physical injury claims that are verifiable. So what do we do about the medical profession? I had a matter yesterday, and sometimes you just think you're on another planet listening to this stuff, where there's a psych who's testified a member of this parliament is like a hermit, psychologically damaged, can't do anything. The member, in fact, is more active and has more meetings with the Premier than Mrs Minns. And there's a total disconnect between the psych assessment and this guy's real life. So the fraud from these psychologists is off the radar on the basis of, I'm sure this psych, if she says, no, you're okay, wake up to yourself, she loses the counselling income from her diagnosis, and even worse for them, words out on the street, she's no good for getting certification, I better go to someone else. So, and that's what happens. So haven't we got to clean out the medical fraud as a first step?
You know, Minister, absolutely. I mean, when iCare, this was a proposal I believe iCare looked to try and introduce about 4 or 5 years ago. They were going to do a computer system back-end that would help manage a lot of the claims process, which identified all of the practitioners, doctors, psychs, you name it, involved. And it would have been a lot easier for them to then internally track trends. Because what's the first question on a medical certificate when you go to see? Is this workers' compensation? Like, it's just, you're right. If you had an answer to that, or if iCare could come up with an answer to that, rather than increasing the limit on just psych, I think everyone would be in a better position.
Have you got submissions on this? We're probably going to have a longer inquiry and take some submissions.
Yes.
You've got written material?
Yes, we do.
We'd like to look at that. I think what you've had to say here is probably the best thing I've heard all day, albeit when, you know, it's dark outside and people are going home. So sorry it's late in the day, but
okay.
It's been refreshing what you've had to say and very, very useful. Thank you.
Thank you. Appreciate it.
Government questions.
I've probably only got one question in addition to what
Practical
has already been
real
asked,
life.
but just with respect to the nominal insurer, it clearly doesn't hold sufficient capital to meet the estimated present value of its future obligations. Treasury's projected that the premiums would need to increase by 32% over the next few years in order to have sufficient capital to meet those future liabilities. We've heard evidence today that an increase of that nature should be and can be absorbed by business. Is that a view you share?
Minister, at a moment, like you talk about an average 8% increase. I don't believe you'll see more businesses go out of business because of the way I don't know if you're aware of how the actual New South Wales scheme is, how the mechanics of the premium calculations work. But firstly, if you have a employment wages versus a whatever the WIC code is, and the base premium is less than $30,000, so it might be only 6 or 8 employees, there is no capping or no restriction on the amount of workers' compensation claims that business can put in, because it will not impact their premium. It'll still be $30,000. So, you know, if I was doing an internal review, the first thing I'd be wanting to know is how many of the claims that are lodged within the scheme fall within that band of non-premium impacting component, because if a lot of it is in there, then there should be a big review on what that minimum premium should be or how that's looked at. If you then look at all of the claims managed premiums, there is a scheme performance measure which is very low. They want the scheme to run at 4.3%. So if you flip it, that's a business running at 95% return. And if it doesn't, the way that the rates penalise business at the moment for just the smallest of claims is massive. Correct. So if you were to turn around and try and recoup that over the next number of years, you'll see more and more businesses going out of business, or businesses trying other ways to try and prevent claims going into the system, because it's just not working.
May I add to that, please? Just in relation to what Tim said, there's absolutely an issue with employers not being able to afford the premium and going out the door. But there is a second issue that the scheme may have, or is having at the moment, and that's the loss prevention recovery model, which is known as LPR. So LPR is more of a self-insured model where an employer has to put up a bond, and if they perform well, then they will save on premium. To put it as an example, I have a client in Tamworth, not-for-profit organisation that cares for people with disability services. We put them in the LPR model. We said, you're going to have to make a huge investment to make sure that your case management and your return to work is right. You need to invest in having return to work coordinators. At the moment, you've got 2, you need 6. And they said, okay, well, what will we need to do that? And he said, I beg your pardon, what will we save to do that? I said, your premium will go from 9 million to 1.5. Well, of course, I'm going to invest in 6 recovery at work coordinators. But the point being here, you'll have good performers that will go into LPR because they'll save $7.5 million. Why wouldn't you? You'll have employers that will go out of business, and then you'll have a scheme that's left with the rest. And regardless of whether that premium goes up, the problem is case management.
It's the acceptance of claims, back to the whole range of who's involved, that is going to be more important than trying to put premiums up every year. That will not fix the problem.
I think I might get a T-shirt. Problem is case management. Thank you for that.
Well, you could have the I love neighbour
and when
if
we
you
say
wanted.
case management, let's be clear to the case managers out there. It's also the fact that they are scared sometimes to make decisions that iCare may not support. And then if that happens, they may no longer be on their panel. So the whole thing needs a proper review for the right reasons.
Yeah. Thank you. It's been very useful. I've learnt a little bit more about the system today. I hadn't picked up on the insurance broker a bit before, so thank you very much for coming along at short notice. That does conclude our hearing for today. The committee will now have a short deliberative. Thank you.
Thank you.